Recording in progress.
Good morning, everybody.
Everybody stand up. Stand up. Raise your right hand. Everybody stand up.
Buenos días a todos. Pónganse de pie todos.
Raise your right hand.
Levanten la mano derecha.
They sleep.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Juran o prometen que tu testimonio será la verdad, toda la verdad y solamente la verdad.
Please be seated.
Tomen asiento, por favor.
So good morning. The first case I'm going to call is Yaleen Vilma Calerdo, case number M267544. Is a Spanish interpreter needed?
No, Judge, she speaks English. This is Assistant Public Defender Jennifer Torres.
And do you accept the provisional appointment?
Yes, Judge, the Public Defender's Office accepts appointment on all the cases we're going to be calling today. Thank you.
Thank you. So there's one count of battery domestic violence. I'm going to read the form to see if I find probable cause.
I'm sorry, this is Sites. Good morning, Assistant State Attorney Sylvia Lorenzo on behalf of the state.
Good morning, Assistant State Attorney Adam Escobar on behalf of the state of Florida.
I'm sorry, sir, you were a little muffled. Could you get a little closer?
ASA Adam Escobar on behalf of the state of Florida.
Thanks.
So I'm going to ask the defense, do you have any probable cause or any arguments on this one?
Judge, I would just be asking for Ms. Gallardo to be released on pretrial services. I don't see any priors, any record. Additionally, the victim stated that he did not want to proceed with the charges. So she has an address in Miami that is not where the alleged victim resides, and she can be released into pretrial services.
Okay.
Your Honor, just for the record, this defendant does have priors. Would you like to take notice, or would you like me to read them for the record?
You can read them for the record.
The defendant has a closed felony from 2023 of controlled substance, a prostitution and maintaining a house of prostitution, soliciting another for prostitution, committing and engaging in prostitution, felony 15, a credit card.
Sorry to interrupt, but I cannot hear the state. If they can get closer to the microphone.
Can you hear me now?
Yes, that's perfect. Thank you.
The prior felonies from 2023 were a withhold of adjudication and sentence to probation, a felony from 2015 of a credit card charge of $100 or more, and a petty theft, which was no action, a felony from 2015 of an uttering of forged instrument, which was no action, a felony from 2013 of a robbery with a weapon, which was no action, and a misdemeanor from 2012 of a petty theft, which was no cross. The stated request is $2,000.
Judge, and just to be clear, those are not priors for the purposes of convictions. Their adjudication was withheld, so they're not convictions. Additionally, no actions cannot be counted towards Ms. Gallardo's record.
Sure. be clear, under the domestic violence statute, all priors can be accounted for by the court, whether they be no action or not.
Yes, I do believe that is the law that, Florida statutes under 741291 requires the state attorneys to provide the background, and they can be considered, for domestic violence cases, arrests, prior arrests, whether they're.
I'm sorry, State, can you speak into the mic, please?
Sorry, that was me. I was saying under Florida statute 741291, prior arrest can be considered. It doesn't have to be convictions for domestic violence cases. So I do believe the criminal history is important. I'm gonna, standard bond is 1,000?
Yes, Your Honor.
Okay, I'm gonna do standard bond of 1,000.
And the stay order as well.
Yeah, and a stay away order.
Judge, we can do a modified stay away order since the victim did not want to proceed with the case. Just a no violent contact order.
I'm sorry?
We would just be asking for a modified stay away order, no violent contact, since the victim in this case did not want to proceed with the charges.
The state would be objecting. This time we have not met the victim nor the victim to get that is for position.
The victim in the A form says that he declined to provide a copy of the video of the alleged incident. He advised that he did not want to pursue the charges against Ms. Gallardo.
Okay, over the defense objection, I'm not gonna modify the stay away order. The victim is not here to testify. So it's gonna be, I'm gonna do the stay away order with the standard bond of 1,000. Ma'am, I wanna make sure you understand you're not to engage in any criminal activities. Do not possess any illegal drugs. Do not use, purchase, possess, carry any firearms, guns, weapons. You must immediately surrender any firearms or concealed to the nearest police department. And you are prohibited from having any direct or indirect contact with Armando Donna Marie. Do you know who the individual I'm talking about? Okay. Including contact in writing, by telephone, through social media, or through a third person. And you must stay 50 feet away from the victim's place of employment, and are at all times. Do you understand?
Yes.
Okay. And
No.
you guys were residing together at the time, is that correct?
Judge, Ms. Gallardo's been living with her mom.
It says on the form, the victim and defendant are in a dating relationship and reside together at the above listed address. On the first sentence.
Judge, Ms. Gallardo currently resides with her mom. She does not share a residence with the alleged victim in this case.
So she did not need to get any personal belongings or anything from?
No.
Okay. The defendant is, and you're like, I'm giving no contact at all with the victim.
Per the arrest form, it says that they do live together. So based off of the representations in the A form, it would be that they do reside together.
Yeah. Yeah, like I was saying, the A form says the victim and the defendant are in a dating relationship and reside together at the above listed address. And there's nobody, the victim's not here to testify against it. So I'm gonna go by the A form. So the address that I have is 11313 Southwest 133rd Place, 33186. So the defendant may return to that address within 48 hours of entry with a police officer to retrieve any personal belongings, personal health, medication. The police But at any other time, they go to that address, they'll be in violation. I'm gonna just go by this day form since there's nobody.
And just for the record, Your Honor, the defendant has already left the room.
Yeah, Judge, they took Ms. Gallardo.
Do you want to bring her back in?
It would just have to be on, it just says their carbon.
Whatever, you just cross it.
Judge, Ms. Gallardo is present now.
Hi, good morning. Based on the arrest affidavit, it says that you and the defendant do reside together. So I'm gonna let you go one time with the police officer within the next 48 hours to retrieve any of your personal belongings, personal health items, medication. But you're not to go back to that property at 11313 Southwest 133rd Place. Do you understand, ma'am?
Okay, that's fine.
Okay, thank you. So the next case I have is Joanne Erin Ortega, M267507. Are you Joanne Erin Ortega? Are you Mr. Ortega?
Sorry, Judge, we're having trouble hearing.
I said, are you Mr. Ortega?
Yes, ma'am.
Okay. So you are charged with 2 counts of battery. I'm gonna go ahead and read the arrest A form to see if I find probable cause. And does the defense have any PC issues on this?
Not at this time, Judge.
Okay, I find probable cause.
This defendant has no priors. So for the state's request for count 1 is $1,500 due to the allegations in the arrest warrant that are very violent. And for count 2, we're also requesting $1,500 and GPS level 3 on both counts.
And sorry, what was the last part?
GPS level 3 on both counts.
Judge, I would just be asking for standard bond on each count. As a statement, he has no local priors.
And where do you currently reside? Are you from Texas?
Yes, ma'am, from Texas, but I live I live in Fredericksburg, Texas at the moment. Yeah, but I came to visit with my girlfriend and a friend.
Since he's from Texas, he has no place to do GPS monitoring.
The state is fine with $1,500 on both counts, then, Your Honor. As the state.
Again, Judge, I would just be asking for standard bond of $1,000 on each count.
Okay. And I'm gonna go, since you're not from here, and and these are serious allegations, I'm gonna do 2,000 on each count.
I'm sorry, Your Honor, what was the disposition from Mr. Ortega?
Oh, I find probable cause on both counts, and I'm issuing bond of $2,000 for each count,
And the stay away order.
and the stay away order. And the stay away order is. And it's you have a stay away order between two victims, Leslie Meza Dominguez and Annette Michelle Ramirez. Are you familiar with those two individuals?
Yes.
Okay, so you're not to engage in any criminal activity, not to use or possess any illegal drugs, do not purchase, possess, and if you have any firearms, you must turn them over to the nearest police department. The defendant, you're prohibited from any direct or indirect contact with the victim, Leslie Meza Dominguez, by use in writing, telephone, third party. You must stay at least 500 feet away from the victim home, place of employment. Were you living with Leslie Meza Dominguez? Well, you're from Texas, so you don't have to reach.
No, we all live in the same town, but me and my girlfriend do live with each other at the moment.
I guess they're in Texas, though. I guess I'll let him go retrieve one time. So I'm gonna let you retrieve from the victim's residence one time, 48 hours entry with a police officer to get your personal clothing, belongings, health, medical. But going back to the place where you reside with her, you would be in violation and you could be arrested again. Do you understand, sir?
Yes, ma'am.
And you're to have no contact with the victim.
So
And Your Honor, just for the 48 hours of release, it doesn't matter if he's in another state, it's still fine with the order to give him 48 hours to go back to the property.
Okay, even though you're in another state, you can go back the state and I will grant the states, they're in agreement, you can go back to the property that's, I guess, local within 48 hours with a police officer to retrieve your clothes, personal belongings, anything that you have here. But you are not to go back to that, have any other contact, and you must go with a law enforcement officer. Understand?
yes, ma'am.
Okay. And then this same applies to the victim, Annette Michelle Ramirez. You can't engage in any criminal activity, no use of illegal drugs. You must turn over any firearms with the nearest police department. The defendant is prohibited from any direct or indirect with Annette Michelle Ramirez in writing, telephone, through social media, third party. You must stay at least 500 feet from the victim's home. And you, again, well, you were not residing with that victim, so you don't need to get any personal belongings from them.
I do need to get personal belongings from the Airbnb.
From The one that's here in Miami.
From the one that's here in Miami?
Yes,
Oh,
ma'am.
Okay, so, well, I'll give you, you may return to, I guess, the Airbnb where you guys are staying in Miami within 48 hours to, with a police officer to retrieve your personal belongings, your medication, anything that you have, and, but you're to have no contact with the victim. Understand?
Sounds good, I understand.
Thank you. Good morning. Are you Alfredo Franklin Brown?
Yes, ma'am. Good morning.
Morning. There's one count of battery. I'm gonna go ahead and read the A form to determine probable cause. And does he have priors?
Yes, Your Honor. This defendant has a felony from 2015 of a cocaine possession, a misdemeanor from 2014 of a resisting officer without violence, a felony from 2021 of selling and delivering, I apologize, attempting to sell and deliver cannabis, a felony from 2013 of possession of cannabis, possession of cocaine, and possession of a controlled substance, a misdemeanor from 2011 of an improper exhibition of a weapon or firearm, a felony from 2011 with 3 counts of aggravated assault with a firearm, and a felony from 2021 of a domestic violence battery by strangulation, which was no process.
Okay, the state finds probable cause.
The state's request is $1,000, Your Honor.
I find probable cause, and the state is requesting standard bond of 1,000. Is that what you said?
Yes.
I will grant the and the stay away order.
And just to clarify, Your Honor, that's $1,000 bond?
Yeah, so it'll be $1,000 bond. Probable cause was found with a stay away order. Sir, I want to make sure you understand. You're not to put, you cannot engage in any criminal activities, possess any illegal drugs. If you have any firearms, you must surrender them to the police department. The defendant is prohibited from having any direct or indirect contact with Daniel Bartley. Do you know who that victim is?
Yes.
And no contact in writing by phone number, through social media, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school. You may return one time with a police officer within 48 hours of entry, accompanied by a police officer to retrieve your personal belongings, any medicine, anything you may have. If you go back to the property, you'll be in violation and can be arrested. Do you understand?
Can you say what?
Yes.
Okay, thank you.
We didn't. I'm not.
About the A form? Okay.
Thank you, Your Honor.
Thank you. Okay, the next case I have, good morning, is Doral Lloyd Collins. Is that you, sir?
Yes.
This is case M267542. You have been charged with battery. I'm going to go ahead and read the A form. Defense, do you have any probable cause challenges on this?
Not at this time.
Okay.
Judge, actually, we do have some probable cause arguments. The witness in this case stated that it was the victim who rushed Mr. Collins. Additionally, Mr. Collins had some injuries on his face. He was bleeding from his face, according to the witness, when he walked out of the apartment where the alleged incident occurred. It's my position that Mr. Collins is not the agitator in this case.
No, I'm finding probable cause. Let me see about this, sir. Let me see the priors.
The defendant has a felony from 2025 of an aggravated assault with a firearm, which was no action and with the same victim. A misdemeanor from 2021 of a battery, which was no prost and not with the same victim. A misdemeanor from 2020 of a battery, which was no prost and not with the same victim. And a misdemeanor from 2014 of a battery, which was no prost and not with the same victim. Due to the defendant's most recent prior of the felony from 2025, which was closed out at the beginning of this year in January, and the allegations in the arrest warrant, the state is requesting a $2,000 bond and GPS level 3.
Judge, we would just be asking for a standard bond of $1,000.
And I see here the victim and the defendant do have a child in common. Is that correct?
Yes, Your Honor. We're working. We have some ready, but
Which way?
$2,000 in GPS level 3. And of course, the stay away order.
I'm gonna actually give a $3,000 bond, especially that the last, it was just, the battery was in 2020, the case closed just of this year in 2026. So I'm gonna do a $3,000 bond, a stay away order, this PC was found. And the level.
GPS level 3 is roaming. GPS level 2 is kind of like roaming, but they ask permission. Yes, they need to ask permission from their house arrest officer. And then GPS level 1 is total lockdown.
Sir, do you know who Chelsea Alex Rogers is?
Yes, ma'am.
Right. I'm gonna give you a stay away order. You're not to engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, carry arms. You must immediately surrender any firearms or concealed weapons to the nearest police department. The defendant is prohibited from having any direct and indirect contact with Chelsea Alexis Rogers, including through phone, telephone, social media, third parties. You must stay away 500 feet from the victim's house or place of employment or school at all times. Do you understand that, sir?
Yes.
And so, but
He would just house arrest, whatever address he would be able to be released to.
Okay. And I just want to let you know that you may go to the victim's residence only one time within 48 hours of your release with a police officer to retrieve any of your clothing, personal belongings, medication, and you are to have no contact with the victim. Do you understand, sir?
Yes, ma'am.
And I'm going to also give you GPS monitoring level 2.
Judge, is that an alternate or plus?
No, that's plus. So $3,000 bond, stay away order, public bus bond, and GPS monitoring level 2. Especially that he was just released this year.
Judge, would you be willing to grant house arrest level 3? He has a job that he needs to continue working at, and it requires him to travel a lot within the city. He also does not currently reside with the alleged victim in this case.
Just to clarify, GPS level 2 will allow him to work. He just needs to provide his work schedule to his house arrest officer.
Did you hear the state that the GPS level 2 will allow you to work? You just have to provide that information all to the probation officer.
The house arrest.
The house arrest officer, the details.
Judge, I would still just be asking for roaming because you already have an elevated bond of 3,000.
No, expensive, Judge, I'm gonna keep it at $3,000 bond. Knowing that based on the priors, it was just this year in 2026. Aggravated assault with firearm.
Your Honor, that was 3,000 plus house arrest?
3,000 plus GPS level 2, yes.
Thank you.
Thank you. That's a need, right? Yeah, I think. Good morning. Are you Ron D. Perry?
Yes, ma'am.
And you in charge of domestic violence warrant? I'm gonna. me see his. What he says. Vince, do you have any PC arguments?
Judge, I don't have the arrest form for this case, so I wouldn't be able to make any argument right now. I also do not have his priors.
This is for civil compliance problem, because we almost don't have an arrest.
It's he was on a domestic violence warrant.
How much is the warrant?
It says here on this form, no bond.
It might just be to convert whatever bond,
Do you have
the
the
warrant
priors?
was
Do you
that
have
to
his-
convert it into a bond.
Do you have his priors?
I don't. We don't handle the civil calendar.
Let me see. Sir, what is your current address?
Judge, he's currently in custody on 2 other cases. So that's something that was added while he was already in custody.
Just had that one. Okay. Do you want to? He said he's on in custody for 2 other cases. So I needed to get his address, but they said he's in custody for 2 other cases. You have Stacy?
No.
Should we
Reset for the future civil compliance.
Yeah, but he's never told the charges. So I'm not gonna.
No, I'll just do maybe for another, for the civil compliance state. Not 100%.
Do you know what are the 2 other charges?
Judge, it's a misdemeanor and a felony. He has a scheduled trial for his misdemeanor next month.
We don't hold for civil compliance. Possibly, but they're not criminal backgrounds. It appears that they're just open cases, but the bond has already been set, so it's just pending either a trial date or.
You know if the warrant is for. It's just for the civil contempt.
It should be, it's appearing on this calendar. Did he not appear at his last hearing? And that's why a warrant was issued?
Sir, did you not appear at your last hearing? Is that why you had this warrant?
Judge, if it's a civil warrant, is it a civil warrant? It's not that he didn't appear, it might be a failure to pay something, he just needs to be placed on the civil calendar. I think this is just a civil hold so that if he does resolve his criminal cases, he deals with the civil hold before he is released. But he has not failed to appear. He's been in custody on these cases and another case that just recently closed out.
I'm sorry, what's the disposition for Mr. Perry?
I'm still reviewing it. So I'm not gonna, I'm not. What are you requesting?
We don't make a request for civil compliance.
Okay. I'm gonna pass this one and I'm gonna pass this one to the end of the honors. I just wanna double check something on this one. So I'm gonna recall it.
Okay, Judge. Yeah.
Thank you.
Okay.
So, are you, Mr. Lopez?
Judge, he requires the services of a Spanish interpreter.
Okay.
Your Honor, these are added charges.
Pues, señoría, estos son cargos adicionales.
Okay, we're gonna swear you in first, the interpreter. Thank you.
Do you swear or affirm that you're going to translate from English to Spanish and Spanish to English to the best of your ability?
I do, Arturo Suárez Silverio, certified interpreter, Spanish.
Okay.
Wait, do you have his priors? Same thing?
This is the same thing, yeah.
Your Honor,
Yes?
for Mr. Lopez, both his felony cases were no action on 4/16.
Señoría, en relación al señor López, los dos
This
casos
is
de
the only
delito
thing
grave
that's
que tuvo
holding him.
pendientes fueron
When he
archivados el
gets
16 de abril.
released, this bench warrant popped up.
Cuando estuvo a punto de ser soltado, esta orden de búsqueda y captura salió.
Because this is an out of charge, so I would need to see if the arrest warrant was issued while he was in custody on his felonies, because that would mean that it would need to be vacated.
Tengo que ver el formulario de arresto
That's why he failed to appear.
para ver si este es un cargo adicional. Tengo que ver si este cargo es algo que sucedió antes de que se le permitiera salir en relación a los otros dos asuntos.
Wait, she's reading.
Judge, is the interpreter on with us? We can't hear her.
Señoría, el intérprete se encuentra con nosotros, no lo podemos escuchar.
Is he moving his mouth?
Él está moviendo los labios. This is the interpreter, Your Honor. Your Honor, the interpreter can hear everyone clearly. Este es el intérprete quien habla. El intérprete puede escuchar a todas las partes hablando.
I'm sorry, we can't hear the interpreter. He's talking, but we can't hear him.
Su señoría, no podemos escuchar al intérprete. Él habla. Can Your Honor hear the interpreter?
Yes, I can.
Okay. The judge can hear the interpreter. La
We can't
jueza
hear the
can
interpreter
escuchar
here,
al
neither can
intérprete.
Mr. Lopez.
I'm sorry.
Mr. Lopez cannot hear the interpreter.
This is el señor
There's
López no
no
puede
noise
escuchar al
from
intérprete.
the
Your Honor,
windows.
I cannot, I have no access to Mr. López's audio. Señoría, no tengo acceso al audio del señor López.
Can you hear?
¿Usted
I can hear
escucha?
the judge only.
You can't hear the interpreter?
Yo solo-
No.
¿No escucha al intérprete? No.
We can hear him here and he can hear us. We can hear Florida guy. So they're happy.
Could we, oh, about. Okay.
That's something on my end.
My advice to Mr. Suarez would be to rejoin the meeting. I'll just let him in.
Can you guys hear it? Oh, he's logging back on.
¿Me escuchan? ¿Le escuchan al intérprete?
Judge?
Can you guys
Pues,
hear?
No, Judge. While they fix the sound, can we move to the next English-speaking defendant?
en lo que ellos arreglan esto, pasemos al próximo acusado, por favor.
Can we go back to Terry?
So this is all, we only have these two left for the DD, right? Okay, I'm gonna go back to Mr. Perry.
Me dirijo al señor Perry.
You had said that he's he's in there on 2 other charges, correct?
Sorry, Judge.
That he was there on a felony charge, is that correct?
Mr. Perry, yes.
But this time, no bond.
Judge, he's already being held on the felony and his other misdemeanor. You can just set a dollar bond. I don't even think it's to be held. It's a civil writ that he'll deal with once he is released from custody, once he either resolves his cases or bonds out. He won't be released without getting the opportunity to deal with it. I don't believe holding him no bond is appropriate.
I'm gonna still do $1,000 bond. And what is his address? He does get released. Not in this. Okay. Do you have an address? Does he have an address?
No, Judge.
Okay, so he'll be $1,000 bonds, and he's also gonna be held because he has the 2 other charges. Thank you. And the future court date will be Your future court date, sir, is May 27th. You want to let him know his court date, May 27th?
Is that for Mr. Perry?
That's for Mr. Perry.
Yeah, I can pull up his cases, 1 second.
John, that was fun.
May 27th at 1 p.m.
I'm sorry, what was the disposition? You gave him a bond?
Yeah, $1,000, and his next court date is May 27th at 1 p.m. Courtroom 2A for civil compliance.
Judge, I have Mr. Lopez back. Can you check if the Spanish interpreter's audio is working now?
Señoría, tengo al señor López de vuelta. Veamos si funciona el audio del intérprete.
We can hear him now, Judge.
Ahora lo escuchamos, jueza.
Can you hear now, Mr. Lopez?
Señor López, ¿ya escucha?
Sí.
Yes.
Okay. So you have been for a domestic violence warrant.
Debe haber sido detenido en relación a una orden de arresto en un caso de violencia doméstica.
You don't have his priors either, right?
¿No tiene sus antecedentes?
No, Your Honor.
No, su señoría.
Defense?
Defensa.
I can't hear you, you're on mute.
No le oigo, su micrófono está apagado.
I don't have the arrest form or priors for Mr. Lopez. I believe this was an add-on.
Defense, do you have any argument or anything you'd like to say?
Judge, I don't know the facts.
You're on mute.
Tu micrófono está apagado, no se oye.
Can you hear me?
I can't hear you.
No se escucha.
Can you hear me now, Judge? No? Can you guys hear me now?
Can you guys hear now?
No, Judge.
I can't hear the public defender.
No puedo escuchar al abogado de oficio.
We want to just pass this case so we can do.
Quizás debemos postergar este caso.
Yeah, they can't hear me. Can you guys hear me?
No, I know, but I can't hear the.
I think even if it were to go
Right.
to the next. case,
Yeah, I
so-
wouldn't hear the public defender, so how would that?
Pasemos al próximo caso.
Oh, I can hear. Now I can hear you. Okay, I said, did you have anything you would like to say on Mr. Lopez's case?
Add-ons, so I don't have the arrest form or expired or anything for that.
Yo le quería preguntar si usted deseaba hacer un alegato. Pregunta a la jueza, su señoría. No tengo los antecedentes de él, necesito el formulario de arresto.
Oh, you're right. This is civil compliance. We don't have that. The state, we stand. for these cases.
You have Zoom on your laptop? Can you pull it up?
Yeah, I would like to know his priors.
Quizás pueda accederlos a través de su computadora portátil.
If not, go to YouTube and let's see if he can just hear it, if they can hear you through the laptop. This one? When I press it, this is why they can hear us now. You want me to press it?
No, okay. No, turn the.
No, go ahead.
The camera, just turn the. No, here.
Turn the camera off? It's gonna do this. You see? She can't see us on here. We need the camera. Yeah. We usually don't have that on. That's why it's an echo. I don't think we can hear the interpreter.
Can you hear me? This is the interpreter speaking to you. Le habla el intérprete. ¿Me escucha?
Can you hear me?
We can hear you, Judge, we can hear the interpreter.
Okay. This is gonna happen in other cases with the interpreter.
You try putting it on your Zoom?
Yeah.
Oh,
Is she here to help us find sites?
I'd like to apologize. This never happens. I'm working with ITV to figure out what's going on.
Because I'm sure we're gonna need the interpreter for a lot of cases.
Probably.
Can you hear me?
We can hear you, Judge.
No, now I don't hear you.
Yes, we can hear you.
Can you hear us?
This is the interpreter speaking, Your Honor. I can hear you very, very well, very clearly.
An echo, but the interpreter can hear you guys, but yeah, that's awful, but I can hear you. Is there anything I need to do? on my end? Like a sites, oh, like she cites, right? Mm-hmm. Right, we just have to wait. You want to see if it works? You want to see if you can hear the interpreter? Because I want to finish Mr. Lopez's case so we can.
Le habla el intérprete. The interpreter speaking. Can you hear me?
Can you hear
This
the
is the
interpreter?
This is the interpreter. Can you hear me?
They can hear
Le
us.
habla el intérprete.
Yep, she can't hear us. No, now she can't hear us, but before we just did interpreters, I was putting it on her computer. So that
I can hear you guys now.
She can hear us. She can hear us. Oh, she can hear us. That's what we're all here.
Let me see if the public defender can hear. Can you talk?
Oh,
Yeah, it's the mic that sounds like muffled and
Yeah.
echoey.
But what are we gonna do? Interpreter, should we? Is sites gonna help? Because
I think they're trying to figure out.
they're trying to figure this out. Can you talk on the computer?
¿Pueden usar la computadora para hablar?
I truly do believe the problem is on their end because nothing over here has changed.
But they can't hear the Spanish interpreter, which I'm
Yeah,
sure
we-
we're gonna need in a lot of
Yeah.
cases.
Judge, you hear me?
I think something on
Judge?
their equipment.
Yeah.
We're logged in on the attorney's laptop. Can you please let her into the Zoom? We're gonna try to do it with her laptop.
Maybe she will.
It's very low what you're saying.
The problem is here.
Who's
Laptop. Can you please let her
okay?
into the
Where
Zoom?
What?
Yeah, we waiting. But how can you do something? Yo, it charges. It's always like that.
Yeah.
That's why we make that whoever that is. You loud. You loud. No, but I'm saying she can't hear us, but you can literally hear everything. Because it's on a different stream. This is on REG. Yeah, because TGK. This is direct just through the internet. That's why. You know what I mean? But no, we said we gonna start taking that camera off and you. Oh, yeah. Yeah. Okay. APT Jennifer Torres. Jennifer. APT Jennifer. APT Jennifer Torres.
We can hear you guys now,
Oh,
but you guys can't hear the interpreter? Can you hear us talk?
¿Ustedes pueden escuchar al intérprete?
no, we can't. No, we can't hear.
What, public defender, what is your, so I can let you in the room? What do you,
What was that question?
what is your last name again? So I can let you in. Oh, I see corrections, as in, to go through your computer.
I think you got most of there. So on here. Why you know was in there? They not letting her in. Yeah, the gym she got me. Jennifer Torres. Slash Lopez.
Not
Jennifer Torres is the name on the jury judge. You gotta say it again. Can you hear me?
Mm-hmm.
Can we call somebody that's in the room?
Yeah, they let you in? What are yeah, waiting for host. This is not your first day, this is a bit of that stuff. Yeah, I've been an attorney, but we never did. You're doing good. Though. Jennifer Torres? Yeah. And that's what your laptop says?
Yeah,
I just
did misdemeanor jail arraignment.
No, felony. She was on the misdemeanor, she's gonna do felony now.
Hi, public defender, your first name is Luna? Rosie?
Okay, y'all hear me?
Wait, join panelists.
Can you all hear me?
Yes. This is the interpreter speaking. I can hear her.
They can hear you.
Okay, Judge, from my laptop, I can hear the interpreter, and I believe I can hear. Believe I can hear him.
Okay, so,
This is the interpreter speaking, Your Honor. I can hear the public defender loud and clear.
okay, perfect.
This is interpreter.
Okay, so back to Mr. Lopez's case.
Volvamos al caso.
Try to talk, can she hear you?
We can hear.
Volvamos al caso del señor
Thank you
López.
so much.
Sorry, Judge, we got it.
I'm glad you had your laptop. Thank you. Sorry about that. Mr. Lopez, what is your current address?
Señor López, su dirección en este momento, ¿cuál es?
No, el ley.
152 Northwest,
676, Southwest,
167 Southwest,
169 lane.
179th Street, or it's not 179th Lane.
Can you repeat that? 152 Northwest?
Repítalo una vez más.
Yeah.
15276 Southwest, 169 Lane.
15276 suroeste de la lane 169.
So I'm gonna give him $1,000 bond, and his next hearing date is May 27th at 1 in courtroom 2A in civil compliance.
Bueno, le voy a poner una fianza de $1,000. Su próxima audiencia es el 27 de mayo a la 1 de la tarde en la sala 2-A en relación a cumplimiento. Es un caso civil.
Judge, from what I understand from corrections, this is the only thing holding him in custody. It's a civil matter that should not be keeping him in custody on $1,000 bond. He should, I'd be asking him for him to be released from custody so that he can deal with this. He'll be placed on the civil calendar to deal with this once his release is granted.
Señoría, tengo entendido por el Departamento de Prisiones que él solamente está retenido por esta causa. Es un caso civil y no es justo, no es correcto que él siga retenido a cambio de una fianza en relación a eso. Por esto pido que se le permita salir bajo palabra para que él pueda comparecer en su caso de revisión de temas civiles.
And he's not being held on any other charges?
¿No tiene ningún otro cargo?
Is he being held on any other charges?
¿Está siendo retenido por algo más?
Judge, I don't know if you can hear corrections, but they're saying no, that his 2 felonies were no actioned on
Okay.
416.
Okay, fine. I will, I'm gonna release him May 27th at 1 AM. For the civil compliance.
Señoría, no sé si usted escuchó al Departamento de Prisiones previamente, pero ellos dijeron que los
1
casos de delito
PM,
grave
Courtroom
fueron
2A.
desestimados. Muy bien, permito que él salga bajo palabra y su próxima vista es el día 27 de mayo a la 1 de la tarde.
And I'll grant the no bond.
Le otorgo permiso para salir sin tener que pagar fianza.
Thank you, Judge, and thank you for Mr. Lopez.
Okay.
Muchas
thank you.
gracias.
Sorry, I'm out of
Señor
breath.
López, le agradece.
It's granting an ROR.
Le he otorgado libertad bajo palabra.
Just to confirm, because you said you're granting no bond.
I'm gonna grant no bond and,
No
to go.
bond usually means that he's gonna be held. In custody.
No, I said I was not gonna do no bond because they said he's only held on this versus the other one. Yeah, because the other one was held on 2 other charges.
So an ROR.
Oh, you want us?
Yeah,
You go
sorry
ahead.
about that. Judge,
Yes? Yes?
that was ROR for the defendant?
Yeah, because he's only held on that and for civil compliance.
Okay, thank you so much.
Puesta es libertad bajo palabra para el acusado. Sí, él solamente está siendo retenido en relación a esto para mostrar que ha cumplido en un caso civil.
I think we're done with domestic violence.
Good morning, Your Honor. This is Joanne Hennessy. I'm here for the city of, I'm here for,
Recording stopped. Recording in
Your Honor, can you
progress.
hear me? Your Honor, can you hear me?
Yes,
Good.
hi,
My name is
morning.
Joanne Hennessy. Hi, I'm here for the city of Miami Beach. I just wanted to make sure after
Yeah,
that.
thank you so much. We're
issue.
just setting up
Thank
for the
you.
next calendar.
Thank you.
Okay, try. Judge, can you hear me?
Her computer shut down. Judge, can you hear us?
Yes,
But what microphone is she can hear us through right now?
I'm talking on bench through the microphone.
No. We trying to find out what microphone do you hear us? What microphone is that? I think she can just hear you.
Can you hear me? From this?
No, she can hear you from over here.
The microphone that
that's
the
why
public
it's
defender
muted.
is speaking from has a lot of feedback. That tall one there, the one sticking up, it's not as good as the one that was heard before she moved close to that mic. The other one is better.
Oh wait, don't hang up from her. The clerk. No, we were trying different things. Yeah. Okay. He has to do it. I think I have to.
So good afternoon still. So the first case that I have is Lawson Bell. I can't hear you. Oh my, this microphone. They think you're muted, the state is saying. This microphone issues. Is it always been like this with the microphone?
Ask her now. Can you hear me, Judge?
I can hear you now.
Is it low? Is it lower? Fine.
You got my stamp. You guys, ready?
Can you hear me? Can you hear me?
Yeah, the clerk's gonna swear everybody in, but, oh, no, we have, okay.
But you gotta talk to us, for us to know. Ask the interpreter,
Can you hear the interpreter?
Interpreter, can you hear me?
I can hear you. It's not as good as before, but can you hear me? This is interpreter speaking to you.
On the microphone. Is anyone in the court?
And this is interpreter speaking. Can you hear the interpreter?
Okay, no one's in the courtroom. No one's in the courtroom, guys. For some reason, they can only hear us through here. It's something over here that they can hear us when I unmute this. But usually this is muted and they can hear through the podium. We don't unmute this.
Judge, can you hear me when I'm over here?
Then you hear me? This is
So she can
interpreter.
hear us over here.
There's a microphone in that little camera.
So that's what she can hear us through here. That's why.
To be on podium.
But the podium, she can't hear us
Yeah,
through.
the computer's picking up the update now. That's what's going on.
No, but this computer has nothing to do with the microphone.
Yeah, that's just her personal laptop.
You guys can't hear me? But we can't hear you.
Your Honor, with the court's permission, this is interpreter. Can the public defender hear the interpreter? Can the public defender hear the interpreter?
Can the interpreter is asking if you can hear the public defender. Can you hear the interpreter?
I cannot hear the public defender.
Not so she's gonna be able to hear you now.
I can hear, can only hear the interpreter. And I can hear the judge, but I don't think you guys can
She
hear
can't hear
me.
you because you're not close right here.
But is that the IT trying to help you? Can we use your computer and like for now we'll pass the Spanish, interpreter and then put them at the end, I guess. We need an interpreter.
Yeah, let us start. Can you let me know?
Okay, so let me start with the first case,
Judge.
Lawson Bell.
Judge, the computer in here is restarting. The public defender computer in here is restarting, so we might need.
I can hear you.
Is
So
it
I guess
my- I'm standing right up to the screen, Judge.
She'll have to.
I guess
So,
we're gonna pass
and make
the
that
Spanish
learning.
interpreter.
Okay. Okay, let's do that.
Okay.
Hopefully, she's gonna stand up.
Just stay right here, Belle. Yeah, stay right here. Stay right there. Yeah, just stay right there.
This is
You wanna let them know?
Lawson Bell. And this was for a bench warrant.
It's called bench warrant.
Do you have anything?
It seems that Ms. Bell, Judge, I believe that this warrant was issued for failing to,
Thank you.
I think,
particular
I don't think she can hear you, gotta talk loud.
Hey, public defender, can you hear?
Yes, Judge, can you hear me?
Yes, I
That
can.
door
So,
gotta be closed.
lost and Bell, this is for a bench warrant. I'm gonna go ahead and grant standard bond of $1,000
Okay.
And the state. We already.
and with a stay away order.
Judge, standard bond for, I believe this is a petty theft, but no violence, it should be 500. Judge, can you hear me?
Yes.
I would be asking for $500. I believe that this is a bench warrant for a petty theft.
No, I'm gonna keep it at this, over the defense objection, I'm gonna keep it at $1,000 standard bond with a stay away order. Ma'am,
Judge, I believe that this warrant was issued for her failure to comply with a class that she needed because she wasn't able to afford it. So I would, again, I would just.
this is the traffic misdemeanor, who's the stay away order? Like the victim. Oh, okay. So ma'am, I'm gonna issue a stay away order. You shall stay away from the following address: 17650 Northwest Second Avenue, Miami, Florida, 33169. Do you understand, ma'am?
Do you understand?
Yes.
Okay, and I'm gonna be granting the standard $1,000 bond.
Okay, so $1,000 bond.
That's
Come on.
it. Okay.
Come on, Smith.
Thank you. The next case that I have is,
Stand right there. No, you go all the way out.
I'm sorry, this is,
Smith.
this is separate. Are you Bethany Smith?
Yes, Amanda, yes. Amanda Bethany.
Amanda Beth Smith. Okay, you've been charged with petty theft. Let me go the form.
It's Amanda.
Amanda.
Bethany's wrong.
Defense, do you have any PC arguments?
Judge, I don't have any probable cause arguments, but I will say that Ms. Smith does not have any local priors to my knowledge. I would just be asking for her to be released on her own recognizance with a big cern.
Your Honor, I'm a 25 M1 withhold objection. State of your listing standard bond 500.
Judge, I know withhold is not a prior, it's not a conviction. So I renew my argument that she has no priors.
So I'm gonna, for the defense objection, I'm gonna do standard bond of $500. Where do you?
No, that was 500.
Your Honor, that was 500?
No,
That's fine.
oh, yeah, sorry, it was 500. Probable cause found.
Thank you.
Company, rather company each, so we don't have to down with it.
The next case I have is,
Your Honor, I apologize. There is a stay.
okay, we can recall the next one. There is a stay away order. Can we recall the previous case
Smith.
for Ms. Smith?
It's Wendy. Wendy. Wendy there.
She said she wanted to call, right?
She wanna recall, Smith?
Yeah.
Smith, she don't wanna come again.
Judge, Ms. Smith does not want to go back.
You guys want to come back? Okay, then I will read it over her objection. I'm gonna let her know there is a stay away order. For the defendant shall stay away from 982 Southwest 8th Street, Miami, Florida, 33130.
Go ahead, Wendy.
Thank you. The next case that I have is Wendy Jorel.
Your Honor, Joanne Hennessy, I'm just announcing my appearance in this case for the city of
Yeah, and
Miami
the
Beach.
case
It's the
number-
state's case.
I'm sorry. Let me just say the case number is B250280003. Yes, and there's a bench warrant. Defense.
Judge, I would just,
It appears there's two bench warrants. For $3,000, requesting that the bench warrant be converted into a monetary bond.
sorry, is the state speaking? I can't hear.
Yes, they are requesting that the warrant be converted into a monetary bond because there's two bench warrants.
Judge, I would just be asking for standard bonds. I don't see any priors in Ms. Jorel's record.
I'm sorry?
I said I don't see any priors in her record. I would just be asking for standard bond instead of the warrant bond.
It's the bench warrant separate $1,000. Asking that it be
Yeah.
converted.
Yeah, so I'm gonna set standard bond on 3,000 on case number 525028003. No,
He was arrested on those counts. It says he was arrested for these on 12/21 of the prior year.
So 15 each. Okay. So for count one, it will be 1,500.
I don't believe it's counts. I think it's just picked up on the bench warrant, and for each case, they set it for $3,000. He was already.
Two counts. He has count one, resisting officer without violence, and count two, camping prohibited on B2580003.
Correct, but he
Yeah,
was arrested in December 2025, meaning he was already given a bond at that time.
But it's two.
Yes, but the bond has two counts, so each count doesn't have a state.
Yeah, the folder is highlighting one of each.
Yeah. I hear correction, repeat, please.
I'm sorry, what you said, Terry?
Repeat it again, please, what you just said.
The case has two counts, so each count has to receive a bond.
Was he never on those count sheets?
Case number B2528003, there are two counts, which is total breakdown.
Right, so in case number B250280003, there's two counts, so it's gonna be 1,500 on count one and 1,500 on count two. So a total of 3,000. And then the next case that I have is M2502536. That's his name. Name on this one?
Same yard, converting the warrant into a bond, so 1,500 on count one, 1,500.
There's only one count on this one.
And just 3,000.
This is Rashawn.
No, Wendy.
3,000.
Okay. Count one will be 3,000.
On the case ending in 8536.
8536.
Judge. And the other one was for the case ending in 8003. Are you holding her on a $1,500 bond on a camping case?
Yeah. I'm holding her. Count one is 1,500 and count two is 1,500.
Judge, that the standard bond is $150 for a camping violation.
The defense is saying that for camping prohibited violation, it's $150, not 3,000 standard, not 1,500.
I understand, Your Honor. The thing is that the bench warrant that was set by the judge, the division judge, was $3,000. So we're asking that it just be converted to a monetary bond, and he be bonding out, or she be bonding out on $3,000.
Yeah, so I'm gonna keep it at 3,000, 1,500 for the camping.
Judge, and again, I cannot hear the state. They're speaking. Can they speak up, please? I cannot hear them.
Can you repeat that? They said they can't hear you.
Yes.
Just to clarify, this is for the case, the M25 case.
We're on 2528003 that has a camping charge.
Yeah, I'm gonna still keep it at the 1,500 because that's what the division judge had and before they go to the division judge, so I'm gonna keep it at 1,500. Each count.
Thank you, Your Honor. There's three.
Yes, thank you. The next case I have is Giselle Ovidio, case number M2001237. And this is,
Where? Judge, I have Rashunda where number. Oh, she
Sorry?
found out, okay. My
Yeah,
apologies, Judge.
Ashunda Walkers.
no, this is Giselle right here.
This is Giselle Oviedo.
Yes,
Okay.
that's what I said, Giselle Ovidio, M2001237. And what is this? Let me see the standard.
This one.
It's 750. It's 750.
2M2, right?
It's M2.
So, no, this is Giselle Ovidio.
Judge Ms. Oviedo has no priors that I see. Because as far as disorderly conduct bench warrant, I would just be asking for her to be released from pretrial services.
The standard bond is 100. And this on
Oh, which count?
Giselle Ovidio is for the bench warrant.
Oh, it's just they want a bench warrant?
Yeah.
Okay, Your Honor, then we're requesting that it be converted into a monetary bond.
And what is the standard bond is?
It's whatever the judge sets as the bench warrant. So it'd be what
Okay, so I'm gonna do standard bond of 100, and there's also a stay away order. Nelson Ochio. Is that name sound familiar to you, ma'am?
There's a stay away order on a disorderly conduct judge. That was from 2021.
Only the one that comes to the check.
I can't hear them.
Yeah, that's why there's a stay away order on a disorderly conduct.
Yes, sir. It's for the bench. This one should not have a stay order, so we're withdrawing the stay order.
Okay, the state is withdrawing the stay away order, which I grant. So it'll just be $100, $100 bond. And disregard the stay away order, please. Thank you. The next case is Rashuda Walker.
The next case is
Rashunda Walker.
no, the next case should be Dory
Judge,
Phillips.
my next case on calendar is Dory Phillips. Walker is the bond
What happened to Walker?
Bond out.
Bond out?
Yes. Do you think you can turn off the audio there so I can turn on my computer and I can hear it? Turn off the audio where on there, like the volume I mean, and then I'll log in.
Okay, let's hear. I don't think so.
The next one that I have is Dory K. Phillips. Case number B25027927. And this is another bench warrant. And let me look at.
Honor, did Rashonda Walker bond out?
Yes.
Just to be clear, thank you.
State. The standard.
Or Miss Phillips?
That's on in sister. Yes. Oh, here. So on this one, there's four counts.
Yes, sir. It looks like there was a bench warrant previously issued. The state would at this time be requesting that the previous amount of $2,000 be converted to monetary bond.
And you're saying the standard bond is 2,000, so 500 each count?
I have 3 counts, Your Honor.
I have 4.
Yes, Your Honor, that's correct, 500 on each count.
Okay, so there's 4 counts. Total of $2,000 bond. I'm gonna issue 500 on each count.
Judge, for the disorderly conduct, the standard bond would be 150, it's a M2.
So I'm not sure if you heard her. She said disorderly conduct should be 150, not 250. Yes, that's what the public defender was saying.
We're not setting bond for the actual charge, we're just converting the bench warrant that the
Yeah.
judge issued.
Yeah, we're not setting, we're just converting the bench warrant.
I understand, I just heard standard bond and how would it be standard bond?
So the total is 2,000, converting from the bench warrant.
Come on, Ms. Phillips.
Lila? Stand right there for the.
Okay.
Next case I have is Julia Harris Nelson.
I have number.
Oh my gosh.
The next person we have is Bill.
I believe the next one
Nicole Tanya Miller. Case number M25005373.
I live in Michigan. I've been here for 5 days. If I stay here, it's like.
This is another bench warrant. Right, I see that. So I'm gonna do the misdemeanor first, the traffic, which is case number. The traffic is. Okay, I'm gonna do the misdemeanor first on the bench warrant. And the standard, there's 2 counts. Oh, on the bench warrant, resisting officer. Okay, that's 750.
And Your Honor, the state would be requesting the $750 amount be converted to a monetary bond.
Yeah, the $750 will be converted into a monetary bond. For the bench warrant. And now there's another count for there's another count for driving without a driver's license. And that's traffic citation AN, the number 1JIGE. Right, and the bond for that will be 150. Here. The next, yeah, it has it. The next case is Mabel Ramos.
Your Honor, are we addressing the Nobel Prize?
Yeah, I gave her a bond.
How much?
It said 150. That's it.
Yeah.
That's what they went there.
Yeah, we would.
Okay.
Then right now.
Are you Miss Ramos?
Yeah.
Okay. So there's. Yeah. Okay, so the first you have 2 bench warrants. This one is the first bench warrant is for traffic violation AIIQLGE. And you want the bench warrant converted?
Yes, Your
Okay, I'm gonna convert the bench warrant to the bond of $1,000. Okay, and the next case is AM9KTCE. Okay,
This is for the same defendant.
yes.
May I please have one more time?
The case number or the citation?
Citation.
It's AM9KTCE.
Thank you.
Yeah, and the bench warrant is for 1,000.
Judge, the case that you read out, was that
She's not being held on this case.
Okay, I'm gonna convert the bench warrant into monetary bond of $1,000. Do you understand, ma'am?
is that for both cases that you just read out?
That's for both cases, $1,000 each.
Okay, Your Honor, it is print on the calendar, so you have to take it in the custody.
Judge, I believe that's just a citation sheet.
Sorry, you couldn't hear?
I believe that's just a citation. I don't
On
have
that
the-
second case, it print on the calendar, so she will be in the custody and give a $1,000 bond.
Judge, I would just be requesting that she remains out of custody on that case. It's not on for bond review today.
There's a bond of $1,000 that was converted from the warrant to monetary bond, $1,000 each count.
I only see a warrant on the case ending in OGE.
This case popped up on PD. The second case popped up, which is case number AM9KTCE. The bench warrant was issued on 12/11/25. It may not be on the calendar, but it is in the system.
It's for failure to appear.
For failure to appear.
Terry, I'm here, no card, we good.
Say it again?
No, I was just saying that I was talking to take that on the jail card.
Neither.
Call the corrections, please.
So the next one I have here is Christina Marie Coing.
Judge, for Ms. Ramos, there's another.
Hold on. I think corrections is gonna try to call. I cannot hear.
I said for Ms. Ramos, she also has another charge that I don't think the bond was addressed for. It's a drug charge.
That's another charge.
So that's a
That was
felony.
not addressed for Ramos.
Yes, there are
Oh.
felony cases that'll be addressed in the felony calendar.
It will be addressed in the felony calendar.
Yeah. It's a felony.
Come on now.
Thank you. So the next case is Christina Marie
Okay.
Coing, Koenig, case number AMFBV7E. Yeah, and this is for another bench warrant.
That is correct, Your Honor. The state would request that the amount of $2,500 be converted to monetary bond as to AMF.
There's two. So the first one ending in 7E will be the 2,500. A bond will be, the bench warrant will be converted into the bond of 2,500.
And same for the case of AMB41L.
And for the second one, AMB41LE, the bench warrant of 2,500 will be converted into monetary bond.
I would just be asking for her not to be held on these bonds in order for the bench warrant to be put against Ms. Coing, it would have to be a willful violation. She went up to the officers according to the A form. According to the A form, there's no evidence that this was something that she did willfully. She just was not aware that she had court. There's case law to back that that's not enough for a willful violation.
Just to be clear, we're not arguing PC. This is just that she was picked up on a bench warrant. It's just that a monetary bond be set so that she can be released and then be before the judge.
That's fine. I'm just asking for her to be released and not be held on the bench warrant. It's not a PC argument. I'm just saying that it's not a willful violation and she shouldn't be held on a bench warrant. The PC argument would be going to the hospital case.
We're not doing the PC. We're just converting the bench warrant into monetary. Thank you. So the next case
It's another bench warrant. The next one.
Flores? Okay, is your, computer working for the interpreter?
If we can't take this off, then.
Hold on, one second. Sit down, I'm gonna explain to you what happened. I can't turn it on. I think you just have the echo. Anything? Can the interpreter?
Judge for the
You have
next,
to, take
Flores is 196.
Yeah,
Judge for the next case, Flores, we require the services of a Spanish interpreter.
and it's gonna be.
This is
you-
interpreter speaking. Can you hear the interpreter?
Yeah, can you hear us? Can you hear us?
Yes, I can hear you. This is
Oh,
interpreter
okay.
speaking.
Okay, come on, Flores.
Adelante, Flores.
Okay, good, good afternoon. This is, case AF 02GAE, and this is for a bench warrant. in the amount
Este es
of
el caso
$1,000.
AF02 GAE. Esto es por una orden de búsqueda y captura.
And the standard bond on this is $1,000.
La fianza estándar son $1,000.
Judge, her failure to appear was not willful. She never.
It's a bench warrant.
Dollars, this time request $1,000 bench warrant be converted into a monetary bond.
The interpreter could not hear the state judge. El intérprete no pudo escuchar al fiscal.
The state would be requesting that the $1,000 bench warrant be converted into a monetary bond.
La fiscalía pide que la orden de búsqueda y captura, que son $1,000, que se convierta en una fianza de $1,000.
Judge, Ms. Flores' failure to appear was not willful. She never received notice at her correct address. The address that the court has on file is not her permanent address.
Su señoría, la falta de comparecencia de la señora Flores no fue intencional. La dirección que figura en el tribunal, los documentos del tribunal, no es su dirección correcta.
No, at this time, I'm not gonna remember, this is not determining probable cause. This is just converting the bench warrant to
Judge,
standard bond. So
it's not a
we're gonna-
probable cause argument. Judge, not required to set the bond at what the judge who set the warrant gave it. You can defer to your own judgment as to what you want to set the bond as, including releasing anyone into pretrial services to tap or release on their own recognizance. You're not required to set the warrant amount to their bond. It's not a requirement. And again, these are not probable cause arguments. It's just going to the willful nature of why they picked up their bench warrant, which again, there's case law to back up that if it's not a willful violation of their fate, and that's what led to their failure to appear, then it should not have been issued or it should not be served.
Your Honor, this is the interpreter speaking. The interpreter is not being given a chance to interpret at this point. La jueza había indicado que iba a transformar la orden de búsqueda y captura, que son $1,000, en una fianza de $1,000, y su abogada, la abogada de la defensa, indica que ella piensa que no es correcto, que la jueza tiene arbitrio para permitirle a usted salir bajo palabra o permitirle salir a cargo de un programa como TAP o algo así, y que no está obligada a imponer una fianza de $1,000, y que como usted no faltó a la corte intencionalmente, que no se le debe poner una fianza de $1,000.
yeah, I'm gonna keep the bond as is. Thank you.
Retengo la fianza tal como está. Gracias.
Okay, I see that, there's some attorneys that, there was an attorney that raised their hand.
Yes, Judge,
And there's-
good morning, Judge Robert Perez. Was that Carla Torres?
No.
Are you here?
I mean Flores?
Flores.
Was that Carla Patricia Flores?
Ms. Flores.
Yes, that's correct.
Yes.
Judge, what was he? I'm sorry, I missed it, and I've been signed on for a while.
No problem.
What was the final?
I just.
And I appreciate the PDs. Go ahead.
1,000.
1,000? Okay,
Yes.
thank you.
You're welcome.
Can corrections tell me, does she have any other holds?
No.
El
No,
departamento de prisiones me puede decir si algo más la retiene. No. ¿Cuánto fue la fianza? $1,000.
Thank you.
Gracias.
Everybody have a great, thank
And I
you.
see that there is another attorney,
Todos tengan buen día.
Mr. Luna.
Good morning. Good morning, Your Honor. Great to see you this morning. Yes, I'm here with my co-counsel, Gabriel McKay, on behalf of David Rivera. That's F26.
It's for the felony. That's for the felony counters. So you have to, we're still on misdemeanors.
Oh, of course, Your Honor. Yeah,
Okay,
we're
perfect.
waiting.
And I believe there was an attorney, Melissa Ramos, that raised their hand.
Yes, good morning, Your Honor. I have someone on the traffic calendar. Azam Ali.
What's the last name again, ma'am?
Ali, A-L-L-I.
A-L-L-I. Okay, I'm gonna go with the next one. We're gonna try to pull that for you.
Thank you so much.
Okay. The next case that I have is Jeanette Andrea Martinez. And this is case AM3QYKE. And this is another bench warrant.
Judge Martinez's bench warrant was issued in error. She was in custody in Broward, but she shouldn't be held on this.
I'm sorry, I couldn't hear you. Public defender?
Ms. Martinez, when this bench warrant was issued, she was in Broward custody. So it should not have been issued.
We couldn't. She said that she was in custody, that this should not have been issued in Broward.
She was in custody in Broward?
Did you say she was in custody in Broward?
In Broward until Saturday, until last Saturday. Oh, sorry.
February to Saturday morning.
Judge, she's been in custody since up until last Saturday.
Since February.
I'm sorry, what did you say?
She's been in custody since February up until last Saturday. This bench warrant was issued in March. She was in custody. It's not a willful violation.
She wasn't in our custody, she was in Broward custody.
Yeah, she was in Broward custody, but she should not have received the bench warrant because she was still in custody.
She wasn't in our custody.
That's fine. She's still in Florida custody. It's not a willful violation.
They're gonna look it up. Let me go to the next one. The state's gonna look up her custody. The next one is AM3QYJE, and that's another bench warrant.
When was she released from Broward?
Was she there? Were you guys able to pull it up?
For the first one, she failed to appear 4/17. So if she got out in Broward last weekend, she should have appeared.
Yeah, exactly. When did she get released from Broward? I can't hear her.
She was in Broward and then transferred to Tampa, Judge. I see the bench warrant was issued on March 31st.
When was she released?
She was released last Saturday. Judge, but she didn't even know she had a warrant. She was in custody. No, I know.
Did she have any other holds in any other counties after this? Will she be transferred somewhere else?
Sorry, say, can you repeat that one more time?
Will she be transferred anywhere else after this? Does she have any other holds?
No, she just needs to deal with these cases. I'm just asking for the warrant to be lifted so that she can deal with these cases out of custody.
That's fine with the state, Your Honor. And ROR on this bench warrant.
So it's that she was you guys were able to, she was in custody?
Yes, Your Honor. It says that the bench warrant was issued on March 31st.
Okay, so and you see the date she was released?
It shows that she was picked up on the warrant 4/17 yesterday.
Okay. So I'm gonna RR because she was in custody on 3/31. And I guess that's the same for both cases ending in KE and JE.
Yes, Your Honor.
I'm gonna RR her because she was in custody when the bench warrant was issued in Broward on both of them.
Yeah, so that you don't get another. Okay, no problem. Okay, well, it's training.
This here?
Okay, no problem.
Just stay right there, okay?
So I'm gonna take, Ms. Leach, I'm gonna take a case out of turn that has an attorney present. Mr. Ramos, so your client is, Azum Allah. The last name is Azam.
Yes, Your Honor, it's Azam Ali, correct.
Yes. Is that your client there?
Hey, squirrel. Hey. Oh. That's it.
And he
Is that
speaks
your-
English, Your Honor.
Is that your client?
I can't really see. Let me see.
Who do you need, Judge? I don't believe corrections.
I want to make sure that that is, Azam Allah.
No, it's not.
Okay, we pulled him out of order.
Oh, okay. Who ain't taking out of order?
What was the name?
The first name is Allah, A-L-L-I, and the last name is A-Z-A-M.
Judge, can we do the zero while I find him?
I'm sorry?
Can we do the zero right now? Why, get, what's his name? Allah. Okay. Let me
Who's
put
in
it-
front of you right now?
Can we have the zero right now? Can we do it?
This is the Zaire judge who's,
Okay. Okay, can you pull that gentleman out, turn, and I'll go on to the next one.
yes, they're grabbing him now, Judge.
Okay, somebody put him out. Okay, so are you, Desiree Dali?
Yes.
Okay. And you have been charged with, 4 counts: trespassing property after warning, indecent exposure, false name after arrest, resisting officer without violence to his persons. I'm gonna go read the A form for probable cause. Do you have anything you would like to say, defense?
No, Judge. Not at this time.
Date? There's an extensive criminal history.
Yes, we're for sure asking for a felony hold. We're just trying to get together the dollar amount.
Yeah.
Wait.
For count 1, the trespass after warning, $500. Count 2, the indecent exposure, $1,000. Count 3, false name after arrest, $500. And the resisting officer without violence, $500 for count 4.
Okay, and the court finds probable cause as to trespass property after warning. The court finds probable cause as to count 2, indecent exposure, count 3, false name after arrest, and count 4, resisting officer without violence. I'm gonna look at his priors.
I'm sorry. You need the box.
He had a, in May of last year, he has a conviction and a sentence for battery, firearm. Okay, so I'm gonna give the bond for trespassing 500, indecent exposure 2,000, false name after arrest 500, resisting officer without violence 500. So the total bond is 3,500.
Your Honor, and also the state's requesting a felony hold at the state.
Yes, yes, and then there's so the right, the total bond is 3,500. I'm gonna grant the felony hold and the stay away order. Sir, you're to stay away from this following address. Sir, are you listening?
Yeah.
280 Northeast 135th Street, North Miami, Florida 33161. You understand?
Yeah.
You're not to go anywhere to the property. Okay, and your total bond is 3,500, and I'm also keeping you on a felony hold.
All right.
All right, thank you. Hey, hopefully they called your case. Sorry, Mr. Ramos. Oh, sorry. Oh, I like right here. Okay. Oh, thank you. Are you Mr. Ramos? Do you need a Spanish interpreter?
No, Judge, I'm Miss
Oh,
Ramos.
sorry,
Miss
sorry, I didn't mean Ramos, sorry. I mean, are you Azam Ali?
Yes.
Okay. And your attorney's present. I don't know if you could see Melissa Ramos.
Huh?
Your attorney's present, Ms. Ramos.
Good afternoon.
So this is a bench warrant, case number AH35P8E.
Yes, Judge, I know that there was originally the warrant had a $2,000 bond. I just be requesting the standard bond of $150. It was not a willful violation. The address that's stated on the A form and the citation on the 2023 case is incorrect. Therefore, he did not receive notice. It was a failure to appear at arraignment. So we'd just be asking for the standard $150.
Oh, I think you're looking at the new case, the new ticket case. That's the 150.
No, Judge, I'm saying I know that the judge issued a bench warrant in the amount of $2,000 on the 2023 case on the warrant.
Yeah.
But because he didn't get notice, because the address is incorrect, I'm just asking for your honor to issue the bond in the amount of $150.
Your Honor, it's up to the defendant to keep his address for the clerk's office in order to receive notice. So the state's requesting a $2,000 monetary bond to be converted.
Yeah, I'm gonna grant, it's true, he needs to upload, if his address changed, he has to, that's his responsibility. So I'm going to I'm gonna convert the bench warrant to the bond of 2,000.
That's fine, Judge. And then in the new case, we're just asking for the standard bond of $150.
Yeah, and the new case is, a new ticket, standard bond 150.
Yes, Your Honor.
State would be fine with all. For the
I'm sorry, what was that state? I couldn't hear you.
I'm gonna, over the state's rejectment, I'm gonna keep the standard bond of $150. So the second case will be the 150.
Okay, Judge, thank you.
Thank you so much. Okay. Are you Mike Kevin? I can't hear you, sir. Good
Wait,
afternoon.
go ahead. Go ahead.
Yes, ma'am. Okay, and this is, you have been charged with prostitution engaging in. I'm gonna go read your affidavit.
I don't have that. You can ask them in the.
You already know they.
Okay, I find probable cause. Defense, do you have any argument?
Yes, Judge, 1 second.
In your honor, posting a felony hold, the 7 the case number 25/2937.
I'm sorry, say,
Here's a felony hold. The state is requesting hold.
could I have the case for the please?
The state, want me to repeat, what's this case number? They can't hear.
F25002987.
It's not on the jail card.
You don't have a hold?
Judge, it's gonna be a felony hold, you just be requesting a $1 bond on this, too.
I'm gonna grant the felony hold. Complete.
Requesting standard bond, $150.
Yeah, I'm gonna grant 150 standard bond and the felony hold. Keep the felony hold. Sir, you're done. You have a hold for the felony. Your felony case.
You'll go on.
Okay. Are you Davis Demetrius?
Sorry, Judge?
Is this Andrew Demetrius Davis?
Yes.
Okay.
Judge, it looks like this bench warrant was issued. Judge, it looks like this bench warrant was issued while he was in custody.
So there's a bench warrant?
Yes,
And
it
then
looks like
there's also for the permanent
he's set to be released soon on the sentence that he's serving at the Florida Department of Corrections. This bench warrant was issued October 20th, 2025. He was in custody at that time. It should not be holding him.
Hold on, seats. Double check.
Listen, I'm sorry, but you didn't have to go in. Because we know. Here's the whole with the permit correction. This is expired on 4/21.
This one.
Yes, Judge, I believe that this is because his sentence is set to expire soon, so he's set to be released, but because he has a bench warrant active in Miami-Dade County, he was transferred here to deal with it, but again, this bench warrant was issued in error. You're done?
There's three.
No.
There's three
I
charges.
think you're not released until the 21st. Your release date is April 21st, so that's.
Where they say he was previously held, and that's why.
Wait, where was he previously? Public defender, where was he previously held? That you say it was not willful?
I'm sorry, state, he was in South Florida. He was in state. His sentence expires 4/6/2026.
I'm sorry, it was so hard to hear you. Where was he being held? In custody? There's 3 counts.
Per the M24 case, ending in 1965, the judge ordered for count 1, 10,000, and count 3, 10,000. Nothing for count 2.
Go ahead.
Judge, was that the state speaking? I could not hear.
Yeah, that was the state.
I did not hear anything they said.
What I said was on procedures, it states that the judge issued a bench warrant for count 1 on 10,000, and count 3, 10,000. Doesn't say about count 2. What we were previously asking you before is where was he held in custody?
He was in state prison.
They were asking you, the state's asking you, where was he held in custody?
He's in state
South
prison.
Florida, he was at
He
South
was in
Florida
state prison.
reception.
Yeah, I believe corrections has been answering. I don't know if you all can hear them.
I don't
He's been-
think
yeah,
they
he's
can
been
hear
in-
corrections.
That might be why. So he's been in state prison. His sentence is set to expire April 21st.
In state prison, expect to expire April.
It's in the A form.
Is it on the felony F2324276?
We told him.
I'm not sure what the case is. But he was in state prison. It says it on the A form. Defendant serving 2 years and 6 months at Florida Department of Corrections. Release date 4/21/26, meaning he's been in custody since 2024. The warrant was issued in 2025.
And count 2 was Noah Frost on
Count 2
10/20.
was no props according to corrections. So the $20,000 warrant amount, it
Was
should not
the
be
count
holding
one,
him
yeah.
because again, this was issued in error.
Correct. They only gave her count 1 and count 3. Prison.
He's about to finish his sentence.
On Tuesday, the 21st.
Which is why I imagine he was brought to Miami-Dade to deal with his bench warrant, which should not hold him past the 21st. He should be released from state prison on the 21st. It should not.
Your Honor, if that's the case, we're just gonna be asking for a misdemeanor hold to ensure that he doesn't appear in front of Judge Ernestondo.
Judge, this warrant was issued in error. He should be able to appear for his court dates out of custody.
Did you confirm that he's?
It is issued in error. I'm an attorney.
Yes, I understand, Your Honor.
So the state's asking.
We're just requesting a misdemeanor hold, not the $20,000 bench warrant, just so that he can appear in front of the division judge, Judge Ernestondo.
And what?
Judge, he can appear in front of any out of custody division judge once he's released from his sentence. He should not be transferred from state prison to Miami-Dade Corrections for something that was not well. What am I lying about? I'm so confused. Mind you, the attorney, it's not corrections that I'm really on. So I'm not really sure what the problem is or what the disconnect is.
ROR.
And how much is the standard on?
The bench was for 10 grand in each count, and since he was in state prison and couldn't possibly appear, we're still in ROR.
Thank you, Sage.
On all 3 counts?
Just count 3 because count 2 was no lost. Those were the ones that are for those.
I'm sorry,
Yeah.
On Tuesday.
Count 1, count 3.
And when will be his court date? Would he be in front of? He's already been assigned to a division, Judge Nelson.
Judge, can he get a date certain, please?
The date, May 20th? May 20th, 2026 at 11:45. Courtroom 5-2.
Courtroom 5-2?
Yeah.
And what was the time, Judge?
11:45.
We need to be present.
Hold on, I'm gonna get to the chat in 1 minute. I know you guys have done the chat. I'm gonna after I done this one. So you guys want to arm on everything, making sure that he's gonna appear, being released.
If his non-appearance wasn't willful, we have no grounds to hold him.
Right, since it wasn't willful and he was sentenced, we're gonna have to ROR it. 1 and 3. Okay. Was already provided. Okay, they already left. Okay. So now hold on 1 second. I see on the chat that Chi Bail Bonds says it was on the call. What happened to Mike Jackass. Can someone please tell me the outcome? I don't know if that case.
It was the prior case. It was $150 standard bond that was issued.
Can you hear me, sir? Which one? Oh. Thank you. Sir, can you hear me? Am I doing it wrong? Like unmuting him? Sir, you can hear me, correct? Okay, so in the last case, and you're here, it was for Mike Jacques, Jaqques.
Yes.
Yes, it was $150 standard bond.
Yes. For committing or engaging in prostitution was the charge.
I gave, yeah, no, I think I gave higher.
We have 150 here, Your Honor.
But he
and
has a felony
felony.
hold. 150, but he has a felony hold, so that's why we left the standard bond, but there's a felony hold on that. Is there any other attorneys that are here present that on the chat? Okay, I'm gonna go ahead and continue to Brian Clifford. Mr. Clifford? Is Mr. Clifford there? On count of trespass property after warning?
Corrections is attempting to bring him, Judge. Corrections is trying to bring him.
Sorry.
Okay, if we can pass him, Judge.
James? And right there.
Okay. We'll put it to the side. So the next, is that, so are you James Blum? Okay.
Mr. Blunt, go. Yeah.
This is a bench warrant.
Question.
It says here he was out of state a fugitive.
Yes, that's correct, Your Honor.
So I'm not gonna, he's a fugitive. He's out of state. Nope. Wait,
One moment, Your Honor.
yeah, take your time.
Thank you.
For Mr. Blum, Judge,
Yes?
we would just be asking for a dollar bond in this case.
He's out of state. Fugitive. Yeah.
Number 16.
At this point. If it's
Long and people go Colorado, no bond.
She said, what's wrong? State, we cannot hear you. You have to speak in a mic.
Yes, thank you.
Sorry. For this, you did have no material, especially for that I could sit for judge which address the case.
Yes, so he's only gonna be held in Miami-Dade County on his open misdemeanor, which is the bench warrant in front of us. It's a drug para bench warrant. That's why I'm just asking for $1 bond to see if he wants to deal with his other hold.
This could be even separate by issue that's yes. Or as a mom.
And Judge, I don't see any local priors. That's just, I would renew my ask for $1 bond.
Sorry, just to be clear, I'm 26104 case. There's a that well. If you were
She probably hears somebody else, man.
after you were bro.
She got me messed up with somebody else. For real.
Judge, I'm sorry, can you, the state repeater, inform me as to what?
Off the phone. Yeah.
Judge, have a felony hold on a fugitive because he cannot deal with that case for Miami-Dade custody, meaning if he resolves his misdemeanor case, he's just going to be held in custody without being able to address his out-of-state hold. The fugitive warrant in itself is a hold, meaning that if he resolves his misdemeanor, he'll be extradited to wherever he needs to deal with his case, so a hold is inappropriate.
You should get me all mixed up, dude.
It's
Judge, that's automatic. Individuals are placed on the extradition calendar once their misdemeanors are resolved, as long as they have an extradition hold. It doesn't require the court to do anything else. It's automatically on their jail card. So once he deals with this misdemeanor, if he takes a plea, if he goes to trial, if it's a no cross, he will automatically remain in Miami-Dade custody, waiting extradition.
right.
It does not. It's an automatic hold, yes. Judge, just to be clear, that's the automatic hold, not an additional felony hold, correct?
Well, so it's gonna be, the bench warrant will be converted to 500. And then
Oh my God, where's she going to be?
out there so it gets picked up.
Okay, so there is no other hold, just a fugitive warrant that's already there.
Right.
Okay, thank you. You want Spanish? Oh, this one, you speak Spanish? And he needs the services of the Spanish interpreter, Judge.
What is it?
Interpreter present.
Jimenez. Sergio Jimenez Torres.
Yes. Interpreter?
You got the right place.
This is, Sergio Jimenez Torres, and it's in no ID.
Judge, and I do have a piece.
Excuse me, Your Honor, the interpreter is having issues hearing the court.
They have a PC argument. Okay, what is your PC argument?
¿Cuál es su argumento en
Judge,
relación a la suficiencia de indicios?
Judge, this is an end to loitering and prowling. According to the A form, the officers saw Mr. Jimenez Torres in a high traffic area. The case law is clear that's not enough to warrant a stop. Additionally, the officer did not see Mr. Jimenez Torres actually committing any acts that raised any reasonable suspicion that there was crime occurring or about to occur, and therefore he should have never been able to stop him. And additionally, to prove loitering and prowling, the officer needs to actually have witnessed something in order for them to be able to testify to it. So there's just no loitering and prowling alleged in this A form, other than him driving in a high traffic area and making the officer uneasy.
Señoría, los policías indican que ellos observaron al señor Jiménez Torres en una zona donde había mucho tránsito. Eso no es suficiente para justificar que se le detengan. Además, no se vio al señor Jiménez Torres cometer ningún delito. Esto no es suficiente para vagabundear y merodear, que es el cargo que está enfrentando. Y por último, el policía tiene que poder haber presenciado alguna cosa que él puede articular verbalmente por qué lo paró. Lo único que dijeron es que lo vieron en una zona donde había mucho tránsito e hizo que el policía se sintiera inquieto. Esto no es suficiente para sustentar el cargo.
Waiting for the state.
Your arrest.
Judge, and if I'm response to the
Excuse me, Your Honor, I cannot hear, the interpreter cannot hear the court.
I said the court finds probable cause.
oh, Judge,
El tribunal determina que hay suficientes indicios de
Judge, if I may
criminalidad.
respond to the state's argument, I'm unsure as to where in the A form there's an allegation that there was crime about to be committed or that the officer saw anything to warrant any type of crime. Sure, Mr. Torres might have not answered the officer's questions that he wanted to. In order for him to even ask him questions, he needed to have observed something to warrant the stop in order to support a finding of loitering and prowling. Judge, there is no finding here, or there's no allegation here that he saw anything. For example, all the case law for loitering and prowling is essentially seeing people opening the door handles of cars, etc. There's no type of allegation here for that matter. It's literally just him driving in a high crime area. There's abundant case law to show that that is not enough to warrant either a stop or a conviction under loitering and prowling.
Señoría, si puedo contestar el alegato de la fiscalía. Aquí el señor Torres solamente se le detuvo porque estuvo en una zona de mucho tránsito. No hay ningún alegato de que hubo algún delito que estuvo a punto de ser cometido. La mayoría de los precedentes que tienen que ver con vagabundear y merodear tienen que ver con cosas como que la persona estuvo tratando de abrir vehículos. Aquí no se ha alegado nada así. No hay suficiente fundamento para justificar el cargo de vagabundear y merodear.
Oh, sorry. Judge, even, I mean, the officer's questions about plumbing and electric, that has nothing to do with a crime. I'm very confused.
Señoría, las preguntas de los policías no tuvieron nada que ver con el delito. Estoy confundida. The court said something, Your Honor, the interpreter did not hear it. I cannot hear it. This is the interpreter speaking. Maybe I should I should log out and come back in again. I cannot hear the court. And no. Can everyone hear the judge?
Right now, the judge is muted, interpreter.
Okay.
Wait,
Very
can you hear
well.
me now? I think it was mute. Sorry. Okay. So the
Yes,
court
yes, Judge,
found,
now
you
I
can
can
let him
hear
know
you.
the court found probable cause, and the amount is standard bond 150.
El tribunal estimó que hay suficientes indicios de criminalidad. La fianza es la fianza estándar, 150.
Sir, are you, Ariel?
No, this is Brian.
Judge, that we passed earlier.
Okay. So you're Brian, are you Mr. Clifford?
Yeah.
Okay. So Mr. Clifford, you're charged with one count of trespass property after warning. I'm gonna read the affidavit to see if there's probable cause. Okay, I find probable cause.
Judge, I would just be asking for Mr. Bryan to be ROR'd and given a date certain. He has no priors. He is currently homeless. This is a non-violent.
The state is no.
Oh,
Can you repeat that stay? I could not hear you.
hold on 1 second, sorry. He has a lot of no.
The state
Sir,
has no objection. Your Honor.
sir, are you homeless?
Are you homeless? The judge asked.
I don't even know. Yeah, I don't really. Maybe I don't know.
He represented to me that he's homeless, Judge.
Do you have any current address where you're staying?
Can you understand the judge? She said,
Standard bond is 500, right?
Standard bond amount, Your Honor, is. Yes, Your Honor.
Okay. We could if he is homeless, we could possibly do tap with alternate 500.
So I'm saying I'm somebody fucking at this home. You understand?
I don't know.
it's on mute.
You can ask him again, Judge.
Are you, sir, are you homeless or do you have an address?
No, it's about no.
He's not gonna answer, so,
I ain't answering it.
okay. I'm going to do,
She ain't never lived on the street.
If we don't know if he's homeless, then we would just be requesting a $500.
yeah, I'm gonna go ahead with the standard bond of $500. Standard bond of 500. And sir, you walked away. Sir, Mr. Clifford, there's a stay away order. Is he waiving his presence? Okay, well, I guess the defendant waives his presence. So for the record, he's to stay away from McDonald's located at 6150 South Dixie Highway, South Miami, Florida, 33143. He walked away while I was speaking to him. So violation of coming on the property, he'll get arrested and there's a standard bond of 500. The next case that I have is Ariel Horapron. Is your name Ariel?
Spanish is.
He's the Spanish interpreter.
Usted se llama Ariel.
Sí.
Yes.
So he's Ariel. How do you say your last name? Can you ask him how to pronounce his last name?
Caballero, ¿su apellido cuál es?
Corporal.
Corporal.
You have been charged with one count of trespass property after warning. I'm going to read the rest affidavit to see if I can see if there's probable cause.
A usted se le acusa de un cargo de intromisión ilegal. Voy a leer la declaración jurada de su arresto para ver si contiene suficientes indicios de criminalidad.
Yes, it is clear that there's probable cause for a trespassing.
Do you know
Do you know
the
the victim, Milton? You spell it Raijam? Maybe
Sí, hay
Raymond?
suficientes indicios de criminalidad, claramente. Usted conoce a la víctima. Él se llama Milton Raiham.
Sí.
Yes.
Okay. Sir, you are
Caballero.
prohibited from having any contact with the victim directly or indirectly, in person, in writing, by telephone, pager, or fax.
Judge, there should be a stay away order from the location, not from the owner of the building.
Please let him translate first.
Caballero, le está prohibido tener cualquier tipo de contacto directa o indirectamente con la víctima, ya sea en persona o a través de medios electrónicos como beeper, fax o cualquier otro medio electrónico.
Or through third persons, defendant must stay at least 500 feet from the property located at 707 71st Street, Miami Beach, Florida 33141.
O a través de terceras personas también le está prohibido contactarse con él. Usted en todo momento tiene que mantenerse por lo menos a 500 pies de distancia del inmueble, de la propiedad ubicada en el 707 calle 71 en Miami Beach, Florida 33141.
Ok, yo trabajaba ahí antes.
Okay, I
Understand
used
that,
to
sir?
work there before.
Okay. And I know the defense mentioned it shouldn't be the person, but here on the affidavit, the building owner is Mr. Raymond, and he advised him, so I'm gonna have a stay away order be from the property location and also from that individual.
Yo estoy al tanto de que la fiscalía me ha indicado que él se tenía que mantener alejado de la propiedad solamente, pero aquí en el formulario juramentado del arresto se indica también el dueño de la propiedad, el señor Raymond. Y por tanto estoy ordenando que usted se mantenga alejado no tan solo de la propiedad, sino también del dueño.
And probable cause was
Okay.
found, and there's $500 bond.
Determino que hay suficientes indicios de criminalidad. Su fianza son $500.
Thank you.
Gracias.
The next case I have, the next case I have is William.
Come on, sir.
William Fantuzzi. I don't know if how to pronounce it. It's Fantauzzi. Is your first name William?
Spanish.
No matter.
English. Your name William.
Well,
I think we're gonna need the Spanish interpreter. Can you ask him for his name, please?
Caballero, ¿su nombre cuál es?
He speaks English.
Okay, sir, what is your name?
William Fantauzzi.
Okay, you're charged with 1 count of petty theft. I'm gonna go ahead and read your affidavit, the rest affidavit to see if I find probable cause.
Yeah.
Okay, there's probable, the court finds probable cause. State?
One moment.
Of course, take your time. And defense, do you have any PC or any arguments you'd like to address?
Judge, I would just be asking for him to be released on his own recognizance. This is a nonviolent offense. And he is currently homeless, so he would need a big certain.
Your Honor, the state was requesting an immediate bond in this case, given these numerous previous convictions.
Yeah, I'm looking at the conviction now. There is several convictions, not just arrests. The standard bond is
150, Judge.
state's request, so it is an elevated bond.
I'm gonna do an elevated bond. He has plenty convictions of $1,000. Oh, and also there will be a stay, sir, there's gonna be a stay away order from the Publix located at 155 East Second Avenue, Hialeah, Florida, 33010. You are to not go on the property or you will be arrested. Do you understand that, sir?
Yeah.
Okay. Okay. Thank you. Take care. Oh. Okay. The next case is Brian Rizzo. Are you Mr. Rizzo? Can't really see him. Are you Mr. Rizzo?
Okay.
Okay. You have one count. One case is for alcohol beverages, curb drinking prohibited. I'm going to read your arrest affidavit to determine if there's probable cause.
You remember me, Mr. Rizzo?
Yes.
Good to see you.
Okay, the court finds probable cause on the first case. The court case is M2. The case number is M26007543.
With regard to the curbside drinking, the state final argument.
Sorry, can the state repeat that one more time?
No, he has a arrest. I'm gonna do the standard, I'm gonna do the standard 150.
Judge, I'm sorry, can you tell me what that's based on? There's no priors in his record. We asked for ROR. The withholds that you see are not priors, Judge.
Elevated the bond to 1,000.
Everything else has been no cross or no action. It should not be considered against Mr. Nova.
Okay, I'm gonna just do the standard monetary bond of 150. And the second case that I have is M26007541. And this is one count of petty theft. I'm gonna read the arrest form to determine if there's probable cause. Court finds probable cause. Defense, any argument?
Renewing my argument for an ROR on both of the cases. He has no priors. He's experiencing homelessness. These are non-violent offenses. I believe that the state would, I couldn't hear them, so I don't want to misrepresent, but I believe that the state did not object to an ROR.
I didn't.
They're asking for an ROR on the petty theft.
Yes, Judge, and I would be asking for an ROR on both cases.
The state's requesting standard on the petty theft. I'm gonna go ahead and grant the $500 standard.
How much, Judge, total was the bond?
The total, the first one was 150 and the second one was 500.
150, Judge, was an M2.
Each count should be 150, a standard bond.
Yeah, sorry, I'm challenged 150. And there's also a stay away order. Hold on 1 second. So 150 for each one. And then, Mr. Rizzo, are you listening, sir? You must stay away from a CVS located at 1177 Southwest 8th Street, Miami, Florida, 33130. Do you understand that, sir? I can't hear you.
Yes, I understand.
Okay, if you go on the property, you'll be subject to getting arrested. You understand that?
Okay.
Okay, thank you. So the next case I have is Matthew Ines. Are you Matthew, sir?
Get out, Judge.
That's a bond out, Judge.
Ines Matthew?
It's a bond out.
Okay, thank you.
Also Terrence Elward.
Hold on 1 second. And then, wait, hold on 1 second. And Ines Edwards was a bond out?
Terrence Edwards is also a bond out.
Okay. On both of them? Okay.
But here already stuck.
Relax.
Let me see. The next case that I have is Brandon Bowen. Are you Mr. Are you Brandon?
Yes, I am.
Okay. So you've been charged with 1 count of petty theft. I'm going to go ahead and read your arrest affidavit. Defense, do you have any PC arguments?
Not at this time.
Okay. Okay, the state finds probable cause for the petty theft. And there's going to be a stay away order from the target located at 3401 North Miami Avenue, Miami, Florida 33127. You understand, sir? You cannot go near that property?
Okay, yeah, I understand.
Okay, hold on 1 second. So I believe that there's three counts of petty theft.
That is correct. At this time, the state would request an elevated bond as to each count in the $1,000 given the defendant's convictions previously.
Judge, I would be asking for standard bond on each count. I do see that he has convictions, but I don't see many petty thefts in this convictions. I don't see any petty thefts.
Over the defense, he has several convictions. So count 1, 1,500. Count 2, 1,500.
Judge, these are M2 petty thefts. I believe that's a little bit excessive. The standard bond is 150. It's tantamount to no bond. He's homeless.
The prosecutions don't need to be for petty thefts in order to
I understand that.
convictions. For those, the state believes that the elevated bond is appropriate.
I understand they don't require, it's not a requirement of their petty theft convictions, but even someone with convictions should not be held without bond. Essentially, he's homeless, $1,500 bond on 3 counts. It's something that he cannot pay. It's tantamount to no bond. He's not going to be able to afford that. And these are M2 petty theft convictions where the standard bond is 150. Basing it only on the fact that he has priors in his record is unwarranted.
He'll be in front of the division judge in 2 days, which maybe he'll be able to get out at that time. But at this time, based on his record, I'm going to do the elevated bond, and he'll go in front of the division judge on.
Judge, that's incorrect. There's a 21-day reset now. That means that he will be in custody for about 25 days before he sees another judge. I'm in jail in front of Judge Obersando.
Will go in front of the judge in 2 days?
Not anymore, Judge.
I'm sorry, Your Honor, what was the bond from Mr. Bauer?
His case will be set for first arraignment sometime in May. At that point, he will get another arraignment date 30 days later, at which point then his case will be set for trial, meaning that he will be in custody on these M2s for more than 2 months.
Okay, sorry.
We'll file motion, modify bond if they so wish to, and have it placed on calendar before the arraignment.
I don't see what the point is in doing that when we can address his bond right now at his bond hearing. And if you're saying that I can modify it in 21 days or before, why can't we not do an elevated bond right now?
The state's reasoning is because at this point, they believe the elevated bond is proper. However, if you disagree, you can file a motion in front of the judge.
Judge, I stand by all my arguments that I've already made. I don't think it's appropriate to hold somebody on a $4,500 bond for 3 M2s.
He's an extensive priors, and I also did the stay away order against the target at 341 North Miami Avenue, Miami, Florida 33127. And like the state said, you can file a motion. Count 1 is 1,500, count 2 is 1,500, and count 3 is 1,500. Thank you. The next case I have is Samuel Lalani.
Your detail of the probation F-25-5618.
The same as the other one. Is there anybody here for Samuel Lalani? Good afternoon, sir. Are you Samuel? Okay. You've been charged with 1 count of petty theft. I'm going to go ahead and read your arrest affidavit to see if there's probable cause. Defense, do you have any PC arguments?
Not at this time, Judge.
Okay, thank you. State, I find probable cause.
Judge, at this time, I'd just be asking for pretrial services. He has a permanent address. And this charge is nonviolent in nature. I'm sorry, did the state say that there was a violation of probation?
No, they have not spoken. They're about to.
Details of the violation of probation F-25-5618.
I'm not sure if he qualifies for pretrial services just because he does have a probation warrant on a felony case.
Corrections, can you verify if that was an M25 or an F25 case, please?
I'm sorry?
For the violation of probation, is it a felony or a misdemeanor?
It's a felony, F-25-5618.
Judge, then I would be asking for a dollar bond.
On the 267-550, the state would be requesting a standard bond of $150. The felony case that has a probation warrant, the F-25-5618, states that he is to be held no bond until he's addressed in front of that judge. And the state is also requesting a felony hold on the F-26-7584, as he has an open felony for a burglary of an unoccupied structure.
Which one is that?
F-26-7584. That is his open felony case, where he's being charged with burglary of an unoccupied structure and criminal mischief as well.
Okay, so count 1, it's going to be standard bond for the petty theft of $150. He's going to be the felony case F-25-005618. There'll be no bond. And
it would just be a probation hold.
And then there's going to be there's also a felony hold on the burglary. Yeah. And And there will be a felony hold on the burglary charge. And there's also a stay away order from the target, sir, located at 3401 North Miami Avenue, Miami, Florida, 33127. Do you understand, sir? I can't hear you. Can you talk in the microphone, please?
The microphone doesn't work. He said yes. Say it again, say it louder so she can hear you. Yes.
Okay, perfect. So there'll be a $150 PC was found for count 1, and there's also the felony hold for the burglary. Thank you. The next case I have is Leslie Jokan. Sorry if I mispronounced that. Oh. Yeah. Please. Sir, can you say your name, please? Okay. You've been charged with 1 count of petty theft. I'm going to go ahead and read your arrest form. And public defender, do you have any PC arguments at this time?
Not at this time, Judge.
All right, thank you. Okay, the court finds probable cause for the petty theft. I'm also going to issue a stay away order from the CVS located at 1825 Northeast 185th Street, North Miami Beach, Florida, 33179. Sir, you're not to go to that property. Do you understand, sir? Did you say yes? Okay. Date?
State elevated bond in this case, given defendant's previous or theft.
And there's also, I believe, a felony case.
That'll be addressed in the felony.
Okay. So the standard bond is normally 150. There's been some violations. I'm gonna elevate it to $1,000.
Sorry, Judge, I can't hear you.
$1,000 bond.
Judge, again, I would be asking for standard bond. This is an M2. The standard bond is $150. He's gonna, I believe that correction said he would be seeing the felony judge later. He's gonna, I don't understand why the $1,000 elevated bond is required.
The state has taken the position that there's been several petty thefts, actually convictions. We're not just talking about no costs. So they're asking for an elevated bond at this time, which the court's going to grant. Thank you.
Come on, sir. You gotta talk about, but you're gonna come back in and see the judge again.
And the next case I have is Bobby Andres.
And the box.
Who, Judge?
Bobby Anderson.
Bobby Anderson.
Yeah, in the box. I'm sorry.
Are you Mr. Anderson? Good afternoon. Good afternoon. Are you Mr. Anderson?
Yes, ma'am.
Okay, you've been charged with 1 count of petty theft, and there's also a stay away order. I'm going to go ahead and read your A form. Defense, you have any PC arguments at this time? Okay, the court finds PC for petty theft. Sir, you're supposed to stay away from the TJ Maxx located at 1420 Northwest North River Drive, Miami, Florida, 33128. Do you understand, sir?
Yes, ma'am, I do.
Okay. And state?
One more. State would be requesting elevated case, Your Honor, given the defendant's criminal.
I'm sorry, could I hear?
The state would be requesting elevated bond, given the criminal crime.
With his said felony 426 of a petty theft, which he was convicted.
Judge, I would just be asking for standard bond.
Yes, that's correct.
Yes.
Okay, I'm gonna give, I mean, his last conviction was this year for petty theft. So I'm gonna do bond of 1,000. The next case I have is Daniel McCrary. Is this, are you Daniel, sir? Sir, are you Daniel McCleary?
He said yes, Judge.
Danielle McCurry.
Okay, sorry. Okay, sorry, I pronounced that incorrectly. So you've been charged with trespassing property, structure, conveyance, and the order to leave. I'm gonna read your arrest affidavit to see if there's probable cause. And do you have any PC arguments?
No PC arguments.
Defender? Okay, there's PC 5. The court sounds there's probable cause. Public defender, do you have any arguments at this time?
Yes, 1 second, Judge.
Okay, take your time.
Case.
Yeah, yes, Judge, I'd be asking for an ROR.
Because he has no priors, right? But I believe, okay.
He was found sleeping at a police station. We're fine with our.
Okay. So, sir, are you homeless?
Sir, wake up, wake up.
I just wanted him to confirm. Are you homeless?
Trying to get to my road,
Yes, Judge, he is.
Okay.
Can you see if it qualifies for TAP? Maybe they have just a second.
Do you want defense? Do you want to see if he possibly qualifies for TAP?
This time, I would prefer that he just be released. TAP sometimes takes a while to get back to us, so I don't want him to sit in custody awaiting.
That's fine. That's fine. Let me get the date certain for him, so you could give it to him. So I'm gonna RR him, and let me give you the next court date.
You just gonna get the next court date, okay, and then you can go. Okay, let the judge give you your next court date. What's the date, Judge?
Yeah, hold on. The clerk is gonna let me know right now. Okay, so the next date, if you can write it down for him, is May 7th, correct? May 7th, 2026 at 2:45 PM in courtroom 66. Did you get that? May 7th, 2:45 in courtroom 66, and he will be RR'd. Sorry, I see someone in the chat that asked about Lydia Houston. Sir, are you Juan Andrews
yes,
Cully?
Okay.
Okay. Okay, you've been charged with approach the first responder after warning, harassment, resisting officer without violence. I'm going to go ahead and read your A form to see if there's probable cause. And public defender, please let me know if you have any PC
At
arguments.
this time, we'll be raising the PC argument for the first charge, the
Okay, let me just read the A form real quick. Yeah, and approach it, responder after warning and resisting officer without violence. Okay, what is your PC argument, please?
Go ahead, I'm sorry.
Judge, I will be raising a probable cause argument for count 1, approaching the first responder after warning, according to the A form. Mr. Kaya was actually leaving the scene and the offender initially began to leave the scene. He got approximately 15 feet away, at which he turned around and began to yell. Doesn't mean that he was approaching the officer. And then the officer says, I once again approached the offender to take him into custody. Under the statute, it says that under the subsection that he was charged, says it is unlawful for any person to, after receiving warning, to approach the first responder. He was not approaching him at this point. As to the second count, Judge, I would be arguing that there is no probable cause because the officer did not have a legal duty in arresting Mr. Kaya, according to the A form.
State?
I'm so sorry, we can barely.
Can you talk louder? They couldn't hear any of your arguments. Yeah, sorry about that.
State, no, you're good. I've had them repeat themselves a couple of times today. So I'd be raising a probable cause argument as to count 1. The statute that it was charged under requires that the person be approaching the first responder. According to the initially began to leave the scene, the offender got approximate distance of 15 feet, at which point he turned around and began to yell at the units on scene. Then the officer says, I once again approached the offender to take him into custody, meaning that Mr. Kaya never reapproached the officer. He was just exercising his First Amendment right in speaking. As to the second count, the resisting without violence, there is no legal duty according to the A form. Again, seems like Mr. Kaya was just using his First Amendment right to speech, and therefore the officers did not have a legal duty as required by the statute for resisting without violence. And I'd be asking, obviously, for him to be released outright for no probable cause on either charge.
Your Honor, the arrest says that the defendant was within 10 feet of the officer. He then to irate, believing that the officers were attempting to violate other males' rights. As well, the officer gave him a lawful command to leave the scene, and he did not obey that lawful order due to the non-obeying of the lawful command. We believe there's also probable cause for resisting.
Judge, he was obeying the lawful command, began to leave the scene, which is exactly what the officer asked him to do. Just because he turned around and said some words that the officer did not like did not mean that he's violating the law. He was walking away. He did not reapproach the officer as required under the first charge of it literally is approaching first responder after warning, and the officer verbatim says, I once again approached the offender, meaning that the officer is the one that walked up to Mr. Calle. And because of the fact that he was obeying his lawful command to leave, as the officer says, he began to leave, then there is no legal duty
Your Honor, if I
to arrest him. Just because he has insulted the
You
officer.
may respond.
although it does
Although it
to harass the officer, once he is then attempted to release into custody, he begins to tense up his arms, preventing the from putting him under arrest.
Okay,
Judge,
I
there was-
find probable cause to count one, and one issue standard bond of 250.
Yes, Your
Count
Honor.
two, resisting officer without violence of the interest, standard bond of 500.
Judge,
And I find PC in both counts.
just for the record, just because the action is unliked, doesn't mean that it violates the law that's charged. The statute is clear. And neither of these two things warrant either resisting or approaching an officer when the officer himself said that he was walking away. So there's no probable cause.
Well, you guys can take that up in division. I find that there's sufficient for probable cause for the arrest.
Judge, please.
The bond is gonna be on count one, 250, and on count two, which is the resisting officer, 500, total of 750.
Come on, sir.
Along the head street.
Okay, the next case I'm gonna be calling is Anthony Gonzalez. Are you Mr. Gonzalez? I can't hear you.
Yes,
Are you
ma'am.
Mr. Gonzalez? Do you need an interpreter, or is English fine? Okay. You've indecent exposure. I'm gonna go ahead and read your affidavit to determine if there's probable cause.
Judge, and I do have a probable cause argument when you're ready.
Okay. Let me first, let me read it. Okay, please go ahead with your probable cause argument.
Judge, indecent exposure requires actual exposure under the statute and even under the language of the charge itself. The witnesses here specifically said they did not see Mr. Gonzalez's private parts, and therefore there's no probable cause for indecent exposure.
Why didn't he even get arrested?
Date.
For the first sentence of the A form, the victim did observe the defendant masturbating in plain view. There are witnesses who did not see his private parts, but there's nothing here indicating that the victim did not.
Judge, sorry.
Okay, they said based on the A form, while defendant was sitting in the waiting area at gate F9, he was observed by the listed victim masturbating in plain view. The victim, the two witnesses, it wasn't in plain view, but that the victim saw it in plain view. I would agree with the state that
Judge, that's not enough for indecent exposure. Indecent exposure requires actual exposure. If there's no allegation that there's actual exposure of his private parts, then he cannot be held on an indecent exposure. It's not the right charge, and it's incorrect. There's no probable cause. Just because somebody said that they saw him masturbating but didn't see his private parts, that goes completely against the statute. It says it in the language, indecent exposure. How can somebody be held for indecent exposure without exposing themselves?
But you can respond. State. It says under the statute, 800.328 that it dictates that if a
Judge,
violation-
sorry, I can't hear you.
Sorry, I was looking up the statute. Under the statute, 800.032A, I was just pulling up the statute. It says it dictates that if violation of exposing sexual organs in a vulgar, indecent manner or being nude in public, I consider the victim watching him masturbate would be considered being vulgar in public. So I
Judge, that's not the element that I'm attacking. I'm attacking the exposure part. You cannot be found guilty of indecent exposure without exposing yourself. There's no allegation. And even the witnesses themselves said that that they cannot attest to him exposing himself. It's in the name of the charge, Judge.
Your Honor, we can resend this for PC hearing to the officer or even themselves to come and testify tomorrow.
Okay. Judge, the officer wasn't there. It's the witnesses. Like it's in the A form. The officer swore to it that the witnesses told him this. He should not be held on something that there's no probable cause.
The officer can testify as to what the victim saw.
Yeah.
But he wrote it in the A form already. It says the witnesses told me that they did not see his private parts.
But that doesn't mean the victim didn't see.
So then the officer can change his mind about what he wrote in the A form. Okay. Sure. Okay.
Well, that's why we're setting for will cause hearing just to determine what the victim saw and
But if they didn't have it in the A form, then sure, we can reset it, but it's in the A form. It says two witnesses saw the motion of the body, but did they not see his private part?
So you guys are gonna reset this for tomorrow?
Yes, Your Honor, for PC hearing.
So just right here, reset. So it'll be reset for PC hearing 419. Thank you. The next case I have is Felipe Leones Collin. Sir, you're gonna have to stay. We're gonna contact the state attorney is gonna contact the officer, so you'll appear tomorrow. Sir, are you Felipe? I can't.
Sorry, Judge,
Are you Felipe, sir?
No, he speaks English, Judge.
Do you need a Spanish interpreter? Okay. You've been charged with 1 count of drug paraphernalia, possession with intent to use, and the second count is driving while license is suspended knowingly. I'm gonna go ahead and read the affidavit for probable cause. And public defender, please let me know if you have any PC arguments. And there's a traffic infraction. Okay, so count one, drug paraphernalia possession with intent. The court finds probable cause.
Mm.
Unless you have a probable cause.
Not at this
cause
time,
already,
Judge.
Defendant,
State,
state,
State would be
which is 150, correct?
For the drug.
500.
500.
So sustainable.
So standard bottom 500.
And then for driving with license suspended,
Okay, and then I have the traffic misdemeanor, which is case ANECSJE. And the court finds probable cause and it's going to issue the standard bond of 150. And then I believe there's a new case.
I gotta come back on time.
No, the box, when the, this is 500.
Oh, Juan Carlos.
Flores. No, you gotta order, somebody got to in the road. You know, ain't nothing to do. The bond on this is 500. 500. Juan Carlos?
Es usted, Juan Carlos.
Are you Juan Carlos?
He needs the Spanish interpreter, Judge.
Okay. Can you make sure that he's Juan Carlos?
Asegúrese, puede asegurarse que es Juan Carlos.
Yes, Judge.
Okay, he's been charged with one count of alcohol beverage curb drinking, which is prohibited. I'm going to read the arrest affidavit. And then there's also another bench warrant case.
Se le ha acusado de un cargo de beber bebidas alcohólicas en la acera. Voy a leer su declaración de su arresto para ver si contiene suficientes indicios de criminalidad. Y también usted tiene otro caso porque no compareció ante el tribunal y se emitió una orden de búsqueda y captura en su contra.
Okay, so I find probable cause for count one.
Determino que
You have an
suficientes
argument?
indicios de criminalidad en relación al primer cargo.
Judge, I don't have a probable cause argument. I would just be asking him for corrections that he doesn't have any other holds.
No, I believe there's
Debería, no tengo ningún alegato en relación a la suficiencia de indicios.
To address the bench warrant, he was unaware of his court date and that he had an open case, so it's not a willful violation. As far as discharge in front of you today, it's an N2 for drinking on the curb. It's a nonviolent offense. He has no priors.
Debería, él no estaba al tanto de que tenía aquel otro caso pendiente, por tanto, cuando él no compareció ante el tribunal, no lo hizo intencionalmente. Y en relación a este caso en la acera, bueno, este es un delito que no es violento.
I'm going to issue the standard bond alcohol curbside of 150. PC was found.
Emito o impongo la fianza estándar, que son $150 por el cargo.
State, did you want to say anything on that one?
We couldn't hear why.
Fiscal, ¿desea añadir
We
algo?
couldn't hear why the bench warrant and his non-appearance was not a willful violation.
Can you repeat why the bench warrant, which I'm going to address now, was not a willful violation? It's failing
Yes,
to.
Judge, it's, he represents.
¿Puede repetir por qué no faltó al tribunal intencionalmente?
Judge, he represented to me that he was unaware that he still had an open case. He didn't get notice in the mail. Again, there's case law to back that does not warrant a willful violation. A willful violation is that he intentionally failed to appear. He did not in this case. I would just be asking him for him to be released on that bench warrant. And again, Judge, I understand that you set a standard bond, but for this alcoholic drinking on the curb when he has no priors, I would again just be asking for him to be ROR on those counts.
Señoría, él me dice que él no estaba al tanto de que tenía aquel cargo pendiente y hay precedentes que justifican que eso no es suficiente para establecer que hay un incumplimiento intencional ante el tribunal. Y en relación al cargo de beber en la acera, su señoría, eso yo entiendo que usted colocó la fianza estándar, pero él no tiene antecedentes, se le debe permitir salir bajo palabra.
And let me just say for the record, the case number that we're talking about, the bench warrant, is A9KSEUE. And actually, I'm looking at it, it's that he's on August 1st, 2019, he was placed on probation for the offense of drinking under the influence. So I believe the bench warrant is for probation violation. So I believe that it was only if he's on probation. I don't know what the state has to say.
Permítame indicar para que conste en el acta que el caso en el cual se emitió la orden de búsqueda y captura en su contra es el A9KSEV y que él estaba con libertad vigilada, probatoria en aquel caso.
That's correct, Your Honor. It is for a violation of probation as well. All notices were sent out to the defendant. He also has notice from the probation committee. There's no reason why he shouldn't have known about his court date. The state's requesting that the bench warrant be converted into a monetary bond.
I'm gonna grant the bench warrant into monetary bond. You're on probation. It's on you to be aware of it, to say you're unaware. I believe that you had all the knowledge you were on probation. You violated the probation. So the 3,500 will be converted to a monetary bond.
Bueno, la fiscal alega que usted estaba con probatoria en relación a aquel otro caso y que usted tenía la obligación de estar enterado de que estaba con probatoria y además de que tenía cita ante el tribunal. La jueza concuerda con aquello y le convierte el monto de la orden de búsqueda y captura, que son $3,500, en una fianza de $3,500.
Thank you.
Gracias.
So are you Hector David?
And he needs a Spanish interpreter.
Okay.
Javier, ¿es usted Héctor David? Yes.
Okay, you have a bench warrant.
Usted es objeto de una orden de búsqueda y captura.
And I believe there are 4 counts.
Tengo entendido que hay 4 cargos.
See, there's 4 counts: controlled substance with possession, pink cocaine, controlled substance, possession, cannabis possession, 20 grams, and drug paraphernalia with intent to use.
Y hay 4 cargos: posesión de una sustancia controlada, cannabis, cocaína.
I apologize, those will be heard in felony. So this is only for the driver's license, no driver's license, the bench warrant. State?
Bueno, esos son los delitos graves, pero en este momento solamente vamos a lidiar con el problema de tránsito de su licencia de conducir. Fiscal.
The state's request is to convert the bench warrant into a monetary bond.
La fiscalía pide que se transforme la orden de búsqueda de captura en una fianza monetaria.
Judge, it's his representation to me today that he moved addresses and he did not receive notice in the mail again. I renew my argument that this is a local violation. Additionally, he, correction, said he will be back to address his felony cases, and therefore I'm requesting a $1 bond on this case.
Señoría, él me ha dicho a mí que él no estaba al tanto de esa cita que tenía ante el tribunal, por tanto, la falta de comparecencia no fue intencional y en relación él va a volver ante usted en relación a los casos por delito grave más adelante. Por tanto, le pido que en relación a esta causa le ponga una fianza de $1.
Against the public defender objection, I'm going to convert the bench warrant into the bond, the standard bond.
Muy bien, entonces sobre la objeción de la defensa, voy a transformar el monto de la fianza de la purga por falta de comparecencia en una fianza.
It was 2,000.
Eran $2,000.
Pago 200. 2,000, pero pago 200, ¿verdad?
It's 2,000, but I pay 200, right?
No, 2,000.
Come on, sir.
2,000.
Let him know that he gotta come back in for his
Tiene otro
felony.
caso, tiene que primero hablar con el juez de su caso.
What?
Lo van a volver a traer.
Oh.
Reyes,
You speak English?
No.
¿hay alguna posibilidad?
He needs
Yeah,
Spanish
hold on,
for
I
that.
don't speak Spanish.
He was saying that he's stepfather, and he's asking. if there's a
Excuse me, Your Honor.
possibility
This is Joanne Hennessy. I'm with the city of Miami Beach. I'm just here for the jail arraignment portion of the calendar. I believe the remaining calendar is traffic.
This that has,
I know this is the Miami Beach. She wants to know if it's only traffic left.
Yes.
And then the felonies, right? And the felonies? Oh, she doesn't. Yeah, you can be
Thank you,
dismissed.
Your
Thank
Honor.
so
Good
much.
day.
If you have
Thank
no cases. Thank you. Okay, there's someone in here.
Is there any possibility that you reduce the bond to Héctor David Velázquez, please?
si quiere, me lo puede decir en español.
Sí, que sea alguna posibilidad que le reduzcan la fianza a Héctor David Velázquez.
He wants to know if there's any possibility of you reducing his bond.
No, not at this time.
En este momento no.
Ok, ¿a dónde tenemos que ir a pagar la fianza?
Where do they have to go to pay the bond?
That's not. Yeah, that's not for me.
Puede coger un bond, alguien que puede pagar la fianza de 10%.
En este caso, ¿cuánto sería la fianza?
10% de 2,000.
Ok, pero él tiene otros cargos ahí, entonces.
No, por ahora mismo fue porque él no fue a la corte, entonces el juez de ese caso
Yeah.
le puso un bench
Hey.
warrant. Understood.
Okay, the next case that I have is
Yeah, it's Mario.
Reyes Mario. Are you
El próximo caso que
Mario?
tengo es Mario Reyes. ¿Es usted Mario Reyes?
Correct.
Correct.
Okay, so there's one bench warrant and one new case.
Hay una orden de búsqueda de
You have a
captura en
bench
su
warrant for
contra y
3,500.
un caso nuevo.
And you also have a 150 traffic violation.
Y usted también tiene una infracción de tránsito nueva.
Public defender, do you have any arguments at this time?
Judge, I don't have any probable cause argument. I would just be asking for the monetary amount of the bench warrant to not be issued just because he recently moved. And again, Judge, this is not a willful violation. A failure to file a change of address is not a willful violation. That warrants waiver.
Su señoría, no tengo ningún argumento en relación a la suficiencia de indicios. Solamente pido que no se le ponga la fianza de la purga porque él se acaba de mudar y él no recibió el aviso correspondiente. El que no cambió la dirección no establece que él faltó al tribunal a propósito. Fiscal.
It's time to state request that the 3,500, I believe, bench warrant be converted into a monetary bond.
La fiscalía solicita que el monto de la purga, que tengo entendido son $3,500, se convierta en una fianza monetaria.
So I'm going to grant the bench warrant to monetary bond 3,500. That's for the case ALS 28FE. And now there's another case. It's AN 749LE.
Voy a otorgar lo que me pide la fiscalía en el caso ALS2AFE. El monto de la purga se convierte en una fianza de $3,500. Hay otro caso AN749LE.
And that's 150.
En ese caso, la fianza son 150.
Hold on one second.
Aguarde un momento.
Yes, it's correct.
Sí.
And do you have any arguments, public defender?
Defensora, ¿usted tiene algún argumento?
Okay, so I'm going to convert the bench warrant into monetary bond, 150.
No, en este momento, señora jueza, y entonces convierto el monto de la purga en una fianza monetaria. Y por el otro son
This
150.
is on the case ending in 9LE.
9LE is 150.
Okay, I don't.
Eh, eh,
Case, Judge, I was just clarifying.
It's a big 108.
Entonces, en el caso que termine en 9LE, en ese caso la fianza son $150 y la abogada señala que en aquel caso no hay ninguna orden de búsqueda y captura.
Thank you, sir.
Gracias, caballero.
Okay. Oh, thank you.
The next case I have is David Gill.
Put the bond out, Judge. Now.
Don't write anything. Okay. The next case that I have is Jean Robert Lacourier.
Also bond out.
Okay. The next case that I have is Stephen Vulture.
Oh.
And there's 2 bench warrants.
Yeah, in the box. Yeah.
Good afternoon. Are you Stephen? I can't hear you. I'm sorry.
No, that don't work. You just gotta say it out loud. Just say.
Oh, my old address.
No, she's asking you your name.
Oh, my name's Steve Welch.
Okay. And there's 2 bench warrants for no driver's license for operation of a motor vehicle. That's case number AKTP7GE. Public defender, do you have any arguments?
Just that he moved addresses and did not receive notice of an upper court dates, and therefore this is not a willful violation. I again renew all my arguments from previously that you cannot be willfully in violation of, or you cannot willfully fail to appear for your court date if just because you did not file a change of address. And again, there's case law to back it.
Okay.
Judge, and I don't have his priors in front of me, but these are traffic cases, $3,000. So these are just traffic cases, and I would be asking for the monetary warrant amount not to be applied. This is
Sorry. Anything you're saying. I'm so sorry.
You're good. I was just making the same argument about the change of address. He did not receive notice in the mail. He moved. It's not a willful violation.
Okay.
There's case law to back it.
I believe that's his responsibility to change his address. So I'm
Judge,
going
it's
to.
not the definition of willful under the case law, though. That's
Would you like to
there's
state?
law to back it up. Right?
Yes, Your Honor, it is the defendant's, it is his responsibility to keep his records up to date with the clerk's office, and just because it does not mean that was not willful.
Judge, and the definition of willful means on purpose, meaning that he chose to evade the law. You cannot choose to evade the law if you don't even have your court notices. It does not rise to the level of willfulness that is required to issue the bench warrant. That's the argument that I've been making all morning, and I will continue to renew it, Judge.
Would you like to respond?
Yes, Your Honor.
like, I don't see the. So are you requesting to convert the $3,000 bench warrant into monetary bond? Okay, I'm gonna go ahead and convert for case number AKTP7GE, the bench warrant of $3,000 into a monetary bond. And in case number AL2CC7E, oh, sorry, interpret, wait, he doesn't need interpret. In case number AL2CC7E, I'm gonna convert the bench warrant of $1,500 into a monetary bond. The next case I have is Thompson Rodney. Do you have any prior? I don't. Is there any priors on him? I don't see any.
Rodney.
Thompson Rodney.
You have a withhold possession of 5 or more identification. That is, a withhold for a commercial device use.
Using a communicative device and then fleeing and eluding police officers, which was no action, but that's not to be considered.
Okay, sir, are you Rodney Thompson? Did he say yes? Okay, this is case number AL852EE. You have a bench warrant for operating with a suspended license revoked. Do you have any arguments, public defender?
No, not you. Can you be real quick? 1 second, Judge.
Okay.
Judge, I would just be again arguing that he did not receive notice in the mail because the address that is in the court file is an incorrect address. It's not a willful violation that when he did not appear for his court date because he was not aware of his court date, and therefore he should not be, you should not be converting the monetary bonds into his bond amount.
Your Honor, state request $1,000 bench warrant, case number 5 or AL52 is converted to monetary bond.
Yeah, the court will grant under AL852EE, the 1,500 bench warrant will be converted into a monetary bond. I do believe it's up to the defendant to upload his address, his information. If anything changes, to say you're unaware is not sufficient. So the bench warrant will be converted to 1,500 monetary bond.
And Judge, for the record, it is the defense's position that it's the willfulness language that does not warrant, or like warrant is not the right word. That is not, it should not be given a warrant when there's no willful violation, and failing, even negligence is not enough to give a warrant because it's not willful. So not changing your address is the same thing as negligence, Judge. And again, I renew my argument that there is case law to back it.
Was it at least, Judge, was it 1,000 or 1,500?
It was 1,500, I believe, right? 1,500.
I believe it was
1,000? Let me hold on. 1,500.
You know what I mean? I see on the arrest warrant, it's 1,000.
Oh, hold on, let me see. Maybe I made a mistake. The next few, I do have like fires. The bench warrant here, events, it says 1,500. Do you want to go to 1,000?
Yeah, that was
Oh, sorry.
1,000. Just ask for that.
It's bench warrant from Judge Newman, says 1,500.
For which case? Sorry.
The case number AL 852EE, Thomas Rodney.
And it says fine with the state, here it says 1,000.
Okay, I'll go ahead. The state says 1,000, I'll go ahead to lower to 1,000. Thank you.
Miller, 400.
Public defender, I noted it. I put it to 1,000. Are you Christopher Miller? Public defender, did you note it that I noted it to 1,000?
I heard you. Thank you.
Of course. You're Christopher Miller, correct? Okay. You had a 2 bench warrants. I don't have any. Is there any?
No convictions, Your Honor. There is one cocaine possession, no action from 1987.
So the first bench warrant is for knowingly violation. It's for $100 under case number ALIJCIE. Defense.
Sorry, Judge. What was your question?
I asked if you have any arguments or anything to say for the case number ALIJCIE.
No, Judge.
We would request that the $100 bench warrant amount be converted into a
Granted, the $100 bench. The $100 bench warrant will be converted into monetary bond. And the second case is AN10DPE. And that standard bond on that one is showing 150. Do you have any arguments?
100, 150. No, Judge. No arguments.
State.
150 is fine.
Okay, I'm going to go ahead and convert the bench warrant of 150 into monetary bond. So the case ending in CIE, the first one will be $100, and the second case, DPE, will be 150. Thank you. The next case I have is Eddie James Luker. And I don't know if there's, I don't know if there's any, are there any priors? I don't see nothing printed here.
Your Honor, a withhold of adjudication on a grand theft or degree of vehicle, withhold on a battery, and withhold a July.
We're not sure. Okay. They should have all, but I don't know why these are missing.
So what was this?
These were brought up on bench warrant, so that's probably why.
Most recent, Your Honor.
You're the judge or the state?
2013.
You're Eddie James, correct?
Yes.
Okay. And so you have a suspended, indefinite, failed to pay traffic. You have a bench warrant for $1,000. Do you have any arguments, public defender?
Judge, I would just be asking that instead of $1,000, it would just be standard bonds.
Eight.
Our request is the same. You're requesting that the bench warrant be converted.
So the bench, I agree, the bench warrant of $1,000 will be converted to standard bond. Thank you. Okay, the next case I have is Lazaro Carlos. Are you Lazaro? Are you Lazaro?
He needs a Spanish interpreter.
Usted es Lázaro.
Sí.
Yes. My name is Lázaro.
This is case ANECTUE. And there is a bench warrant for reckless driving. Again, on this one, I don't have if there are any priors.
Este es el caso ANCTUE. Es un cargo de conducir de forma temeraria.
No.
Sí.
Yes.
And the standard bond is showing 150.
That's correct.
La fianza estándar son 150, correcto.
Sí.
Yes.
Do you have any arguments, public defender?
Yes, Judge, it seems that this for this reckless driving charge, there's just conclusory statements. The listed vehicles, the defendant driving displayed a wanton disregard for the safety of himself and other motorists. The defendant willfully drove in an unsafe manner, almost causing multiple traffic accidents. Judge, there's no specific allegations as to what conduct led to the accidents or what was reckless about it. These are conclusory statements that are not enough to warrant probable cause in the arrest form. The officer needs to state specific facts as to how he was driving recklessly.
Defensora pública, ¿usted desea hacer algún alegato en relación a la suficiencia de indicios? Sí, su señoría. Aquí el formulario juramentado del arresto contiene una serie de conclusiones y no alega nada específico. Dice que el acusado estaba conduciendo de forma insegura y que causó el accidente y que no estuvo debidamente atento a la seguridad de él ni las otras personas. El policía no alega nada específico que sustente la determinación de suficiencia de indicios. ¿Qué tal?
Here in the arrest form, it says that the defendant had the vehicle rear with louvers attached, blocking all rear visibility.
State, we can't hear you. We can't hear the state, Judge.
Can you hear me?
Yes, better, thank you.
Rear window had a louver attached, which was blocking all rear visibility. The vehicle was not mobile. Eastern northbound lane, the 12th Avenue, was moving very slowly. The officer observed the vehicle commit an improper start, and as it went to the left without using the turn signal, causing traffic to abruptly stop to avoid a collision. That same vehicle then sped up and another vehicle had to abruptly stop due to traveling too close to the vehicle. So for those reasons, we believe that a charge was driving.
Judge, failing to use a stop is not reckless driving, or sorry, failing to use a turn signal does not warrant.
I think the interpreter needs to interpret.
Oh, I'm sorry, Judge. Sorry, interpreter.
La fiscal alega que en el formulario del arresto se indica que usted dobló a la izquierda sin usar el indicador, la señal de cambiar de senda, y que eso causó que otros vehículos tuvieron que detenerse abruptamente.
What are you requesting?
So I was just responding to the state's argument, Judge. You failing to use a turn signal does not amount to reckless driving. And I hear the state, but it's like kind of muffled, and I'm missing some parts of the argument. I heard something about a window. I'm not sure how to address it just because I couldn't make out exactly what the state said. I really only heard about the turn signal, which is what I see from the A form. I believe that the officer is basing the charge of reckless driving on. And again, Judge, failing to use a turn signal, it does not amount to reckless driving.
Señoría, el no usar el indicador de cambio de dirección, esto no constituye conducir de manera temeraria, y hubo partes de la presentación de la fiscalía que no pude escuchar. Hubo algo que se dijo de una ventana trasera, pero no pude escuchar eso claramente porque estaba el ruido, la voz algo en sordina que no se escuchaba. Y nuevamente le repito que el no usar el indicador al cambiar de dirección, que eso no constituye conducir de forma temeraria.
Your Honor, contained within the form is much more beyond simply a relative blinker. As on two here, the vehicle, the officer observed the vehicle as emerging lane without using a turn signal, which caused traffic to abruptly stop to avoid a collision. I'm now in the next paragraph. The listed vehicle sped up north. The vehicle had to abruptly stop due to him traveling too close to the vehicle in front of him. These two paragraphs alone, the defendant was driving in a way that disregarded the safety of others around him. I feel like PC exists here clearly.
Yes, yes.
Judge, I couldn't really hear the state's argument, but I'll rely on what the judge says back, just because I don't think we're gonna solve the audio.
There's enough PC for reckless driving. You're gonna convert the. Wait, this is a bench warrant. Standard bond 150. Traffic.
Tengo entendido que la jueza determina que hay suficiente fundamento para el cargo y que en relación a la orden de búsqueda de capturas, esto se va a transformar en una fianza.
This is standard bond. I guess it's a new case. Okay. So what's the standard? What is the standard bond?
150.
Okay. So I'm gonna do 150 standard bond on case number ANECTUE. I find that there's enough PC for reckless driving.
En el caso ANESTE, determino que hay suficientes indicios de criminalidad y impongo una fianza de $150.
The next case I have is Daryl Thompson. Thank you so much.
Your Honor, this is interpreter for the record. Interpreter is also having difficulty hearing the state.
Okay, I'll have her speak up a little bit louder.
Okay, Mr. Thompson, just give me 1 second.
Are you Mr. Daryl Thompson?
Yes.
Okay. This is for operating with a suspended revoked license. It's case ANECUNE. I don't have his. Actually, I do have it. His price. Do you have any argument, public defender?
1 second, Judge.
There's a
2628.
I believe there's a case on this.
Okay, I give it some more.
Which one? That's a 2,500.
Judge, I would just be asking for a dollar bond.
What you gonna do? What you mean, y'all?
Date?
What you mean, y'all? Like,
State will be requesting felony hold in this case due to the open felony for first degree grand theft set for arraignment on the 27th, Your Honor.
And monetary bond, traffic case 150.
Yeah, so I'll grant the monetary bond for the traffic 150 and the felony hold, which can be heard when again?
The 22nd of this month.
Which would be April 22nd.
It's not, it's a related felony, Judge. He should be back later today to address that. Shouldn't be a hold.
There's an arrest warrant on that same felony, but we're also requesting a hold so that he be brought in front of the division judge.
Yeah.
I'm sorry, Judge, I cannot hear the state.
We are requesting a felony hold so that he can be brought in front of the division judge to determine his bond. There's also an arrest warrant in that same case.
a dollar hold.
That would be addressed with the felony calendar.
Felony hold for which one? Wait, that's the state.
Yeah, right, so he doesn't need a felony hold according to instructions.
We can address the felony hold at a later time.
Yeah,
150 for traffic.
150 converted for the traffic, and we'll address the felony hold.
Okay, so it's just 150.
Yes.
Thank you, Judge.
Welcome. The next case I have is Joseph Frank Wright. Good afternoon. Are you Mr. Joseph Frank Wright?
Yes.
Okay. These are two, the first case is AND5GIE, and this is normally violation. I'm gonna move the rest. There's no rest. There's no rest for this one. I see what you're, okay.
Yeah. Thank you.
Okay, so this is case number AND5GIE. Joseph Frank.
Okay, that's him, Joseph, right?
You're Joseph Frank, correct?
It's just Frank, right? Yes.
Yes.
Okay, state.
The state's requesting standard bond for case ND5GIE of 150. And in the other case, AND5GSE, reckless driving, 150.
Okay. So I will, the first case AND5GIE, standard bond of 150. And in the second case, AND5GFE, standard bond of 150 as well, as I find probable cause in both of them. So it's 150. I found probable cause in both. The next case I have is Mario Perez.
He needs a Spanish interpreter, Judge.
Okay. Can you confirm that is
¿Es usted Mario Pérez? ¿Es usted Mario Pérez?
Sí.
Yes.
Your Honor, I have a question says the defendant has an immigration.
Señoría, el acusado es objeto de una solicitud de retención por parte de las autoridades migratorias.
Okay.
Okay.
okay, so there's an ICE hold. Okay.
I'd be asking for a
Ahí
dollar.
pide que se le retenga.
¿Cómo?
What?
Okay, so there's an ICE hold, there's one bench warrant, and then there's one violation of probation. I'm gonna first start off with the bench warrant. That's for 5,000, and that's case number A939NIE. And it's currently set for 5,000, and there's also an ICE hold. Do you have any arguments, public defender?
Bueno, en este momento hay una solicitud de retención por parte de las autoridades migratorias, hay una orden de búsqueda y captura expedida por un juez y hay una infracción y cumplimiento de probatoria. El caso de la falta de comparecencia ante el tribunal, la purga son $5,000. Abogada de la defensa, ¿usted tiene algún alegato?
Judge, I would just be asking for standard bond in these cases. It's a $7,500 bond on 2 misdemeanors, Judge. I think that's excessive. One of them is a no driver's license charge. I haven't had the opportunity to speak to him about his failure to appear, but if you give me a second, I will.
And I just want to correct for the record that it's the traffic citation is A939NIE. No, 1E, sorry.
Su señoría, yo le pido que usted determine que el monto de $7,500 sería excesivo. Estos son delitos leves, un caso de no tener una licencia válida. No sé exactamente por qué no compareció, pero si usted me da un momento, yo lo consulto con él para determinarlo. La jueza entonces aclara que hay el caso pendiente por la falta de comparecencia, es el A93 9A y E o 1E.
Judge, Mr. Perez was experiencing homelessness when he picked up these bench warrants, so he did not have notice of his court dates. And so I believe that a $7,500 bond, when these failures to appear were not willful, is excessive. I would just be asking for standard bond if you're not willing to grant my request for a dollar bond on these cases.
Señoría, el señor Pérez en este momento está sin hogar y por tanto yo le pido que usted determine que él no faltó al tribunal intencionalmente. En todo caso, la fianza de $7,500 sería excesiva. Yo le pido que le imponga una fianza estándar si no está de acuerdo con ponerle la fianza que yo le pido, que es $1.
So in case number A939N1E, I'm going to go ahead and convert the bench warrant, that's $5,000, into a monetary bond. And for the violation of probation, which is case number 0426XEB, that's 7,500.
Yes, Your Honor.
Okay, I'm going to convert the 7,500 into a monetary bond.
Entonces, en el caso de la falta de comparecencia que termina en 1E, en ese caso voy a voy a convertir el monto de la purga, que son $5,000, en una fianza de $5,000. En el caso que tiene que ver con el incumplimiento con la probatoria, que es el 0426XEB, en ese caso hay una purga de $7,500. Eso lo voy a convertir en una fianza en ese mismo monto.
And I'd also like to know for the record that there's a ICE hold.
Y también quiero que conste en el acta que hay una solicitud de retención por parte de las autoridades migratorias.
And the next, there's one more case I have. Wait, you guys have one more case?
Yes.
Israel Hayden.
Yeah. It's a bench warrant. Good afternoon. Are you Israel Hayden? I can't hear. I'm sorry at all.
Hello, good morning, Judge. How you doing?
Good afternoon. Oh, good. How are you? Are you Israel Hayden?
Yes, I am.
Okay, and this is case number AJP81UE. There's a bench warrant for $3,500. Public defender?
Hello.
Hold on, somebody? Who's Pauline?
Our sister, he went to court for that already, and the judge supposed to remove the bench warrant off of him. He had court on the 16th.
I did Zoom on Thursday.
And who are you related to?
I'm
the
his
defendant?
sister, Pauline Hayden. I'm his sister.
The sister said, you had court on when? The 16th?
We're checking to see if the warrant was washed.
Okay, we're checking right now the record, the status.
Yeah, I did Zoom.
You're here for Israel Hayden, correct?
Yes, ma'am.
Okay, hold on one second. The status checking.
It was Priscilla. No, I ain't doing.
Ma'am, can you repeat for the court that you were saying that on the 16th? Yeah, can you just repeat what you were saying? So
Yes.
the state can check.
Yes. Me and my brother was on the phone together. They scheduled his court date, the 16th at 1:45 on Zoom. If they said if he couldn't come in person, he could do it on Zoom. And we both did it he did it completely. And that was it. But the judge forgot to take the warrant off of him. But they arrested him with the same bench warrant and when he already went to court for, Your Honor. He went to court on the 16th at 1:45 on Zoom.
Judge, I can confirm that Mr. Hayden was present before Judge Alvarez-Zane, for 16 days ago, which was Thursday. I'm not entirely sure why the bench warrant was not lifted at that point, but he was present according to his assigned public defender. He was present over Zoom.
Your Honor, just to provide a little bit of clarity, it is true that there was a motion filed to set aside the bench warrant. However, there was no ruling made.
Okay, Judge, then I'd be asking for the bench warrant to be set aside. He changed his address on his license. He was getting notice incorrectly at the wrong address, and he appeared for court on Thursday. He should not be in custody right now.
So the reason that the state is telling me why he got picked up is because the judge hadn't ruled yet. Is that correct? The judge has not ruled, so that's why he did get picked up on the bench warrant. If I'm mistaken, please correct me.
No, that's correct.
Judge, but he appeared in order to get the bench warrant set aside. And I understand that the judge might not have made a ruling, but.
So it was a motion to set aside the bench warrant. There was no ruling on it. So at this time, I'm going to convert the 3,500 into monetary.
Judge, he was present before the court 2 days ago. He's not failing to appear. He appeared before Alvarez-Zane 2 days ago.
Well, there was a warrant that was made on Wednesday, but prior to for failure to appear.
Okay,
and there was a motion Wednesday. She didn't rule on it. So the warrant is still active.
So the state wants him to stay in custody for a $3,500 bond when he was in court 2 days ago. I'm just confused as to what the state's position is right now.
It's not the state wants him in custody. That's what the judge ruled.
Okay, this judge is not required to impose the monetary amount that's on the warrant, though, Judge. You can ROR him right now. He appeared before the court 2 days ago.
No, I'm not gonna RR him at this time. The judge did not make a ruling. If the judge had made a ruling, but unfortunately the judge did not make a ruling on case AJP81UE. So I'm going to hold him with the bench warrant converting into the monetary 3,500. And when he's in front of that division judge, they can discuss it then. But I'm sorry, but the judge did not make a ruling on that.
Excuse me, can I say something?
Judge, and just to be clear, if the judge did not make a ruling on the motion to set aside, it's likely a clerk error because he was present before the court. And I have a note here from his assigned public defender in his file from our system. Client was present before the court. Confirmed address at his new updated address, file change of address. Judge, he was there. Why the bench warrant wasn't set aside, I'm unsure. It could be a clerk error, it could be oversight, but he's in custody right now on this when he was present before the court 2 days ago, and now he's going to be held on a $3,500 bond. I just don't understand what his recourse is if he appeared to avoid this situation 2 days ago. Are we holding people in custody when they trying to fix their warrants now?
It's the state's position that because he failed to appear earlier, and then a motion was filed to quash that warrant, and the judge decided that there was no ruling to be made at that time, that the bench warrant is still active.
She would have denied it if she found that it should be denied. She made no ruling. It's likely a mistake.
If it was denied, she would have stated it was denied.
That's what I'm saying. That's exactly my position, that if she would have wanted to deny it, she would have denied it. There is no ruling, which means that she likely made a mistake in not entering a ruling. We do this all the time in county court.
I just had the clerk double check. The clerk, right? There was no ruling made.
Judge, exactly. If she wanted to deny it, she could have denied it.
The clerk that was just here. Yeah, you can take that up with division judge, but the clerk that was just here informed me.
He did on Thursday. That's what he was trying to take it up with the division judge that he's assigned to on Thursday when he appeared for court. And now he's going to sit in custody on a $3,500 bond when he appeared in court 2 days ago.
You do it right. Do it right, baby.
Judge, he appeared in court 2 days ago for this.
Exactly, even corrections have a no, like this was,
Correction says he appeared, but there was no ruling from the judge. That's correct. If there was a ruling, she denied, so at this time, there was no ruling from the judge, the clerk confirmed, and the state confirmed there's no ruling.
And just to be clear, like Judge, you can RR, and the state can stipulate to doing so. But their position is that he should remain in custody on a $3,500 bond when his colleagues saw him in court today. Just to be clear.
Yeah, I've already made a ruling. I'm not gonna argue him. And the state does not stipulate to that at this time. Thank you.
That's messed up. That's a lawsuit too.
Your Honor, are the felony hearings next?
This profiling my brother, racist.
Recording stopped.
Your Honor, I'm sorry, the public defender, could you, I know your mic is off, but can you tell me what time is felony if you're able to? Or the state, if possible?
The judge is on a restroom break, I believe. There's no clear timeline, but it should be soon.
Okay, thank you so much.
Recording in progress.
All rise and raise your right hand.
Pónganse de pie, levanten sus manos derechas.
May you all please rise and raise your right hand to be sworn in.
Ustedes todos podrían ponerse de pie, levantar sus manos derechas para prestar juramento.
Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? If so, say I do.
Juran que el testimonio que presentarán será la verdad, toda la verdad y solamente la verdad. Si es así, contesten que sí.
You may be seated.
Pueden tomar asiento.
So, good afternoon. We're gonna take a case out of turn because the family is present. The name is Hector David Vasquez Garcia.
Judge, may I ask what number on the calendar that is?
Number 24 on page 8.
Good afternoon, sir. Are you Hector Vasquez Garcia?
Muy buenas tardes, caballero. ¿Es usted Héctor Vázquez García?
Sí.
Yes.
Okay. You have been charged with 4 counts. The first count is controlled substance possession. Second one is another controlled substance, psychotic mushrooms. The third is cannabis possession, 20 grams. And the fourth is drug paraphernalia with the intent to use.
A usted se le imputan 4 cargos, caballero. El primero es posesión de una sustancia controlada. El segundo es otra posesión de sustancia controlada, hongos psicotrópicos. El tercero es posesión de una sustancia controlada, cannabis 20 gramos. Y el cuarto es posesión de adminículos para usar drogas con intento de usarlo.
I'm going to go ahead and read the A form to determine if there's probable cause for each of the 4 counts.
Voy a leer el formulario juramentado de su arresto para ver si cada cargo está sustentado por suficientes indicios de criminalidad.
Public defender, do you have any PC arguments at this time?
Judge,
Abogado de
Assistant
oficio,
Defender Jacob Cope. I
¿usted
apologize.
desea hacer algún alegato en relación a la suficiencia de indicios?
This is Assistant Public Defender Jacob Kovas on behalf of the defense judge.
Hi, good afternoon.
Good afternoon. We do not have any probable cause arguments at this time, Judge. We would be asking for Mr. Velasquez Garcia to be released on pretrial services for this case.
Usted, el abogado de la Defensoría Pública, Jacob Kovitz, a nombre del acusado. Un gusto, contesta la jueza. En este momento, su señoría, no tenemos ningún alegato en relación a la suficiencia de indicios. Pedimos que se le permita salir al acusado a cargo de servicios previos a juicio.
I talked to pretrial service, the bench warrant disqualifies him.
En relación a los servicios previos a juicio, tengo entendido que en la orden de búsqueda y captura que se ha emitido lo descalifica.
Yes, Judge. In which case we would ask for the court to go below standard bond, being that he does have a bench warrant, and being that there are multiple charges in this case. It's defense's position that standard bond with all these charges would be tantamount to no bond and would create an issue with Mr. Velasquez Garcia being able to pay in this case, Judge.
I will not,
Uh,
I will not go
en,
below any, the standard bond. I want to hear from the state.
en este caso, su señoría, pedimos que el tribunal se desvíe y imponga una fianza por debajo de la fianza estándar. El imponerle la fianza estándar sería equivalente a retenerlo sin poder pagar fianza. La jueza indica que ella no está dispuesta a ir por debajo de la fianza estándar.
The state's request on count one for possession of a controlled substance is $2,500. State's request on count two for possession of a controlled substance is $2,500. State's request count three of possession of cannabis is $500, and state's request for count four possession with intent to use drug paraphernalia is $500.
La fiscalía pide que en relación al primer cargo, posesión de una sustancia controlada, se le ponga una fianza de $2,500, que en el segundo cargo, posesión de una sustancia controlada, se le imponga una fianza de $2,500. En relación al tercer cargo, posesión de cannabis, que se le ponga una fianza de $500, y que en el cuarto cargo, posesión de adminículos para usar drogas, se le ponga una fianza de $500.
As to count five, the state's request is $150 for consuming an alcoholic beverage.
En relación al quinto cargo, la fiscalía pide que se le ponga una fianza de $150 por consumir una bebida alcohólica.
And for count six, entering a park after hours, the state's requested $150 bond.
Y en relación al sexto cargo, que es ingresar a un parque después de las horas de cierre, la fiscalía pide la fianza estándar, $150.
The victims are here and do wish to, or not the victims, I apologize, the parents are here and wish to refer.
Además de esto, su señoría, los padres de él desean que se les escuche a ellos.
Okay, they keep it here. I'm gonna swear them in.
Judge, I'm sorry, I can't hear what the court is
I'm gonna,
saying.
so the parents are here and want to be heard, so I'm asking the clerk to swear them in.
Do you swear?
Los padres de él se encuentran aquí. Le estoy pidiendo al secretario auxiliar que presten juramento.
Yeah. My name is Hector Arias. I am the father from Dr. David.
Me llamo Héctor Arias, soy el padrastro de David.
Él recuesta you download de bond, que se puede reducir la fianza, por favor.
I request that you to consider lowering the bond.
Is there anything else you would like to?
Es eso por
add
ahora,
at this
por
time?
favor, gracias.
¿Hay algo más que desea
Por
decir,
ahora,
caballero?
gracias.
At this
Judge,
moment, that's all.
if I may address the court regarding the bond again.
Señora, si me puedo dirigir a usted en relación a la fianza otra vez.
Judge, I understand the state's request for a standard bond and the two controlled substances counts. However, for the misdemeanor bonds that are the misdemeanor cases that are attached here, we would ask the court to go below the standard bond, being that charge count 3 is cannabis possession, which the state attorney's office has a memo from a few years ago stating they do not go forward on these cases. We'd be asking for a $1 bond in that case or in that count. Furthermore, the drug paraphernalia charge in this case, Judge, the allegation of the drug paraphernalia in this case is cannabis related, which again, the state of Florida has said in the past that they're not going forward on those cases. We would ask for a $1 bond in that case. Judge, as for the drinking alcohol in public count, we would ask for, again, a $1 bond. Typically, I know it's not legal precedent, but from my experience, Judge, these cases, if they are standalone, get dismissed at jail arraignment typically.
Excuse me, counsel, this is interpreter speaking. Su señoría, en relación a los dos cargos primeros que tiene que ver con posesión de una sustancia controlada, yo comprendo que el tribunal imponga la fianza estándar. Sin embargo, en relación a los delitos leves que le siguen, le pido que se desvíe de la fianza estándar. El tercer cargo, que es posesión de cannabis, hay un memorándum que se emitió hace varios años en los cuales el Estado indica que no van a seguir adelante en relación a aquellos casos. En ese cargo le pido una fianza de $1. El cuarto cargo tiene que ver con adminículos para usar drogas. Eso también está vinculado al cannabis. Por tanto, en relación a aquel cargo le pido que se le ponga una fianza de $1 en relación al cargo que tiene que ver con el beber alcohol. En mi experiencia, su señoría, la fiscalía nunca o muy a menudo no sigue adelante con aquellos casos. Por tanto, en relación a aquel cargo, le pido que le imponga una fianza de $1.
Your Honor, that's true. It is in your discretion to deviate from the standard bond. However, this, agrees with its position requesting standard bond on each.
Okay.
Su señoría, todo esto es cierto. Usted tiene arbitrio para desviarse de la fianza estándar, pero la fiscalía le pide que ponga la fianza estándar.
Okay, so the court finds probable cause on count one. It's gonna issue the standard bond of 2,500. The court finds probable cause on count two. Will issue the standard bond of 2,500. The court finds probable cause on count three. And will issue the standard bond of 500. Court finds probable cause on count four. Will issue the standard bond of 500. Count five. Standard bond 150 probable cause, and count six probable cause for 150. So the total amount is 6,300. And the court finds probable cause on all 6 counts.
Bueno, el tribunal estima que hay suficientes indicios de criminal en relación al primer cargo. La fianza son $2,500. En relación al segundo cargo, el tribunal estima que hay suficientes indicios. La fianza son $2,500. En relación al tercer cargo, el tribunal estima que hay suficientes indicios. La fianza son $500. En relación al cargo número 4, hay suficientes indicios. Y la fianza son $500. En relación al quinto cargo, hay suficientes indicios. El tribunal impone una fianza de $150. Y en relación al cargo número 6, la fianza son $150. El monto total de todas las fianzas son $6,300.
And Judge, is that all for Mr. Velazquez Garcia?
Señor, esto es todo en relación al señor Velázquez García.
Yes.
Sí.
Now going back in order, the next case that I have is Adam Sky.
This guy, come here and stand right.
Yes. I'm sorry? Ma'am, are you Adam Sky?
Yes, Judge, she's present before the court with me.
Did the court correct? Okay.
I'm sorry, Judge, can you hear the corrections officers?
No, I cannot.
I believe they're trying to address the court.
Oh, hold on, I believe. Is there an attorney, Erna Luna, present?
I'm sorry, Judge?
There's an attorney raising their hand. Luna.
Your Honor, we're here on, I'm not sure. We're both here on behalf of Mr. David Rivera.
Oh, that case has not been called yet. We just started.
Okay, thank you, Your Honor.
What was correction saying? I'm sorry, I couldn't hear.
Yes, Judge. Can you hear correction or not anymore or no?
Can you hear us now, Judge?
Judge, I believe they were trying to advise you that Miss Sky was on house arrest when at the time she was arrested for another case.
Okay.
I'm sorry, Judge, can you?
Yeah, they just told me. So there's two counts here: aggravated assault, deadly weapon, and count 2 is battery attempt.
Oh, you are told it? Yeah. Okay.
Okay, here, Mama.
We're trying to figure out the communication so you can hear us better.
So what I'm gonna do is.
Can you guys hear me? Wait, this is for number 10, right? Oh. Okay, so I'm gonna proceed with the first count is aggravated assault with a deadly weapon and a battery attempt.
Yes,
Yeah, there's
Judge.
2 counts. Thank you. There's 2 counts, aggravated assault with a deadly weapon and 1 count of battery.
Yes, Judge, and we do have probable cause argument as to one of those counts of aggravated assault with a deadly weapon. I'm not sure.
Okay,
if
let me read the arrest affidavits for PC. What are your go ahead with your probable cause argument.
Judge, the probable cause argument would be that in this case, according to the arrest affidavit, it's alleged that there's one instance of knife being drawn on the alleged victims in this case, Judge. It's the defense's position that only one accusation of aggravated assault with a deadly weapon should be charged. Even though there are 2 alleged victims in this case, the incident comes from the same set of facts from the same time. And I believe it would be. Judge, I'm sorry. I think corrections is also trying to address you. Are you able to hear them? No. I'm going to inform them. The judge, but essentially the defense's argument boils down to this should be charged as 1 count of aggravated assault with a deadly weapon, not 2, based off the fact that they come from the same time, the same incident, even though there are 2 alleged victims in this case from that same time.
Your Honor, this would be with the assistant public defender. However, we would request PC on 1 count of attempt aggravated assault with a deadly weapon, and then a 2nd count for attempted aggravated assault. Just 1 without the weapon.
What happens is all good.
Yeah, Judge, I believe corrections is here to address the court regarding this case.
Judge, I just want to let you know that the defendant was out on house arrest and she picked up this charge. So the case that she was out on house arrest on, you have to place a hold.
Okay, so we're gonna. Okay, so I'm gonna go ahead and address. I'm gonna find probable cause for aggravated assault with a deadly weapon for 1 count.
I'm sorry, Judge, I can't hear.
Okay, I'm gonna find probable cause for aggravated assault with a deadly weapon for 1 count. And then I'm gonna.
And then the state is requesting for count 2 for attempted aggravated assault
Without a deadly weapon.
Correct.
And then count 2, we'll go ahead aggravated assault without a deadly weapon. And then I find probable cause for battery.
It's
gotta listen to your
for attempted battery.
Yeah.
I did not do
Ma'am, I can't hear the judge right now, and it's gonna affect how our notes are. I know you're frustrated. I just need you to calm down. I'm sorry, Judge. Did you set a bond on those cases?
Yeah, I have not sent a bond yet, and I wanted to let you know that there's a hold in front of Division Judge Gamas in the felony hold for F25-19158.
Yes, Judge.
So she,
I apologize. Say what else I'm missing your hold for the case M2516675D. So that bond can be readdressed.
okay. So let me go ahead and address the state areas for count 1, the aggravated assault with a deadly weapon, $5,000.
Yes, sir.
I'm sorry, Judge. Did you say 1,000?
No, 5,000.
Judge, if I can, I understand the court and the state's position. However, being that there are other holds on this case, we would ask for a $1 bond. I understand that the court is going based off the arrest affidavit. However, based off my conversations with Ms. Sky, I believe that there is a viable standard ground defense of this case.
Yeah, can you bring her back? Because there's like stay away orders. I need to address her.
Judge, I'm sorry, which case did you place the hold on that she was on house arrest?
Yeah, but I have to let her know about the stay away orders and she has to confirm.
I'm sorry?
I need to let her know about the stay away orders, so if you can bring her back.
Judge, she's back in the courtroom. I believe that she was just outside so that we could hear her.
Okay, no problem. So I'm gonna go 5,000 for count one with aggravated assault with a deadly weapon, $5,000. Count two would be aggravated assault without a deadly weapon. And what's this? General bond without a deadly weapon.
Judge, I believe it's
2,500 without a deadly weapon. And then the battery standard is 1,000.
Judge, this is attempted battery. The standard would be 250.
Sorry, that's. I was reading a separate charge. It is.
I was reading another charge. Okay, so then attempted battery 250. And I also would like, it's gonna be 2 stay away orders. Ma'am, you have to listen to this. The defendant is prohibited from having any contact with the following named person, the victim. S. B. Date of birth is 12/31/2008. I'm not saying the name on the record because it's a minor. Do you know who that is? Do you know who that is?
Don't talk about. She's just asking if you know who that is. I'm sorry, Judge. Can you repeat the?
The initials are SP. The date of birth is 12/31/2008.
Can you hear what she's saying? You know us. Okay. Judge, I apologize. Ms. Guy has represented me that she doesn't know any of the individuals involved in this case.
The state.
He said that the defendant does not know any of these individuals involved in the case.
That's based off the representations to me by Ms. Guy.
Your Honor, of the state, that's their full name.
Sensitive advice.
Okay, I didn't know if it was a minor. Okay, so.
Judge, I believe you just need to advise on the initials. It wouldn't need to be the full name.
Correct. Okay, so I'm gonna go with the 2 individuals. Do you guys have a phone?
We do. Both are minor.
Yeah, the minor. That's why I did the initials.
It's Stevion
Stevion Butler. Okay, instead of the initials, it's Stevion Butler. Do you know who Stevion Butler is?
Judge.
Okay, well, either way, over her objection, she doesn't know him. There's a stay away order. You're prohibited from any contact with the victim, directly or indirectly, in person, in writing, by telephone, or fax, or through third person. You're going to stay 500 feet from the defendant. Sorry. Defendant must stay 500 feet away from the victim's home, place of employment, or school at all times. Do you understand this, ma'am?
I'm sorry.
Okay.
Judge, I apologize.
Your Honor, apologies. Did you call it the second victim as well?
No, I was trying to do that.
Yeah, she was escorted out.
Yeah, I think she took it.
Judge, I apologize. We might need a second.
Nope.
Nothing like legal since this morning.
It was all this morning. There's one more stay away order I'd like to address.
I believe we're trying to get her back. Judge, corrections cannot get her back in the room.
Judge, the defendant is too irate right now. They're gonna have to advise her when she goes to division.
Okay. She's gonna be held for division. Prince Davis, and the same rules apply directly, indirectly, in person, in writing. Cannot have any contact. Defendant must stay 500 feet away from the victim's place of employment. And she's staying in on a felony hold, but to address the bonds, it's gonna be count 1, 5,000, count 2, 2,500, and count 3, 250, and probable cause was fine on all of them.
Judge, this is corrections. I just want to clarify the hold that you're placing on her is M25 13675D. That's the case she was on house arrest for that needs the hold placed on.
I thought I'd hold on to that 51958.
25 19158 was RR on 121. She needs the whole place on that misdemeanor battery because that's the case she was out on house arrest for.
Okay. Okay. There's a hold. There's a hold. There's a hold. She violated house arrest. Okay, the next case. I have is Wanda Rivera.
Rivera. Come on, Rivera. Let's do this. You want to do it in English?
Okay. And Judge, Ms. Rivera will need the assistance of a Spanish interpreter.
Interpreter present.
And Judge, just for the record, the public defender accepts appointment on all cases that.
Su señoría, que consta en el acta que en todos los casos los abogados de oficio aceptan nombramiento.
Okay, thank you for accepting on all cases unless an attorney appears.
Gracias.
So I just want to confirm you're Rivera Wanda.
Quiero confirmar, señora, ¿es usted Wanda Rivera?
Sí.
Yes.
Okay, you've been charged with hired vehicle fail to redeliver. I'm going to go ahead and read your arrest affidavit to determine if there's probable cause.
Estoy confirmando, se le acusa a usted de no devolver con agravantes. Voy a leer su declaración, la declaración jurada de su arresto para ver si contiene suficientes indicios.
Judge, the defendant is out on felony bond.
Señoría, la acusada se encuentra bajo libertad condicional en un caso por un delito grave.
Okay, there's a felony hold for case number F25-217.
Hay una retención en su contra en el caso F25-217-59D.
And that is in front of Judge Brinkley.
Eso se encuentra ante la jueza Brinkley.
So there'll be a hold now.
Por tanto, se le retendrá.
Judge, I just want to confirm because I do see there are 2 Wanda Riveras on the calendar today. And I believe it's the other Wanda Rivera that has the open felony case.
You're right.
Señoría, quiero confirmar porque veo que en el día de hoy hay 2 Wanda Riveras nombradas. Yo pienso que es la otra Wanda Rivera la que tiene el caso por delito grave.
Judge, pass that defendant. Go to the next defendant, please.
I'm going to pass that
Entonces, señoría, por favor, postergue esta audiencia, pase a la próxima acusada o acusado.
But it's the same one. Is that, are we passing that?
Yeah, the one I bonded out. No, that was.
What about Wanda Yvette Rivera?
That was her 2 bonds.
This is the defendant that does not have the open felony.
This is the mother that.
Yes.
Number 3. Number 3 is here. Number 3 is here. Judge, I think number 2, Miss Wanda Rivera might not be in the unit right now. We might need to pass this case.
Okay, I'll go ahead and pass it.
Yes.
The next one I have.
We do have number 3, Wanda Rivera.
No.
Oh, no.
She's a bond out. We're gonna move to Miss Reed. Reed.
Okay, I apologize. Judge.
Sorry about that.
No worries.
Number 3 is the bond out. Yes, we're going to number 4. This is Miss Reed. And the boss.
The Don.
Wait, which one is that?
That's the.
Wow, this is very different than misdemeanors. Okay, so this is bond out? So the next case that I have is Toya Reed.
Yes, Judge. Miss Reed is here with me.
Do you need a Spanish
No,
interpreter, ma'am?
Judge, she speaks English.
Okay. You're here with tampering, witness, victim, and robbery by sudden snatching. I'm gonna go ahead and read the arrest affidavit to see if there's any probable cause. And public defender, please let me know if you have any probable cause arguments.
Judge, probable cause arguments at this time.
And I also have a stay away order. Let me go ahead and read the arrest affidavit, please.
We may have a stay away order from the child. I mean, for the big. Yeah, yeah.
And Judge, may I ask if Miss Reed's mother is present on Zoom, if the alleged victim in this case is present on Zoom?
Is the alleged victim for Reed present on Zoom? What's her first name?
I don't have the first name, Judge. I just have it listed here as Miss Labella. I just wanted to know if there was any opportunity instead of a stay away order to have a no harmful contact order, being that that Miss Reed and the alleged victim are daughter and mother.
No, unless the victim's here, I will not modify the stay away
Yes, Judge.
order unless at all.
Yes.
So Dave, anything for count one?
Yes, Your Honor, the state's request would be $2,500 bond for count one, count two, $5,000 bond.
Judge, we would request below standard bond. I know that what the court's position earlier on this was. However, Miss Reed has no priors. She does have, the only thing that she has on her record is a 2019 withhold for a controlled substances charge, Judge. Miss Reed lives in Homestead. She's a resident of Miami-Dade County. She's been here. She's not a flight risk to this court, and she's not a risk to the community despite the allegations in this case, Judge.
Against the defense objection, I find probable cause, count one, 2,500. Count two, I find probable cause, 5,000. And I'm gonna go ahead, ma'am, state, I'm gonna go ahead, there's gonna be a stay away order for the victim, Catherine Lab. Okay. I'm gonna read this to you. You cannot engage in any criminal activity, do not use or possess any illegal drugs. Do not use, purchase, possess, or carry any firearms. You must immediately surrender any firearms you have to the police department. The defendant is prohibited from having any direct, indirect contact with the victim in writing, by telephone, through social media, or through third persons. The defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Understand that, ma'am?
Yes, but that's my mother.
I'm not finished yet. They do not.
And Judge, is Miss Reed ready to be taken out, or is there anything for?
She needs to set the bond.
Yes, she said 2,500 on count one, 5,000.
Okay, come on, yes. Go all the way up and you have a step.
And she does not reside with the victim.
I'm sorry, Judge.
She
Judge, she does reside with the victim.
Okay, you need to bring her back, please.
Yes.
So the defendant may return to the victim's residence only one time within 48 hours with a police officer to retrieve her personal belongings, personal health items, medicines. If you go back at any other time, you will be rearrested and you have to go with a police officer. Do you understand that, ma'am?
Do you understand her? You gotta concentrate for now. Okay, well, you just gonna have to wait then.
Okay, so there's a stay away order and the bond is 2,500 and 5,000. I find probable cause of those. Thank you.
Okay, come on, ma'am. Come on, ma'am. Sanchez Flores. English is fine.
The next case I have is Chelsea Zaira Sanchez Flores.
Judge, Ms. Sanchez Flores is here present with me.
She speaks English.
And Judge, the defense would be stipulating a probable cause in this case.
Okay, let me first say you're charged with battery on a person of 65 years or older, and the second charge is criminal mischief more than 200. Let me read the arrest affidavit to determine if there's probable cause. And I know you have an argument.
Yes,
so
Judge,
let me
we did
first-
stipulate.
Thank you. Okay, I can go ahead. Please tell me your probable cause argument.
Well, Judge, we stipulate to probable cause. We're not arguing the probable cause at this time. Just asking in this case for below standard bond or the option of house arrest, Judge. In this case, Ms. Sanchez Flores has no priors. This is her first contact with the Miami-Dade legal system, Judge. And despite the allegations in this case, we do think that Ms. Flores should be entitled to some form of release.
The state's request on count is $5,000, and as count two, the state's request is $5,000.
Yeah.
Hold on one second.
That's exciting.
And Judge, and the alternative to
Sorry about that.
house arrest or below standard bond, we'd be asking for $1,000 bond on each count.
State on count one, I find probable cause for battery and a person 65 or older. You're requesting 5,000?
Yes, Your Honor. Yes, Your Honor.
And I found probable cause on count two.
State's request is 500.
I'm gonna go ahead and actually. This is with an elderly, so person 65 or older, so I'm gonna issue $6,000 bond on the elderly on count one. And count two, I'll issue the standard bond,
That is
which is 500.
Count one was how much, Judge?
6,000.
Okay.
6,000. And then let me tell you, there's a stay away order, ma'am. Larry Jamone Williams. Do you know who that is?
Answer the judge.
Yes. Okay. You are to have no contact with the victim, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. You must stay 500 feet away from the victim's homes, place of employment, and school at all times. Understand? And that also means no contact through emails, texting, Facebook. Thank you.
And Judge, is that all for Ms. Sanchez Flores?
Yes, I believe so. Thank you. Thank you. The next
Miss
case I
Mora.
have is Shani T. Mora. It does?
Yes, Judge, I'm here with Miss Mora. She would ask for her in this case, Judge.
I couldn't hear you. I'm
Yes,
sorry.
Judge. Miss Mora is asking for the assistance of the Spanish interpreter.
La señora Mora pide un intérprete de español, intérprete presente, interpreter present.
Okay. She's been charged with 3 different counts. The first count is controlled substance possession. The second count is unlawful possession. And third is petty theft. I'm going to read the arrest affidavit to determine if there's probable cause.
Ella está enfrentando 3 cargos. Uno es posesión de una sustancia controlada. El segundo cargo es posesión ilícita. Y el tercero es hurto de menor cuantía. Voy a leer la declaración jurada que sustenta el arresto para ver si contiene suficientes indicios.
And public defender, do you have any arguments at this time?
Judge,
Señor
I don't
defensor
have
de
any
oficio,
probable
¿usted tiene
cause.
alegatos? Señoría, no tengo ningún alegato en relación a la suficiencia de indicios.
I don't have probable cause arguments. However, I do have an argument as to count 1 in this case, Judge. I would just inquire as to whether the state's aware whether the officers impounded the alleged narcotics. It's not on the arrest affidavit like it typically is. And if they did not impound the narcotics, we would ask that the state dismiss the charge at this time since it's not viable to go to trial.
No tengo ningún alegato, señoría, en relación a la suficiencia de indicios. Solamente quiero cerciorarme de que si los policías retuvieron la presunta sustancia controlada o narcótico, como normalmente eso se escribe en las declaraciones juradas de arresto, aquí no lo encuentro. Quiero que los fiscales me digan si ha sido retenida esa muestra. Porque si no, entonces el cargo tendría que ser desestimado en base a que eso es lo que exigiría la ley.
Yes, sir. As to count the public defender's argument, just because the form is whether it's been impounded or not, mean that there's a cause for that. The state is not going to dismiss the charge at this time. If upon further investigation by the ASA assigned back to this case finds out that the drugs were not impounded in the story, that up to that purview. But at this time, requesting
Señoría, en relación al alegato de la defensa, la fiscalía en este momento solamente mantiene que no va a desestimar el primer cargo, incluso si la muestra o los narcóticos no fueron retenidos, que eso en este momento no va a resultar en que se pida que se desestima el cargo, y si más adelante se determina que no fueron retenidos, se tomarán medidas.
Court finds probable cause for count 1 in the amount of $2,500. Court finds probable cause count 2, $2,500. And the court finds probable cause for count 3, $150. A total of $5,150 with a stay away order.
El tribunal estima que hay suficientes indicios de criminalidad en relación al primer cargo. La fianza son $2,500. Hay suficientes indicios de criminalidad en relación al segundo cargo. La fianza en relación a ese cargo son $2,500. Y en relación al tercer cargo hay suficientes indicios de criminalidad. La fianza son $150. El monto total de la fianza son $5,150. Y además se emite una orden de alejamiento.
Ma'am, you're supposed to stay away from Miami, Florida 33126. Do you understand?
Señora, usted tiene que mantenerse alejada de la tienda Target, que queda ubicada en el 3825 noroeste de la calle 7, Miami Gardens, Florida 3126. ¿Usted ha entendido? Yes.
Judge, if I may, I never had an opportunity to make a argument for the bond in this case. I understand that the court has already set bond. However, we would be asking for, again, below standard bond. We'd be asking for $1,000 bond in count 1 and count 2, and a $1 bond in count 3, based off the facts that Ms. Mora, the majority of her life, She has no priors that the defense is aware of. And Judge, it's our position she's not a flight risk or a risk to the community. She's had cases in the past that have been closed, which shows that she comes to court and she does close out cases. And she's no risk of flight to this
Su
court.
señoría, previamente no se me dio la oportunidad de hacer un alegato en relación al monto de la fianza. Con todo respeto, le pida que se tome en cuenta la posibilidad de imponer una fianza más baja que la estándar. Yo le pediría una fianza de $1,000 en relación al cargo número 1, $1,000 en relación al cargo número 2 y $1 en relación al cargo número 3. Como fundamento, le señalo que la señora Mora ha vivido en Miami toda su vida, que no tiene antecedentes y que ha tenido casos anteriores, pero todos aquellos casos han sido cerrados. Por tanto, ella no presenta un riesgo para la comunidad ni presenta un riesgo de darse a la fuga. Ella ha demostrado que ella comparece ante el tribunal y cierra sus casos.
Like I previously ruled, I'm gonna keep with standard bond this time. Thank you.
Como previamente determiné, yo voy a mantener la fianza estándar en relación a cada cargo. Muchas gracias.
The next case that I have is Emilia Ramos.
Ms. Ramos? Here, come stand right here. Okay. Yes, Judge, I'm here with Ms.
Does
Ramos.
she need a Spanish interpreter?
No, Judge.
Okay. You're charged with one count of controlled substance possession, another count of drug paraphernalia with the intent to use, and the third one, you have a bench warrant. I'm gonna go ahead, and the bench warrant is on case AIIQLGE. But I'm gonna go ahead and read your rest affidavit to determine that there's probable cause.
Judge, the bench warrant was taken care of at jail arraignment.
In the traffic.
Oh, yeah.
Calendar, yes.
And do you have any arguments about the defender this time?
Judge, I don't have any probable cause arguments again. However, I would like to re-raise the point from one of the prior cases, which is that this case also does not include any mention in the arrest affidavit of any property or narcotics being impounded. The defense would ask if the state would be willing to dismiss the case if there was no property impounded, being that they cannot prove this case and they cannot in good faith go forward if there's no evidence of the crime impounded.
Your Honor, on page 2 of the A4, right above bond document was utilized. It does indicate that it says impounded station.
Sorry, I don't see that.
On page 2 of the A4, it says impounded. Right after the transported to the GK, it says impounded.
I am seeing that now, Judge. I apologize.
No problem. Okay, so the state wants to proceed with inner bond.
Yes, it would be
2,500.
2,500 for 2 and 500 for drug paraphernalia.
And
The
Judge,
court finds, the court finds probable cause for count 1, 2,500.
Judge, if I may make an
Wait,
argument.
let me finish. What were you saying?
I haven't been able to bond, and if I may argue against the state's request for standard bond.
I'm gonna issue standard bond.
I understand if I could just lay a record as to,
Okay.
yes,
Go ahead.
Judge. Ms. Ramos has no prior convictions. Everything on her record that the defense is aware of is a withhold of adjudication. She's from Miami. She is a Miami resident, and she does have cases closed in the past. It's our position that she is not a flight risk, nor is she a risk to the community. Everything in these allegations is with narcotics that would, if the allegations are proven, pose more of a risk to herself than to the community as a whole.
When she goes in front of division judge, that can be addressed, but so for count 1 is gonna be 2,500, count 2, 500, and find probable cause on both counts. Thank you. The next case I have is City of Houston.
Yes, Judge, I'm here with Houston.
Are you Miss Houston, ma'am?
Yes, ma'am, how you doing?
You have been charged with aggravated battery. I'm gonna go ahead, and you also, with a stay order, I'm gonna go ahead and read your arrest affidavit to determine I find probable cause. And public defender, please let me know if you have any PCR arguments.
Judge, we're having issues hearing you. I don't believe Miss Houston was able to understand what you were saying.
Sorry, you've been charged with aggravated battery. I'm gonna go ahead and read your arrest affidavit to determine that there's probable cause. And I asked the public defender to let me know if he has any PC arguments at this time.
Judge, we would stipulate to probable cause and we would ask that the standard bond be set in this case or on house arrest.
Do you have anything to address at this time?
Yes, Your Honor, they would request a standard bond of $7,500.
So I find probable cause, we're gonna set the standard bond for 7,500.
Correct.
Probable cause is found, and also there's gonna be a stay away order from Angela Lusma. Do you know who that is, ma'am?
No, ma'am.
Well, it's the alleged victim in the arrest affidavit, so you're to have directly no contact in person, indirectly, directly, in writing, telephone. You must stay 500 feet away from the victim's home, place of employment. The defendant shall stay away from the following address: 26510 Southwest 138th Avenue, Miami, Florida 33032. Do you understand, ma'am?
Yes, ma'am.
Thank you.
Thank you.
Next case I have is Carolina. I'm not sure how to pronounce last name.
Yes, Judge. Ms. Vior will need the assistance of the
How do you
Spanish
say it?
interpreter. Vior, sí. Vior.
Señora Vior necesita el intérprete.
Good afternoon, ma'am.
Necesita
¿Tiene
intérprete,
Spanish
señora.
interpreter?
Yes, Judge.
Yes, correct.
Okay. You have been charged with 3 different counts. The first count is battery, and the third count is battery. I'm gonna go ahead and read your arrest affidavit to determine each count has a probable cause. And you also have 2 stay away orders. So I'm gonna go ahead and read your affidavit.
Señora, usted enfrenta 3 cargos. Se le acusa de un cargo de robo con fuerza. El segundo cargo es agresión física. El tercer cargo es también agresión física. Usted también es objeto de 2 órdenes de alejamiento. Voy a leer tu declaración de su arresto para determinar si contiene suficientes indicios de criminalidad. Es una declaración jurada.
And Judge, we do have a probable cause argument as to count 1 in this case.
Señoría, en este caso tenemos un argumento en relación al cargo número 1. Argumento en relación.
Okay, you can go ahead with your PC argument.
Yes, Judge. Based off the 4 corners of the arrest affidavit, Judge, there is no strong arm robbery alleged, Judge. There is, however, probable cause for robbery by sudden snatch, which would be a 3rd-degree felony rather than a 2nd-degree felony. On the 2nd page of the arrest form, you'll read that there was a physical altercation that occurred. And then based off the arrest form, it seems as if There was a gap, at which point the arrest form alleges that Ms. Viord had snatched the phone from his hands and walked into the kitchen. The arrest form literally reads snatch the phone. The strong arm robbery would require some type of force during the grabbing of the object. We
Señoría,
would ask
si
we would
usted
ask that notice be done.
se fija en el formulario juramentado del arresto, aquí en la página segunda y tercera se indica que hubo algún tipo de altercado y después hubo un intervalo entre eso y a continuación, más adelante, dice que la señora Villor le aló, hubo un alón y le quitó el teléfono de esa manera a la otra persona. Para que hubiera un robo con fuerza tiene que haber algún tipo de forcejeo. Y si es así, entonces habría suficientes indicios de criminalidad para el delito de robo mediante un alón repentino, que sería un delito grave de tercer grado, y no para un robo con fuerza, que es un delito grave de segundo grado.
I would also like to point out to the court that on page 2, the arrest affidavit does allege that he committed battery on Ms. Viord. However, I don't see that as charged or any arrest made for that. It's not a probable cause of argument, but I believe it should be something the court should note.
Yo también observo, señoría, que en la segunda página aquí se indica que la víctima número 1 comete una agresión física en contra de la señora Villor y aquí no se indica que ha habido algún arresto en relación a aquello. Esto no está vinculado al alegato acerca de que el tribunal lo tome en cuenta.
Sí.
Claro.
Right before, someone just referred to it, slaps it, he poured a hot grease on it.
Excuse me, Your Honor. The interpreter cannot hear what is being said.
Can you hear me now?
Now I can.
Before the victim is said to slap the defendant, he pours a hot pot of rice over her, injuring her. So just wanted to know for the record, that's part of the PC argument. However, state does agree. We are finding for robbery by snatching for count.
La Fiscalía concede que indicios de criminalidad para robo mediante un alón repentino en relación al cargo de la bofetada que la presunta víctima le dio a la acusada. Hay algo de que la acusada, algo caliente, pero el intérprete no pudo entender qué fue.
And okay, the court finds probable cause, and I agree. And there's probable cause for the second count of battery, and there's probable cause for the third count of battery. The standard bond for the two batteries would be $1,000 each. And what is the standard bond for robbery with snatch? And I'll issue the standard bond for robbery with snatching, $2,500.
Este tribunal determina que hay suficientes indicios de criminalidad para robo mediante un alón repentino y no para robo con fuerza. Y en relación al cargo número 2, agresión física, el tribunal estima que hay suficientes indicios de criminalidad. En relación al tercer cargo, agresión física, el tribunal estima que hay suficientes indicios de criminalidad, impone una fianza de $1,000. En relación al robo mediante alón repentino, impone la fianza estándar, $2,500.
There's a stay away order. The defendant is prohibited from having any contact with the victim. I think this is Harry Ferrer. The victim, you know who that is? Ferrer, it's the last name.
Se emite además una orden de alejamiento. No se le permite tener ningún contacto con la presunta víctima de apellido Ferrer. ¿Usted sabe quién es esa persona?
Sí, señoría.
Yes, Your Honor.
Okay, you have no contact directly, indirectly, in person, in writing, by telephone, pager, fax, or third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and school. Either via email, Facebook, Twitter. It's all prohibited. Do you understand that, ma'am?
Entonces, señora, se prohíbe que usted tenga cualquier contacto, ya sea directa o indirectamente, con esa presunta víctima. No puede hacerlo en persona, por teléfono, por beeper, por fax o a través de terceras personas. No puede comunicarse con ellos, ya sea a través de medios sociales, correos electrónicos o de ninguna otra manera. ¿Usted ha entendido? Understood.
And then there's also another release conditions. You're not to engage in any criminal activity, cannot use or possess any illegal drugs. You cannot purchase, use firearms. If you have any firearms, you must surrender them to the nearest police station immediately. You're prohibited from having any direct or indirect contact with the victim, Julie. I can't really read this writing. With the victim, Julie, for code. Do you know who that is? Yeah.
Entonces, señora, hay condiciones adicionales. A usted le está prohibido inmiscuirse en actividades delictivas. No puede usar, portar ni tener ningún tipo de arma de fuego o munición. Si usted tiene armas de fuego o municiones, tiene la obligación de entregarlas en el departamento de policía que le quede más cercano y darle un archivo que le dan allí al tribunal. Además de eso, le queda prohibido tener contacto con Judith Ferrera Blanco. ¿Usted sabe quién es esa persona, señora?
Sí, señoría.
Yes, Your Honor.
And defendant must stay at least 500 feet away from the victim's home, place of employment at all times.
Y la defensa está obligada a permanecer por lo menos a 500 pies de distancia de la víctima, del centro de trabajo de la víctima o de la escuela de la víctima en todo momento.
Do you reside with any of the victims in this case?
¿Usted vive junto con alguna de las víctimas en esta causa?
Sí, correcto.
Yes, correct.
Okay. You will be able to go within 48 hours, accompanied by a police officer to retrieve your clothing, personal belongings, medication. The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim. And you're only allowed to go one time within 48 hours with the police officer. Do you understand that, ma'am?
Muy bien. Se le permitirá regresar al hogar común una sola vez en un plazo de 48 horas a partir del momento en que quede en libertad de esta detención, para volver allí acompañada solamente por un policía, para que usted recobre allí sus ropas, sus pertenencias personales, sus medicinas. La policía le pedirá que entregue cualquier llave o dispositivo para abrir el estacionamiento del vehículo en ese lugar y solamente puede ir allí acompañada de esa manera. ¿Usted comprende eso?
Entendido, señoría.
Understood.
Okay, thank you.
Muy bien, gracias.
The next case I have is Leticia Carvel.
And Judge, I am here with Miss Carvajal. She is number 10 on the court's calendar.
Okay, does she need a Spanish interpreter?
Judge, she does need the assistance of the Spanish interpreter.
Okay.
Yeah, no.
Ella necesita el
Ma'am,
intérprete.
you have been arrested for assault aggravated with a deadly weapon and cocaine possession suspected to be crack cocaine. I'm going to go ahead and read your arrest affidavit to determine if there's probable cause for each of the counts.
Señora, se le acusa de agresión con agravantes con un arma mortífera y también de posesión de una sustancia controlada que se estima que es cocaína en forma de crack, de piedra. Voy a leer la declaración jurada de su arresto para ver si contiene suficientes indicios de criminalidad.
And Judge.
Yes. Let me finish reading it. If you have,
Okay.
Y jueza, la estoy leyendo.
Okay, the court finds probable cause of assault aggravated with a deadly weapon and court finds probable cause for cocaine possession, but did you have an argument, defender?
Judge, I would just like to point out to the court that on the arrest affidavit, it does say that no weapons were seized. Does seem that there might be some evidentiary issues here, which wouldn't necessarily be dispositive. However, we would be asking for a reduction from the standard bond, being that Ms. Carvajal has no priors that the defense is aware of. We'd be asking for a $2,500 bond on count 1 and a $1,000 bond on count 2, Judge.
Muy bien, yo determino, dice la jueza, que hay suficientes indicios de criminalidad en relación al delito de agresión con agravantes con un arma mortífera y también de posesión de una sustancia controlada. El abogado señala en relación a todo esto que en la declaración jurada de su arresto no aparece ninguna indicación de que se ha retenido algún tipo de arma mortífera en ese asunto, que eso podría tener algún peso sobre las pruebas en el caso, y pide una reducción de la fianza en relación al primer cargo a $2,500. En relación al segundo cargo, pide que se le imponga una fianza de $1,000.
I'm sorry, to clarify, you said that no weapon was retrieved?
Perdón, usted señaló que usted estima que no se retuvo ninguna arma, no se decomisó ninguna arma.
Yes, on the arrest affidavit, in the center of the arrest affidavit, it says no weapon was retrieved. Again, as I said, it wouldn't be dispositive or something that would lead to, a judgment of acquittal in this case. However, it is an evidentiary issue to consider when Your Honor is setting bond in this case.
Usted me dice que no se ha encontrado ningún arma. Correcto, si usted se fija en el centro de la declaración jurada del arresto, aquí se indica que no se ha retenido ninguna arma. Eso no estoy indicando que eso es un asunto dispositivo y que puede resultar en una absolución total, pero es algo que podría resultar en problemas con la presentación de pruebas en el caso.
Your Honor, standard and setting bond is probable cause, which is low standard. The U.S. form clearly states that the weapon was involved. The state's requesting standard bond.
Su señoría, la fianza estándar, independientemente de que si en la declaración jurada del arresto se diga que no hubo un arma retenida, la fiscalía pide una fianza estándar.
Yes, there was a deadly weapon used. I'm going to go ahead and grant the standard bond $5,000 for count 1. It's probable cause was $2,500 for count 2.
Sí,
Probable cause was fine.
se usó un arma mortífera, entonces voy a imponer la fianza estándar. El primer cargo, que son $5,000, y la fianza en relación al segundo cargo es la fianza estándar, $2,500.
And then, ma'am, I'm going to read you. There's a statewide order from Antonio Mena. Do you know who that is?
Señora, le voy a leer una orden de alejamiento en relación a Antonio Mena. ¿Usted sabe quién es esa persona?
No.
No.
Well, it's the defendant in this case.
Judge, I believe you mean to say the alleged victim.
I'm sorry. The alleged victim in this case.
¿Usted sabe quién es la presunta víctima en esta causa?
Antonio.
No, sir.
It's Mr. Mass, right? The person's name. Antonio Pernuti Mena. Do you know who that is, ma'am?
Sí, señora, Antonio
Perduni Mina.
Antonio Perduni Mina o Mena.
Mena is the last name, M-E-A.
I'm sorry, is it Peña?
Sorry,
Do you know
we're
who
gonna
that
need to
person is?
repeat that.
Antonio Mena.
Antonio Mena.
Do you know who that is, ma'am?
¿Sabe quién es?
Judge, she's saying no.
Okay, 1 minute, still proceed. You're to state directly or indirectly from this individual, no contact in person, writing by telephone, pager, fax. Defendant must stay at least 500 feet away from this victim's home, place of employment, school at all times, no contact through any social media. Also, the defendant shall stay away from the following address: 786 83rd Street, Unit 3, Miami Beach, Florida, 33141. Do you understand, ma'am?
Muy bien, señora. Usted no puede tener ningún contacto con la presunta víctima en esta causa, cuyo nombre es Antonio Mena. No puede, además, comunicarse con esa persona a través del teléfono, a través de un beeper, a través de fax. Y encima de eso, señora, usted tiene que mantenerse en todo momento, por lo menos a 500 pies de distancia de esa persona, del hogar de esa persona, del centro de trabajo de esa persona o del centro de estudios de esa persona. Y también, señora, tiene que mantenerse por lo menos a 500 pies de la siguiente dirección: 786 calle 83, unidad número 3, Miami Beach, Florida, 33134. ¿Usted ha entendido eso, señora? Yes, correct.
The next case
Muy bien,
is
gracias.
Christian Rivera.
Judge, Mr. Rivera, he refused. He's also out on felony bond on 8 cases.
And Judge, we would have to reset this to tomorrow.
Good afternoon. Are you guys, I know there, I just see an attorney person. Are you here on the Christian Rivera case?
No, Your Honor, David Rivera.
Okay, and, okay.
Judge, Mr. Rivera
Okay,
refused.
so we'll go ahead and reset him for tomorrow.
Yes, and he's also out on felony bond
There's,
on 8 cases.
there's several charges. Okay, so we'll reset him for tomorrow.
Yes, Judge.
Thank you. They're asking if you could pull out David Rivera. He has counsel present. He's on page 10.
Who, Judge?
David Rivera.
Number 30 on page 10.
Thank you.
And there's counsel present on that one, public defender. There's two.
Yes, Judge.
There's two counsels present.
Yes, Your Honor.
Yes, Your Honor.
For the same individual?
Yes.
Yes, Your Honor.
Okay. When he comes in, I'll have you guys state your appearance for the record.
Yeah, pretty warm.
Of course.
And Judge, the next individual on the calendar, number 12, Mr. Calwood, he did refuse court. That's what corrections had just
Sorry, I didn't
advised.
hear you. What do you?
Corrections had advised me earlier that Mr. Calwood, number 12 on your honor's calendar, has refused court for today. We'd just be asking to reset it tomorrow.
Okay, I'll adjust that. Maybe I'll waive it if you refused it. Let's go to, are you Mr. Rivera?
No, yes, Judge. This is Mr. David Rivera.
Okay, do you need a Spanish interpreter?
No, I don't.
Okay. Counsels, can you please state your name?
Yes, Your Honor. Good afternoon. Gabrielle McCabe on behalf of David Rivera.
Yes, good afternoon, Your Honor. Hernan Luna on behalf of David Rivera.
Okay, I'm gonna go ahead, and you have been charged with burglary with assault and robbery. The second count is robbery strong arm. I'm gonna go ahead and read the rest affidavit to determine probable cause, and then I'll let your attorneys make their argument.
Thank you, Your Honor. And I do have arguments.
And
I
in addition,
I do have arguments
sorry, and in
regarding
addition,
probable cause.
Okay, and in addition, just like, whichever the state is filing a motion for pretrial detention. So let me just read the rest affidavit, and then I'll hear your argument.
Sorry. Can you repeat that?
Okay, I can go ahead and adjust your probable cause argument this time.
Thank you, Your Honor. So as it relates to the burglary, Your Honor, the statute requires a showing that the person is not. A form does not allege that he's not licensed to enter the dwelling. In fact, my understanding that he is the person on the lease. The A form also states that they previously lived together, they resided together at the apartment. He is still legally able to enter the dwelling. His license to enter the dwelling has not been terminated. The A form also states that the door is unlocked, and while that's not dispositive, it again shows that he was not intending to illegally enter. Additionally, the A form does not state that the documents that he was allegedly attempting to take belong to the alleged victim. He lived there with the alleged victim. He does have property that is still there. He has allowed her to continue residing there. Even though he is not residing there at the moment, again, it is under his name. The apartment is his, so he cannot be charged with burglary, and the A form does not sufficiently state the cause of action. As it relates to the assault and battery, Your Honor, the statute also requires for burglary or battery that he perpetrated an assault or battery on her. However, it states that he grabbed the box and that at that point, the alleged victim attempted to maintain control of it. So any altercation that occurred between them was initiated by the alleged victim. There's no allegation that Mr. Rivera was the one who initiated any physical altercation, Your Honor. So I would also argue that there's no probable cause based on that. As to the form, again, it also requires the taking of property of another. The A form does not allege that the documents allegedly taken belong to the alleged victim. It says that he grabbed up the box containing documents. Moreover, Your Honor, again, it requires the assault or battery during the course of taking the property. However, the alleged form states that he grabbed the box, at which point the alleged victim was the one who then would be considered the initial aggressor trying to grab the box. So there was no assault or battery during the course of the robbery. So Your Honor, as to count two, we would, I would argue that there's no probable cause as to either. In the alternative, Your Honor, I would ask that the court enter a standard bond as to count two, and that the state either amend the first charge or stipulate to a bond. Otherwise, Mr. Rivera is going to sit in custody for something that it is not supported by the facts in the A form.
Your Honor, the state would disagree. In the arrest form, it does say that husband and wife who resided together in the past. There's no indication on the arrest form that he is a person who's on the lease of the property. In fact, the arrest form does say that she was inside of her apartment. The defendant entered without her permission. Additionally, going to the defense's argument that the documents were not hers and there's no probable cause for strong arm robbery. The arrest form clearly states the victim advised the defendant then fled the scene with her box, indicating the box was owned by her. So for those reasons, the state would be requesting PC on both counts, and that the detention should be granted.
I didn't hear the majority of the state's arguments, but I will say, just because the officers didn't do their job.
Would you like her to would you like her to repeat it so you can hear it? Just make it louder. Sorry.
That's fine.
We've been having technology problems all day. Sorry.
Can you hear me now?
It breaks up. I don't know if you can speak a little louder.
Can you hear me now?
Yes.
Okay. So to your argument that he lives there or has any kind of authority to enter the home that's not visible on the arrest form, there's no documentation on the arrest form to note that he is on the lease or an owner of the property. As well, on the arrest form, it states that they resided together in the past. And he entered the apartment without her permission. The arrest form also states that it is the victim's apartment. Additionally, for the strong arm robbery, the arrest form states that the victim advised the defendant then left the scene with her box, indicating that she owned the box. He tried to take it without her permission, and when she tried to take the box back from him, he shoved her to the side with his elbow. So for those reasons, we're requesting PC be found on both counts, and that the pretrial detention motion be granted.
Your Honor, may I briefly respond? Your Honor, I would say
Yes,
the
ma'am.
fact that the officer did not diligently do their job in determining whose apartment it is doesn't mean that someone should sit in jail on a PBL offense. Yes, it does say that she did not give him permission to enter, but she does not need to give him permission to enter his own apartment, and that is not the language of the statute. The language of the statute requires a showing that the person is not licensed to enter the dwelling. That is not alleged in the A form. He is licensed to enter the dwelling. It's under his name. He has not been evicted. There's no previous DV allegations. There's not an injunction. And there has been no termination of his lease. So as to that argument that the state is making, Your Honor, I still stand on my argument that there's no probable cause for the burglary with an assault or battery, Your Honor. If the state would like to charge him with battery, then that's one thing, but he cannot be charged with burglary for entering a dwelling where he is legally allowed to be.
Your Honor, we're asking for a pretrial motion, pretrial detention motion. There will be a hearing later on the merits of whether he owns the property or not, which will be determined by the diligent judge. As for the probable cause, it's to be determined within the four corners of the A form. And unfortunately, it doesn't state that the defendant owns or leases that property.
Your Honor, yes, the judge will hear it, but Mr. Rivera is going to lose his job if he remains in custody. He's already missed 2 days of work due to this, due to allegedly taking a box with his belongings in it, an apartment where he is on the lease. The state could stipulate to a bond with GPS if they want to. There's no, I believe he has one prior from 2015 that was no pros, and it was cannabis possession. There's no violent priors. This is it's charged very seriously. However, the allegations are, that he allegedly pushed her trying to obtain some documents from his own home. So I would ask that either probable cause not be found or that the state stipulate to some type of bond.
The state is not willing to stipulate at this time. We don't have enough information. We're going based off the information that's on the arrest warrant, which is required for probable cause.
Okay, the state is gonna find probable cause for count 1, 7,500. And the state's gonna find probable cause for count 2, which will be no bond.
It would be 1.
Oh, sorry. Count 1 is the no bond, sorry. Okay, so count 2 is the 7,500.
Thank you, Your Honor.
Hold on, there's also so count 1 is the no bond. And 2 is the 7,500. And of course, you're gonna be able to go in front of the division judge, but these are very strong allegations, and under statute 907.041, I'm gonna grant the state's motion for pretrial detention at this time. And also I will, I guess, is this the one that feels like I granted no bond?
Yes,
okay. And we're also willing to, these are the standards of conditions of release. Okay, you're not to engage in any criminal activity, do not use or possess any illegal drugs. If you have any firearms, you must surrender them to the police immediately. The defendant is prohibited from having any direct or indirect contact with Nathid Barriato. Do you know who that is, sir? Sorry if I pronounced it incorrectly. I couldn't hear you.
That's incorrect. That's okay. I understand.
Okay. No contact indirectly, directly.
Can't really hear you that well.
Something else.
No, I'm saying that I can't really hear you that well. I hear a bunch of echoes.
I'm sorry, we've been having trouble. Do you know who Nelly? Sorry, I don't know how to pronounce it correctly. You know who that I'm referring to? Okay. You're to have no contact directly, indirectly to that individual. Do you understand?
I just have a question regarding, let's say, my child, because we have been in custody. So I want to know what that was about.
Jana, may I answer him briefly? Mr. Rivera, I'm gonna come see you first thing Monday morning, and I'll answer all of your questions, okay? You're welcome.
Okay, thank you.
At this time, there would be no contact with your, as your attorney said, she'll speak to you on Monday. There'll be no contact with your minor child at all at this time.
Thank you, Your Honor.
Thank you. And do we have a date? Okay, you'll be on the calendar Monday, so.
What time will he be on Monday, Your Honor?
Number 2.
Yeah.
The clerk informed me they.
So he's
started
gonna
at
be on
9,
this
9:15.
calendar?
No.
Okay, perfect. Thank you.
Thank you, Your Honor.
Thank you.
Judge, Corrections has advised me that Ms. Ramos, who was number 2 on the court's calendar earlier, we had asked her. She is present now in the unit.
Ramos or Rivera?
Or sorry, Rivera, Ms. Rivera. Yeah.
Okay, so this is Wanda Rivera. Ma'am, are you Wanda Rivera? Okay, you've been charged with hired vehicle failed to redeliver. I'm gonna read your.
I'm sorry, Judge, we can't really hear you too well. It's better when you're closer to the microphone.
I think it's just the audio is bad. That's what I had to do with the last one.
Okay. This is the other. No, but this is. Yeah. Yeah. Okay, I'm gonna go ahead and
Just she's an open felony.
yeah, there's an open felony in this case, but the count is for hired vehicle failed to redeliver. I'm gonna read the rest affidavit to determine probable cause, and defense, please let me know if you have any PC arguments. You have any probable cause argument, public defender?
Judge, we don't have any probable cause arguments. We would just be asking for a reduced bond in this case, being that Ms. Rivera's only priors are from marijuana possession back in 2001, it looks like. And then she also has a withhold to a grand theft in 2023. We would argue that non-monetary bond non-monetary bond, such as a program or a lower bond, reduced bond, would be appropriate in this case, given her record and her non-violence. She's not a risk to the community, and she's not a risk of flight. She has an address in Miami.
Stay with your existing standard bond, $25 with this case. They would also be requesting a felony hold with regard to felony case as well.
Yes, the court is going to go ahead. If I'm probable cause, I'm going to go issue the 2,500 standard bond in this case. And there's a felony hold in case number F25-21759, E as in boy.
Judge, is that all for Ms. Rivera?
Yes, I believe at this time. Thank you.
Mark. I think you might have wrote yours.
Okay, the next case that I have is Callwood Shamira.
Shamari Callwood or Callwood, Judge?
Yes, pronounced it incorrectly.
No worries. It's number 12 on the calendar. Judge, I was advised by corrections earlier, I gave refuse court. We would ask to reset this to tomorrow. He refused.
They,
He refused.
they refuse court, so we set for tomorrow. Wait, public defender, would you waive their presence?
Wait, stay away order. If that's the case, we would have to.
Judge,
There's what?
being that they were arrested yesterday, I can't wait their
Okay. We'll reset this for tomorrow.
Yes.
Thank you. Okay, the next case that I have is Felipe La Paulin. Are you Felipe, sir?
Yes, Judge. I'm here with Mr. Llanos Colon.
Okay, so you've been charged here with grand theft, second degree, and the second charge is assault aggravated with a deadly weapon. I'm gonna go ahead and read your arrest affidavit, and public defender, please let me know if you have any PC arguments at this time.
Yes, Judge.
Public defender, do you have any arguments at this time?
Judge, we don't have any probable cause arguments. We would just be asking for the reduced bond in this case, Judge. We'd be asking for a total of a $5,000 bond or $2,500 between both charges, Judge.
He's a career criminal.
Yes, Judge. He does have priors, as the court has noted. However, as the defense has said in prior cases, Judge, it also does serve as proof that he does show up to court. He is interested in closing his cases, and that he is not a flight risk to the court. While I can understand the court's concern with the community, Mr. Llanos Colon, as proven by his priors, does show up to court and does close his cases.
Date?
Under the state requesting an elevated bond in this case, as well as.
The court finds probable cause for count 1, grand theft, and the court finds probable cause for count 2, assault aggravated with a deadly weapon.
And Judge, I'm not sure if the state said it. Is there a reason that they're asking for the elevated bond?
It would be criminalized.
Okay.
Okay. Count 1, grand theft, the bond will be $10,000.
10,000.
Okay, count 2, assault aggravated with a deadly weapon. Based on his extensive, I'm gonna give count 2, 10,000.
And Judge, I apologize. If you do hear me saying the bond, it is me trying to.
10,000 on each count.
Yes, if you do hear me saying the bond out loud, it is me trying to convey that information to correction so the jail card can reflect.
Okay, so I find probable cause in both, and I find the bond to be 10,000 on each.
And that's without GPS, Your Honor, just to confirm.
Oh, no, if he's gonna bond out, yes, with GPS monitoring, and there's also a stay away order.
What level?
I'm sorry, Judge, did you say GPS monitoring?
No, he's.
She works here, yes, I'm just asking. You would like us to make a recommendation?
Yeah, you can make a recommendation.
I can't hear anything that's
Okay,
being.
the state is making a recommendation for GPS number 1. That's the strictest monitoring, correct?
House,
Okay, the court is gonna also order the GPS monitoring house arrest level 1
and this is
plus bond. So there's bond in each count. Count 1, 10,000. Count 2, 10,000 bond. GPS monitoring.
Judge, I think that would be, I understand that,
This is my ruling, and then I'm gonna have
I
GPS
understand,
monitoring level
Judge.
1.
However, I just need to lay my record. I believe that would be punitive, Judge. There has already been an elevated bond. The state was not asking for house arrest originally. The court granted the
The
10,000
state
bond.
was asking for GPS monitoring originally.
The defense was not able to hear that. I understand there's technical issues over here and it is affecting my representation of these clients, Judge, if I can't hear what's being said in court.
We apologize about you not being able to hear. The audio's been crazy.
I understand, but it doesn't affect me. It affects my clients. That's the issue.
Okay, so please convey to him that there's count 1 is $10,000 bond, count 2 is 10,000. There's gonna be a GPS monitoring level 1, which is house arrest. And there's also stay away order from Nicholas Perez Carbonell. You're to have no contact directly, indirectly by phone, pager, fax. You must stay 500 feet away from the victim's home, place of appointment, and school. No emailing, Facebook, messages, or Twitter. It's prohibited. Do you understand that, sir?
Can you hear it?
I hear what she's saying, but I don't understand a word. What it's echoing. I don't know what she's saying.
Judge, he's saying he's having issues understanding due to the echoes and the reverberation.
Can you hear me? That I'm saying that you have $10,000 bond on count 1
$10,000 bond on count 1
and $10,000 on count 2.
He said, okay.
And then you're gonna have GPS monitoring level 1, which is house arrest, the strictest monitoring possible.
Okay.
And you also have a stay away order from Nicholas Perez Carbonell.
Right.
You understand? Okay. House arrest plus bond. And I'm making that based on his career criminal history. That's why I put him on house arrest and elevated bond.
Mr.
The next case that I have, there's 2 arrest forms, but I have is Curtis Briggs.
He's not. Judge, we're gonna have to pass this case. The corrections is bringing him now.
Okay. And the next case is Logan Timothy.
Judge, Mr. Timothy refused, or Mr. Logan refused, Judge. We'd ask to reset this to tomorrow.
You don't waive his presence?
Judge, I cannot waive his presence at this time.
Okay, we'll reset this for tomorrow. The next case I have is Carlos Lazaro.
Judge, he will need the assistance of the Spanish interpreter.
Okay.
Interpreter present.
You do have a probable cause argument in this case.
Tenemos alegatos en relación a la suficiencia de indicios.
Okay. Mr. Lazaro, you've been charged with 3 different counts. The first count is grand theft, 3rd degree with firearm, loss or abandoned failure to report property, reckless driving. I'm gonna go ahead and read the arrest affidavit to determine if there's probable cause in each count. And I know the public defender has a PC argument.
Caballero, se le acusa de un cargo de hurto de mayor cuantía con un arma mortífera. El segundo cargo es que no devolvió propiedad. Y el tercero es que condujo de forma temeraria. Voy a leer el formulario de su arresto para ver si contiene suficientes indicios de criminalidad. El abogado tiene un alegato en relación a la suficiencia de indicios.
Yes, Judge.
Let me go ahead and read the affidavit.
Permítame leer la declaración jurada.
Okay, yes, please tell me your PC argument.
Yes, Judge. Our probable cause argument would go as to count 1 and to count 2 in this case, Judge. I would direct the court to page 3 of the arrest affidavit, where it discusses the fact that that Mr. Lopez Guerra actually had reported the alleged weapon to his supervisor, and no one had returned to pick up the firearm. And at that point, that's when he gained possession of the firearm. It would seem that he did report this weapon. It just wasn't the proper chain of command at his job did not go through what they needed to do once a weapon was found, Judge. We would argue there was no intent here. And furthermore, he did report, he didn't fail to report that there was a weapon. He did report, and the people we reported to allegedly did not do what they had to do.
Pues, señoría, la dirijo a usted a la página 2 y 3 de la declaración jurada. Allí se indica que el señor López Guerra reportó el arma que había sido extraviada o perdida a su supervisor, y entonces aparentemente esa quizás no fue la persona idónea que se le hizo el reporte. Fue solamente después de eso que él fue y obtuvo o tomó posesión de esa arma. No hubo ningún intento doloso de adquirir esa arma, y él sí la reportó.
And Judge, I believe that also goes to the intent to deprive on count 1, since he did report it and did wait for the owner to show in the allegations. He didn't have any intent to deprive the weapon. We would say there's no probable cause for count 1 and count 2 in this case, Judge.
Y en teoría, esto también tendría que ver con el intento de quitarle el artículo al dueño legal. Él, de hecho, reportó ese artículo y esperó a que llegara el dueño, y entonces no ha habido ningún intento en relación a eso, y eso también indicaría que no hay suficientes indicios de criminalidad en relación al primer cargo. Fiscal.
Yes, Your Honor. Are two counts. Number 1, I would direct the court to page 3 of the arrest, in which the officer asks, or the defendant stated he had a firearm in the glove box. However, it was not his firearm. At the bottom of page 3, the defendant further advised that he had saved the firearm. The defendant showed which depicts him at a shooting range shooting the mentioned firearm. This clearly indicates within the 4 corners of the A form, and then not only knew that it was not his, but he did use the firearm. It was not his. Therefore, it's the state's position, the existence of one.
Judge, if I'm sorry.
Your Honor, this is interpreter. The interpreter was unable to clearly understand the state's language. I'm so sorry. El intérprete no pudo entender al fiscal.
I apologize. So it's the state's position with regard to count 1 that probable cause exists for the following reason.
La fiscalía tiene la postura de que hay suficientes indicios de criminalidad en relación al primer cargo por las siguientes razones.
On page 3 of the arrest form, it reads that the defendant stated he had a firearm in the glove box. However, it was not his firearm.
En la página 3 dice que el acusado indicó que él colocó el arma de fuego en el compartimiento en la guantera de su vehículo, y sabía que esa no era el arma de fuego de él. Por tanto, hay suficientes indicios.
Furthermore, a weapon or firearm was found in a glove box of the vehicle.
Además de eso, había un arma de fuego o un arma en la guantera del vehículo.
Lastly, at the bottom of page 3, the defendant showed the officer a video of shooting that firearm.
Y por último, el acusado le mostró al policía un video de él disparando el arma.
Thus, within the four corners of the arrest form, it is clear that the defendant knew the gun was not his, yet he used it.
Esto está dentro del documento del arresto. El acusado claramente sabía que el arma de fuego no era suya y sin embargo la usó.
Judge, if I may, we have a Second Amendment in this country which allows you to possess firearms whether they're yours or not. The statute doesn't require you to prove that he knew it wasn't his. It requires you to prove that there was no permanent intent to deprive it, or no intent to deprive it. In this case, the four corners of the A form overwhelmingly support that there was no intent to deprive it. He literally turns it in, and only after nobody comes forward do they then give him the gun according to the arrest affidavit, Judge.
Entonces, aquí tenemos un derecho en conformidad con la segunda enmienda que nos permite usar un arma de fuego, sea o no nuestra. Aquí, en este caso, no hay ningún intento de permanentemente quitársela a su dueño o, de hecho, de quitársela a su dueño. Él la entregó, su señoría, y fue solamente después de que nadie la reclamó que se la dieron a él.
Okay, the state's gonna issue probable cause for in the standard bond is the state finds probable cause in both count 1.
I'm sorry,
and
Judge,
count
I
2.
can't hear you.
The state finds probable cause in count 1 and count 2.
I apologize, Your Honor.
Sorry.
For the record, the court.
I mean, the court, I apologize. The court finds probable cause for count 1 and count 2.
Este tribunal determina que hay suficientes indicios en relación al cargo 1 y cargo 2.
Yes.
Judge,
And I'm gonna issue the standard bond, which is $2,500.
Impongo la fianza estándar, que son 2,500.
And then I believe the reckless driving was already addressed.
That is correct.
Y
Judge,
el caso de tránsito ya fue ventilado, así fue.
Judge, based off the facts of this case and his lack of priors, I would just ask that the court consider going down from the standard bond in this case.
Y en base a los hechos en el caso y su carencia de antecedentes, le pido que reduzca o que estime la posibilidad de reducir la fianza.
The state's, the court is not gonna go down and it's gonna approve the state on standard bond at this time. And there's also a stay away order from Michael Romero. Do you know who that is, sir?
Este tribunal no descenderá de la fianza estándar. También emite una orden de alejamiento en relación a Michael Romero. Caballero, ¿usted sabe quién es Michael Romero?
No, no sé quién es Michael.
No, I do not know who that is.
No, si yo lo veo.
Yes, the victim did it.
Okay, so in this arrest affidavit, Michael Romero is the victim. So the defendant is proven from having any contact with Michael Romero directly or indirectly, in person, in writing, by telephone, page, or fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and school at all times.
Muy bien, en conformidad con esta declaración jurada de su arresto, Michael Romero es la presunta víctima en esta causa. A usted se le prohíbe que tenga cualquier contacto, ya sea directa o indirectamente, con Michael Romero, por teléfono, por fax, por beeper o de cualquier otra manera. Y en todo momento tiene que mantenerse por lo menos a 500 pies de distancia de Michael Romero, de la vivienda de Michael Romero y de su centro de trabajo, de centro de estudios. ¿Comprende?
Ok, ¿puedo una pregunta?
Okay, am I allowed to ask a question?
I would advise him to speak to his counsel.
Yo le aconsejo que usted hable con su abogado.
Judge, I believe he's just asking if he can continue to work if he were to get out of jail.
Señoría, tengo entendido que lo único que él desea saber es si puede seguir trabajando si logra salir de la cárcel.
And I've told him yes.
Y yo le contesté que sí.
Yeah, there is no house arrest. It's just a straight bond, so he can continue to work. There's no house arrest.
Sí, no hay ningún tipo de arresto domiciliario. Él puede seguir trabajando. Es una fianza sencilla. Thank you, thank you.
All right. The next case I have is Harry Lewis, and there's 4 different arrest affidavits.
Casper Lewis. He went to the bathroom. Judge, I believe he's in the restroom. Mr. Lewis. Yeah.
Okay, so we'll pass him for now.
Oh, that's example.
Daryl Thompson.
He refused? Judge, Mr. Thompson refused.
Okay, so we'll reset that for tomorrow.
Yes, please.
Carol Thompson.
Yeah, refused. So the next case I have is Oscar Alvarez.
Oscar.
You speak English? No, nada de español. I'm here with Mr. Alvarez, his number 19 on the docket. He will need the assistance of the Spanish interpreter.
El señor Álvarez se encuentra aquí. Él es número 19 entre los casos del día y él necesita un intérprete de español.
Sir, you've been charged with 2 different counts. One count burglary of unoccupied dwelling, and count 2 is petty theft. I'm going to read your arrest affidavit to determine if there's probable cause in each count.
Caballero, a usted se le ha procesado por 2 cargos. Uno es por allanamiento de una vivienda sin ocupantes y el otro es por hurto de menor cuantía. Voy a leer la declaración jurada de su arresto para ver si contiene suficientes indicios de criminalidad.
Okay, the court finds probable cause for count 1, burglary of an unoccupied dwelling, and the court finds probable cause for count 2, petty theft. Do you have any arguments?
Este tribunal determina que hay suficientes indicios de criminalidad en relación al cargo número 1, allanamiento de una vivienda sin ocupantes, y en relación al cargo número 2, hurto de menor cuantía. Abogado, ¿usted desea hacer algún alegato? No tengo ninguno en relación a la suficiencia de indicios.
Okay.
Judge, I didn't get to, I don't have any probable cause arguments. I do have arguments as to the bond in this case, Judge. Again, we would be asking you to depart from standard bond and go below standard bond in this case, given the nature of the allegations and the fact that Mr. Alvarez does not have any prior convictions. He does have prior withholds to battery, as the court will note. However, those are not convictions in the state of Florida.
Señoría, no tengo ningún alegato en relación a la suficiencia de indicios, pero sí tengo alegatos en relación a la fianza. Yo le pido que usted reduzca o imponga una fianza por debajo de la fianza estándar en vista de los cargos que se han presentado y en vista del hecho de que el señor Álvarez no tiene condenas previas. Su señoría se fijará que sí ha tenido un fallo sin condena en un caso de agresión física, pero no ha tenido ninguna condena. Fiscal.
State would be the standard amount already count 1, that would be $500.
And count 2 is
I didn't hear that, Judge. I'm sorry.
The state would be requesting the standard bond amount for count 1.
Okay.
La fiscalía pide que se imponga la fianza estándar en relación al cargo número 1.
Okay, the court finds probable cause for count 1, 7,500, and count 2, probable cause for 150, and there's also a stay away order.
Este tribunal estima que hay suficientes indicios de criminalidad en relación al primer cargo. La fianza son $7,500. En relación al segundo cargo, la fianza son $150. También se emite una orden de alejamiento.
Okay. There's a stay order. The defendant is prohibited from any contact with the victim, Monique Smith, directly or indirectly, in person, in writing, by telephone, fax, pager. Defendant must stay at least 500 feet away from the victim's home, place of employment, and school at all times. Do you understand this, sir?
Se ordena que también se emite una orden de alejamiento. El acusado tiene que mantenerse en todo momento sin contacto con la presunta víctima. The name of the victim of something Smith, Judge?
Minetta, M-I-N-E-T-T-A.
La víctima se llama Minette Smith y no puede tener usted contacto con ella, ya sea en persona, por escrito, por teléfono, por fax, por beeper o de ninguna otra manera. Y en todo momento usted está obligado, caballero, a mantenerse por lo menos a 500 pies de la vivienda de esa persona y del centro de trabajo de esa persona y el centro de estudios de esa persona. ¿Usted comprende?
In addition, the defendant shall stay away from the following address: 3401 Northwest 178th Street, Miami Gardens, Florida 33056. Do you understand?
Y caballero, además de todo esto, usted está obligado a mantenerse alejado de la siguiente dirección: 3401 Noroeste, calle 178, en Miami Gardens, Florida 33056. ¿Usted ha entendido?
Sí, pero yo no creo que haya alejamiento porque está muy cerca donde yo vivo.
Yes, but regarding the restraining order, that's very close to the place where I live.
Judge, I'll have one of the attorneys from my office speak to him about that.
Haré que uno de los abogados de mi oficina hable con él sobre eso.
He expressed concerns that the stay away order is close to the address that he lives at. And I said to the court that I would just have one of my colleagues speak to him about that.
Okay, perfect. Thank you.
Él expresó la inquietud de que la orden de alejamiento tiene que ver con una dirección que le queda muy cerca donde él vive, y yo le contesté a él que yo voy a hacer que uno de los abogados de mi oficina hablen con él sobre esto. Muy bien, gracias.
Okay, the next case I have is Joseph Frank Wright.
We have Lewis.
Lewis, Judge, Mr. Lewis is back here. I believe he was number 17 on the court's calendar today, Judge.
Yes. Okay. Sir, are you Casper Lewis?
Good morning, Judge.
Good afternoon. So there are 4 different A forms. Okay, I'm gonna go to each one. The first one, you've been charged with retail theft and you have a prior conviction. I'm gonna read the first arrest affidavit to determine probable cause. This is a case ending in, the case is F2-600-7605. Thank you.
Judge, the defense can stipulate to probable cause in these 4 cases. We would just be asking that the bond be set at reduced bond from standard bond.
And Judge, Mr. Lewis also has a hold for immigration.
Okay, I'm gonna note there's an ice hold and he has. He's an extensive career.
I don't know why.
Okay, so the court on the case ending in 7605, court finds probable cause. He has a prior conviction. Let me see. Intermont. Do you have anything?
One. Stay of your elevated bond in this case.
Yes, I'm gonna do an elevated bond. He has an extensive career criminal with some violent crimes. So count 1 will be for the first arrest, $10,000.
I'm sorry, Judge, what was that?
$10,000.
For which case?
For case ending in 7605.
And for the record, state will be handing over his brief.
I can't hear the
He's
state.
working on a stay away order.
Okay.
Judge, are
Next.
you requesting a Nebia hold as well? The jail card is asking for a Nebia hold. I just need to know, should I put no Nebia or with the Nebia?
Judge.
Okay, so in the first one that I just gave, there's also a stay away order from Marshall's located at 16800 Collins Avenue, Sunny Isles Beach, Florida 33160. Sir, you understand you cannot go to the Marshalls?
No, I understand.
Okay,
Oh, Chris, back there.
and regarding, there will be a Nebbia hold.
As to the case ending in 7605, Judge, or on all cases?
On all cases.
Yes, Your Honor.
Okay, so the next case that I'm going to go to is the one ending in 7595. And this one is resisting officer without violence. Count 2. But didn't I address that one in this one? Right?
All of them have retail theft charges,
Oh, okay,
all for Marshalls.
okay.
And
That's why they look similar.
Okay,
Judge,
so let me go, sorry about that. So let me go to case number F26007595. In that case, there's 3 counts. 1 is for retail theft, prior conviction. 2 is resisting officer without violence. And 3 is hold for the magistrate. And there isn't, yeah, just wanted to, sorry about that. And there's a Nebbia hold on all these cases and a stay away order.
Judge, I'm sorry, what did you say the bond was in those cases?
And 10,000.
10,000 each?
On each case?
No. Discuss the bond 7595 now.
I'm sorry, State. I'm hearing every third word you're saying. I'm sorry.
State.
It's gonna be the same for this, Your Honor. We're still asking for the elevated bond due to its lengthy priors.
And the standard bond is
For vote. That's correct.
yeah. So I'm gonna do count 1. I'm gonna elevate it to $10,000.
And then to the resistance without violence, state's request is 500, standard bond.
Standard bond on count 2, 500. PC found, and on count 3, PC, no, there's only 2 counts. And there's a Nebbia hold.
Correct.
So the first count is 10,000 and the second count is 500. And there's a Nebbia hold and there's also an ICE hold.
Judge, I think the ICE hold may be a mistake, but I think that's something we can rectify later. It doesn't seem like Mr. Lewis was born here.
Okay, the next case is the one ending in 7606. And there's 1 count of retail theft.
And
There's the state waiver.
Judge, again, as with all the cases, we'd be asking for either standard bond or reduced bond. I'll understand the court's concerns and the state's concerns. These allegations remain unproven despite its priors, and there is a default entitlement to monetary or non-monetary release before you've been proven guilty.
Okay, and there's a stay away order, and again, in this case against the Marshalls, in all of these cases at 3401 North Miami Avenue, Miami, Florida 33127. What's the standard bond? And state, are you asking if it's elevated?
Stay with your bond, Your Honor.
Yeah, I'm gonna give an elevated bond of 5,000. And the last case is the one ending in 604. And again, that's a 1 count retail theft. And again, there's a stay away order from the Marshalls, 3401 North Miami Avenue, Miami, Florida 33127. Do you understand, sir?
Government, I do.
Okay. You need 10,000. Yeah, and then this one, again, I'm gonna do as I did in the other cases. I'm gonna find probable cause and I'm gonna elevate the bond to 10,000 based on the prior conviction.
Your Honor, just to be clear, that was the case ending in
The last one.
7604.
as well.
Oh, went for it. Oh, it's the same one. Okay, so there's a stay away order from marshals, just, and in that case, the marshals in the last case ending in 7604, it's the marshals located at 16800 Collins Avenue, Sunny Isles Beach, Florida, 33160. You understand, sir? We're to stay away from both the marshals located at 3401 North Miami Avenue and the marshals for 16800 Collins Avenue.
Okay. Yes, ma'am.
Thank you. We now to order.
Mr. Wright?
I have Caesar Nava. Who's that, Mr. Wright?
Yes, Judge. This is Mr. Joseph Wright.
Who's that?
Joseph Wright, Judge, number 20 on your calendar. And I do believe count 4 in this case was addressed earlier at jail arraignment.
I'm sorry, I didn't hear what you said. Public defender?
Yes, Judge. I said that I just wanted to point out that count 4 in this case was addressed earlier at jail arraignment, I believe.
And count 4, correct?
Count 4, yes.
Let me just confirm with the state.
Double check.
I'm gonna double check.
Right. Corrections is advised that yes, it was addressed earlier at arraignment. There was a $150 bond given.
For the felony. The reckless.
Yes, the reckless driving, count 4.
Yeah, we did.
Okay, so we're gonna only be addressing counts 2 and counts 3.
Counts 1, 2, and 3, Judge. Or no,
Okay,
sorry,
yeah,
counts
that's
1 and 3, yes.
Okay, so count 1 is for fleeing and eluding the police officer. Count 2 is wearing a mask on the street, and count 3 is cannabis possession. I'm gonna read the arrest affidavit to confirm there's probable cause in each of those counts. Do you have any probable cause arguments about the defender?
Judge, we don't have any probable cause arguments at this time. We would just be asking again for a reduced bond in these cases. I understand the court's position from prior. However, Mr. Wright does have fairly few priors and none of them are convictions. He has 2 withholds of three withhold of adjudications on non-violent offenses. He's not a danger to the community, nor is he a flight risk. He's a Miami resident. He has an address as noted on the arrest affidavit and a Florida license. Is noted there. Judge, we'd just be asking for reduced bond. I understand he was given $150 on the counts earlier, and we'd be asking for $1,000 bond on count one, a $50 bond on count two, and a $100 bond on count three.
Okay,
For the record, Your Honor, the defendant does have previous convictions, one of which being a battery on Leo fire from back in 2021, including other convictions. The state would request standard bond in this case, which would be, as to count one, $2,500, count two, $150, count three, $500, I believe.
yeah, so he does have an extensive prior, count one, probable cause fine, 2,500, count two, probable cause, 150, count three, 500.
And Judge, I just want to make sure we're speaking about the same defendant because the local priors I have here, it's 3 withholds of adjudications and nothing else. So is it, just to be sure, it's the number 1064673? Because the defense isn't aware of any other priors.
The specific case number the state is referring to is F21-17212, where he was charged with a misdemeanor petty theft, a felony of a battery on a law enforcement officer, a misdemeanor of disorderly conduct at an establishment, and a resisting officer without violence.
And again, I don't have that on the priors that I have, not that I don't believe the state's representations, but I just want to make sure that we're speaking about the same individual. Is there a date of birth for those priors? Because I think it would be important for the judge to weigh the correct priors. I just want to make sure.
And the clerk is double checking.
The date of birth that we have is July 25th, 1989.
Is there a SIN number? I apologize.
The SIN number we have on the local cars is 1064673.
Okay, Judge. At this time, I do believe that it's the correct priors. The defense doesn't have those. However, we would rely on the court's representation.
Thank you. So the next case that I have is Cesar Nava.
So 2,500, 150, and 5. Judge, just to confirm, for Mr. Wright, count one was 2,500, count two, 150, count three, 500.
Yes, the total is 3,150.
Mr. Nava? Mr. Nava? Judge, I believe we're searching for Mr. Nava. We're gonna pass him. We can move to the next individual, Mr. Dube. Or Doobie.
Jamie Doobie, yes. And there is 1, 2.
Mr. Doobie refused. We'd ask to reset to the bond.
And there's also 4 felonies.
The next one.
Okay, but it's showing 4. You wrote down 4. No, but yeah, so we'll set him for tomorrow. Okay, we'll set him for tomorrow. Oh, more counts. Okay. He's set for division 4 and there was 4 felony counts. Okay, the next case I have is Daniel Higgins. Are you Mr.
Judge,
Higgins?
Mr. Higgins' pay refused court as well. We'd ask to reset this to tomorrow.
Okay, we'll reset this. He's gonna wait with it.
Okay.
Okay, so then, the next case I have then is, Kylie, Budworth.
Yes, Judge, I'm here with Mr. Kyle Butterworth.
Okay, he's been charged with battery, domestic by strangulation, which is a very serious crime, so let me read this arrest affidavit. Defense, is there anything you'd like to?
Judge, we don't have any probable cause arguments. We would just be asking for standard bond in this case. I understand that the court is concerned with the allegations. However, Mr. Budworth is a Miami resident, and he also does not have any prior convictions that the defense is aware of. The only thing that the defense has here on their local prior paper, on my local prior papers, is a withhold of adjudication to drug paraphernalia and another withhold of adjudication to possession of controlled substance. It's our position that that does not pose a danger to the community despite the allegations in this case, and we'd ask for a standard bond.
This is the state of your standard bond, $5,000.
This is a very serious crime by strangulation. I'm gonna raise the bond to $8,000.
I'm sorry, Judge. Eight?
8,000. PC is found. So let me tell you.
Judge, I'm sorry, you said the reason for the upward departure was the severity of the allegations?
The severity of the allegation, strangulation, and the A form says that the victim by the neck and applied pressure, and she had difficulty with her ability to breathe.
Judge,
Very serious.
While I do understand the court's position, the charge of battery by strangulation implies those facts, and the standard bond for that is 5,000. I understand the court's concern, but.
Okay. And you are not to engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess any firearms. You must immediately surrender any firearms you may have. The defendant is prohibiting from having any direct or indirect contact with the victim, Laura DeMurio, including contact in writing, telephone, through social media. You are to stay at least 500 feet away from the victim's place of employment, home, or school at all times. You and the victim were living together at the same time.
No, not at the time.
So you guys are not at the same residence?
No.
So you don't need to retrieve any personal belongings?
No, I do not.
Okay.
The alleged.
You're to have no contact with the victim. Do you understand, sir?
No contact. Oh, yeah, of course.
And you were not, because it said.
I'm sorry, Judge, we can't, it's
So
cutting in.
you did not live with the victim. Is that correct? I just want to make sure it's clear.
You know what? You do not live with the victim.
No, we do not live together. We haven't for many months. 6 months.
Okay. I was asking to see if you needed to retrieve anything from your home. Okay, thank you, sir.
Thank you. Mr.
And
Daniel?
the case I have is Lloyd Daniels. Are you Mr. Daniels?
Oh, no, that's one. Okay. Not here.
Good afternoon. Are you Mr. Daniels?
No, Judge, he refused court. We're gonna have to reset him to tomorrow as well. This is Mr.
So
Middlebrook.
Daniels is reset?
Yes.
They refused.
He refused. This is the previous one. And then he refused. So let me see. The next one that I have is Travis Middlebrooks. Are you Travis?
Yes,
Okay. Okay.
and Judge, corrections is trying to inform you that there's a probation hold in this case.
There is a probation hold, and that's case number F23-18358. Okay. The defendant has been charged with 1 count of firearm weapon possession. Number 2, a concealed firearm carry. Count 3 is grand theft in the 3rd degree. Count 4 is probation violation. I'm going to read the affidavit to determine that there's probable cause in each of these counts, but he also has a probation violation.
And Judge, we can stipulate to the probable cause in these counts, and we would just be asking for a reduced bond in light of the probation hold.
So the court finds probable cause in count 1, count 2, count 3, and there is a probation violation. Do you, defense, is that it? Do you have anything that you need to state?
Yes, the state would be requesting first the standard bond as well as a probation hold.
Okay, so
And we would be requesting a lowered bond, Judge.
so count 1, you were requesting 7,500.
Yes.
Count 1 will be 7,500. Count 2 is 2,500. And for the same for count 3. So count 1, count 2, and count 3 are all 2,500. 75, 25, and 25.
And Judge, I would like to point out for the sake of bond that this is a case where there was a search warrant served on Mr. Middlebrooks' home. The charges are all firearm related. And in the arrest affidavit, it mentions that there were no weapons seized when they arrested Mr. Davis at his home where the search warrant was served.
So I'm going to just, to be clear for the record, count 1 is 7,500, count 2 is 2,500, count 3 is 2,500. Probable cause is found on both, and there's also a probation felony hold. The next case I have is James Strawbridge.
Judge, I'm here with Mr. Stormbridge.
Okay. Good afternoon. Your charge is 4 counts. The first one is a short barrel shotgun rifle machine possession. Count 2 is a firearm weapon from a convicted felon. Count 3 is a concealed firearm carrying, and count 4 is cannabis possession. I'm going to go read your arrest affidavit. There's probable cause. Okay, the court finds probable cause in all 4 counts.
Judge, I do have a probable cause argument for count 1, which is the barrel shotgun rifle machine gun possession. Part of the element of that is that the police officers have to allege operability of the weapon, even though the arrest affidavit states that it is a semi-automatic machine gun. I believe it doesn't state whether it was an operating use or condition. There's no mention of operability. I believe it would be enough to the level to not find probable cause on that charge, Judge.
So if I may, page 2 of the form, the officer does know it was loaded. It's the state's position that would indicate that it was operable.
Judge, a gun can be loaded without being functional, without being operational.
Just to clarify the record, under Florida statute 790.221, subsection 1, it says it's unlawful for any person to own or have in his care, custody, possession, or control any short-barreled rifle, short-barreled shotgun, machine gun, which is or may be readily made operable.
Yes, and there's no mention of whether there was any maybe operability.
The fact that the gun was loaded means that it was maybe operable.
Are you requesting a standard bond on all 4 counts?
Yes, Your Honor. So that would be 7,500 is to count 1, 7,500 is to count 2, 2,500 is to count 3, $500 is to count 4.
And we would be asking for reduced bond, Judge. Again, we understand he has priors, but lives in Miami, he's not a flight risk.
I count probable cause in count 1, count 2, count 3, count 4, and I'm going to issue standard bond, count 1, 7,500, count 2, 7,500, count 3, 2,500, and count 4, 500. The next case that I have is Kingdom Patrick.
Here with Mr. Kingdom, Judge.
Okay, are you Mr. Kingdom?
Excuse me?
Yeah, are you Patrick?
Yes, Judge.
Okay, you've been charged with burglary of an unoccupied structure, count 1, and criminal mischief, count 2. I'm going to read your arrest affidavit to determine that there's probable cause, and there's also a stay away order.
Okay. Defense does have a PC argument on count 2 of this, Judge.
Okay, what's your PC argument?
Yes, Judge. The arrest affidavit's listed as a first-degree misdemeanor criminal mischief. Part of the elements of that is they need to have value. There's no value listed on the arrest affidavit. Therefore, the probable cause is sufficient for M2 criminal mischief, which doesn't require value, not M1.
To confirm, you said he was a HVO?
State? Oh, yeah. No problem. state is refusing. No, take your time.
The judge,